Also like to thank some people, Professor Graby, who's here, and the Rudman Center. Definitely helped out a lot in this planning process. Also, Professor Ford, who's the faculty advisor for law review, was definitely very instrumental in helping get everything set up for today. Also would like to thank the law school administration for all of their efforts in helping plan this event. I know they worked very closely with Kyle in this entire planning process, so it was much appreciated. Additionally, I'd like to thank Laura and Terry for helping promote the event today, and also AJ Kierstead for helping to get all the technology set up for today. Finally, I'd like to thank all of our volunteers and anyone else who has helped play a role in this planning the symposium for today. Honestly, it would not have been possible without everyone's contribution, so definitely thank you for that. Additionally, I'd like to commend our symposium editor, Kyle Kopko, for putting together quite an impressive event. When Kyle first told me that he wanted to make Symposium an all-day event for the first time, I definitely knew it would be a difficult task, but I also told him that he had my support, but it turns out he didn't quite need it. Whether it was booking rooms and caterers, finding speakers for the event, or coordinating details with the administration, or even sending me midnight update emails, Kyle was truly on top of it all. I can confidently say that there was never a moment where I had to wonder if Kyle was on top of everything. So he has set the bar high, honestly, for future law review symposia, and deserves all the credit for today's symposium. So with all of that being said, I'd like to just now introduce our next speaker. Prior to joining UNH Law, she was the founder and co-director of the Center of Law and Intellectual Property at Texas A&M University School of Law. Additionally, she has extensive experience in institution building, spearheading the creation of innovative academic programs, including experiential learning initiatives, joint degree programs, and more. She's also written a published book on intellectual property and written multiple book chapters and published works for several prestigious journals, including Columbia, Fordham, and Yale, to name a few. If all that wasn't enough, she has received multiple awards for her dedication to students, her skills in the program development, and her service to the university and the community, including the Texas A&M University System Distinguished Faculty Award, the President's Grand Challenge Award, the Judith Kuhn and Stephen R. Alton Service Award, and the United States Association for Small Business and Entrepreneurship Best Workshop Award. Currently, she proudly serves as the Dean of UNH Law. Without further ado, please join me in welcoming Dean Megan Carpenter.
Thank you so much, Seth. And one of the things that I just love about this event is that it's so true to the spirit of who we are as a law school. You know, our law school was founded almost 50 years ago. We have our 50th anniversary next year. And we just welcomed many alumni back this past weekend for our reunion. And one of the things that came up in talking with alums throughout the years is just this pioneering spirit of saying, like, this doesn't exist, we're gonna start it and we're gonna build it. And I think this event today is such an, is exactly that kind of event where you all as a law review have said, we're gonna step this up a notch and we are going to do something that has a national profile and build this for generations to come. Professor Graby and I were talking last night that you all set the bar really high, and we can't wait to see what gets built on this foundation, and we're so proud of you. To all of you, welcome. We're really happy to have you here at UNH Franklin Pierce School of Law. You know, we couldn't be in New Hampshire talking about elections if we didn't talk a little bit about primaries. And I'm just going to tell a little story. So primaries now are not at all what they used to be. Until 1948, most of the primaries in states across the country were really selecting the delegates. People were voting for the delegates that they would then send to the convention. And people were thinking in a pioneering way, sort of aligned with some of the things I was just talking about how to increase turnout for the primaries. And so Richard Upton, who was Speaker of the House of Representatives in New Hampshire, decided to pass a law that enabled voters to just go ahead and vote for any presidential candidate. And that worked, as we all know, and had a national impact. In 1952, sort of right away, Truman was kind of an unpopular president as the Korean War was sort of dragging on. And Senator Estes Kefauver of Tennessee ran against him. And he ended up beating Truman in the New Hampshire primary by about 4,000 votes. And Truman decided not to run for a second term. On the Republican side, things were kind of interesting as well. General Eisenhower, since coming home from World War II, had been encouraged to run for president, I think from people from both parties, but he was kind of a reluctant candidate. And then a group of supporters here in New Hampshire took advantage of the new law and put his name on the ballot. I think it required maybe 50 signatures to get a name on the ballot. And although he did not step foot in the state during that election, unlike many candidates today, he won the primary with 50% of the vote, beating the party favorite, and the rest, of course, there is history. So once primaries became important, voting for candidates, not just determining delegate strength themselves, sequence started to matter. And so now our state law in New Hampshire provides that our primary is going to be the second Tuesday in March, or at least 7 days earlier than any other state, whichever's earlier. So these laws that are made by our state legislature here in a small state like New Hampshire have truly had an impact on the entire country. And also, I can say within the state, I have noticed a civic engagement. Having lived in states across the country, there is a civic engagement here that really is impressive. From town meetings to electing the president, across the board, people are incredibly engaged. You know, we talk a lot about 6 degrees of separation between anyone and anyone, or anyone and Kevin Bacon. But I think in New Hampshire, it's really sort of 1 degree of separation between people and maybe between anyone and the president. And at least that's how we feel. Here at the law school, we also believe that our role is to be engaged and active and to a center of discourse and action. And I can say that we're equally intrepid in our national leadership. We're always trying to think ahead of the curve, think about what comes next, including our non-residential JD program that Kyle is a part of, which we started before the pandemic, which now takes students to various locations across the country to embed them in learning experiences everywhere. Our Daniel Webster Scholar Honors Program, which is the first in the nation bar alternative program that is competency-based, and that many states have tried to emulate. Our Rudman Center for Justice, Leadership, and Public Service is certainly that too. It's directed by Professor John Graby, who does an incredible job, and it is the hub of most of our civic leadership here at the law school. One of the things I'm most proud of about the Rudman Center is that it instills in students a sense of public service. It provides, this past summer, provided over 60 different stipends for students to have jobs contributing back to the community in state agencies, nonprofits, all kinds of public interest positions. And that helps instill in students a sense of pro bono, so later on they will give back for many years to come. It also engages the Rudman Center with various organizations on issues at the intersection of justice and journalism and fiscal responsibility, civics, and even hosts many of those presidential candidates. Downstairs, if you will see in our jury box, we have now a wall of signatures of presidential candidates that we started this past election cycle that will be a wall of history in the decades to come. Issues in election law have never perhaps been more important or top of mind for all of us as we navigate issues core to the state of our democracy, as we seek to preserve the balance of powers, and really as we consider the soul of our nation and who we are as people. From redistricting and gerrymandering, campaign finance, voting rights, the Electoral College, I learned last night it extends to ballot design. There are issues that we are confronting and that we will continue to confront, where dialogue among scholars and practitioners together and the people is critical. So this day is about contemporary issues in election law, certainly, but it is no less about who we are as a society and who we want to be. A big thanks to Kyle Kopko, our Symposium editor, also to Seth, and the entire staff on the Law Review for your dedication and your leadership. You all are shining examples of what makes this law school so pioneering and so special. Thank you. Kyle, we have a little gift for you. You see the stars, they're just right.
Thank you very much. I greatly appreciate it. Thank you. Good morning, everyone. I get to add my welcome as well. My name's Kyle Kopko. I'm the Symposium editor here at the UNH Franklin Pierce School of Law. And to everyone who's online, welcome. Everyone here in Concord, what a beautiful day. I wish we could take credit for this weather, but it's been absolutely wonderful. I'm really looking forward to the symposium. I won't take too long, but I really hope that this is an engaging discussion for all of us. Not just today, but I'm hoping that all of us can make a professional contact here or online and continue this conversation beyond the confines of the 2022 symposium. As someone who thinks about these things in academic contexts, I couldn't help but think that law is perhaps one of the most, if not the most, interdisciplinary topic that one can conceive of. It touches upon all aspects conceivable of life. And as we're planning this symposium obviously that touches on issues of election law, what we have today is a wide range of interdisciplinary experts who have assembled here in Concord to offer their perspectives and offer a better understanding of this topic. It isn't just one disciplinary approach. And today, we're essentially bifurcating the symposium. The first half of the day is going to be focused on government officials, civic group leaders, practitioners who are going to be able to provide insights on what they do and how that affects election law, election administration, and the promulgation of rules. Then in the afternoon, we'll hear from a wide range of nationally renowned speakers, again, from a whole range of academic disciplines, not just law, but we'll hear from individuals with backgrounds in political science, computer science, data science, and neuroscience. So again, I think this will be a fascinating, fascinating conversation. So I would like to kick things off, if I may. Our very first speaker is Secretary of State David Scanlan. David Scanlan was sworn in as New Hampshire Secretary of State on January 10th, 2022. He previously served as Deputy Secretary under William Gardner from 2002 to 2022. And before assuming his role as Deputy Secretary of the State of New Hampshire, he was a Republican member of the New Hampshire House of Representatives from 1984 to 2002, so 8 terms in total, becoming Majority Leader of the House in his final term. Native of New Jersey, Secretary Scanlan has a bachelor's degree in forestry from West Virginia University's School of Agriculture and Forestry. After graduation, Secretary Scanlan moved to New Hampshire in 1978 to work as a licensed forester in the private sector, and he still maintains a license to practice forestry, and he's considered New Hampshire his home ever since. Please join me in welcoming Secretary of State David Scanlan.
That's great. Thank you, Kyle. You might ask how I went from forestry to the position I'm in now, and that's a long story, so we'll save that for another day. But I would like to thank Kyle and Seth and Dean Carpenter for pulling this symposium together, because it really is timely, and I believe that it is really important that we have a good discussion about the challenges surrounding elections that we face today. And we do have some really significant challenges. I'm going to focus on that, and hopefully that will lead into the broader discussion that is going to take place as the day goes on. So there are really 4 main principles that I see in conducting elections. The first one is maintain the privacy of a voter's vote. And that was actually a reform that took place about 130 years ago when we had other serious challenges and issues related to elections, namely vote buying, voter intimidation, voters' ballots or how they were voting was not secret. And so nationally, there was a movement that said, you know, we really ought to have some reforms that protect the privacy of voters. We went to an Australian ballot. We still use that process of voting today. Another principle is making sure that the voter has an easy experience when they're trying to cast their vote. There should not be impediments that prevent them from getting to the polling place and being able to exercise their fundamental right. There also needs to be security in the voting process. You know, every voter has a right to know who is participating in the election process, and that those voters that are participating are qualified. And then finally, it is important that we come up with accurate results from the election, and they should be reported in a timely manner. And if we do all of those things, we should have a great system that people believe in. There's a lot of trust in the process, and that the voters' vote actually counted and meant something. There is natural tension, though, between making it easy for voters to exercise their right and making sure that everybody that's participating in the process is qualified. Because the easier you make it, it might open the process up to fraud or the perception of fraud. And the more difficult you make it, you start getting into the realm of voter suppression and preventing people from exercising their right to vote. Some examples of making voting easy. In New Hampshire, it's same-day voter registration. It's being able to use absentee ballots when you have a need for being absent or having a disability. And using affidavits to prove qualifications. That's permissible in New Hampshire. Some examples of making sure that the process is secure is a voter checklist. We have a process in New Hampshire where every voter fills out a voter registration form, which is approved by the local supervisors of the checklist. And upon that approval, the voter's name goes on the checklist. Voter ID is used in New Hampshire. That's another way to make sure that the individuals that are voting are who they say they are. And that was a controversial piece of legislation when it passed in 2012. But it is really readily accepted and generally accepted today. Most voters don't have an issue presenting an ID. And the ones that don't, there is a process by which they can still vote by filling out an affidavit and having a photograph taken. But the individuals that fall into that category are just a fraction of 1% in any given election. So that's a success story. The great thing about New Hampshire elections are also that they are decentralized. In other words, the Secretary of State and the Office of Secretary of State administers the elections. Generally, we print the ballots, we get them distributed to the towns, we make sure that the towns, the election officials in the towns have the proper training and the materials that they need. But each polling place in New Hampshire is run locally by locally elected election officials. And there are 8 of them in every polling place. There's a moderator, there's a clerk, there are 3 supervisors of the checklist, and there are boards of selectmen, which range between 3 and 5 members. And even in city wards, those individuals are elected for the purpose of running elections in the wards. So voters in a community should rest assured that they're the ones that elected those individuals to the positions of running an election. And hopefully they voted for those people because of their integrity and their honesty and their ability to do a job in a trustworthy manner. Many volunteers also participate. And again, to work in a polling place, you have to be from the community in which that polling place is located. Our elections would not run, certainly they wouldn't run well without the volunteers that step forward and help with the elections, whether they're the locally elected officials or the people that step forward to be poll workers just to help out. There's also a number of checks and balances. Our system is built on checks and balances. In every polling place, the political parties have a presence. The political parties, in the first instance, get to appoint the individuals that serve as ballot clerks, the individuals that are at the check-in table that mark a person's name off the checklist, or and the other individual gives the voter a ballot. Usually it's a member of each party, opposing parties, that are working together to make that process happen. Parties also get to choose a position that's called an official challenger. And that individual gets to have a special place near the check-in table so that they can see and hear what is going on throughout the day. In the past, that individual usually has a separate checklist, and they make sure that the members of their political party are going through and voting. And if not enough of them are showing up, the list gets handed off so that phone calls can be made to drive voters out. More recently, the role is acting as an official challenger, actually questioning the qualifications of some voters if they have a reason to believe that a voter is not qualified. There are also many constituencies of the election process, and the list is growing. It used to be, even a decade ago, running an election was kind of a sleepy thing. It was a ministerial duty. You made sure that the polling places were equipped with the ballots and everything they needed to run the election. Voters, for the most part, had faith in the outcome of the election. They trusted the process. But that's changing. The constituencies that we have, number one, are the voters. They're the most important constituency of elections. And we want to make sure, as mentioned before, that they can vote with ease and that they have confidence in the outcome of the vote. Poll workers, those are the locally elected officials that have to run the polling place. We want to make sure that we don't create a situation where their jobs are too difficult. We want to make sure that they understand the process and they're able to run an election that's sound and accurate. The candidates, they have a big stake in the outcome of the elections, and there are things in place for them. The location of their name on the ballot, party column rotations, their campaign finance laws that we administer, and there's reporting that is required to run for those offices. The political parties have a major interest in the election process, and we're starting to see nationally, and even New Hampshire, the political parties are realizing that perhaps if they can control the Secretary of State's office or the agency that runs the elections in their state, that there may be some benefit to that. And so there are pressures coming from political parties in how elections are run, how they generate information to their voters to get them to show up at the polling places, and they push the limits because they have a major stake in the outcome. The media also have an important interest in how the elections are run, their ability to get information, what's happening with the elections, where are the problems, where are the successes, and are the results accurate? There are a growing number of special interest groups that are out there now that are surrounding the election. Some of them are partisan related, some of them are not. Examples would be there are movements now for things like ranked choice voting. There's a constituency out there that's trying to push that type of change on the voting process. Groups out there that would like to see the national popular vote be the determinant of whether a person is elected president of the United States or not, as opposed to the Electoral College that we have now. There are some groups out there that use elections to raise money, to raise funds, to raise money. And any type of a group that has a cause usually does a better job fundraising if there is a crisis, even if it's perceived or generated. That can be used to say, hey, this is going on. Since you're following our group, please send us money so that we can make sure of our successes or that failures don't happen. That's a significant growing concern. Now that election systems are getting away from paper-based, and heading in the direction of using technology. There are a lot of businesses out there that have an interest in how elections are run and whether they can solicit a state to go to their voting equipment or election management systems. So there's pressure from marketers. And then obviously the big part is the legislature, and they discuss legislation every time that they're in session. Over the past decade, there are probably at least 50 to 60 pieces of legislation that are submitted in every session of the legislature. And depending which party is in power, it determines what type of legislation is going to be heard. And there's always the pull on that tension that I mentioned earlier between making it easy to vote and making it secure that comes into play. It can be difficult for election administrators if the ball keeps bouncing back and forth. It's better for administrators if there's kind of a path that we can follow that we know isn't going to change dramatically one way or the other in a legislative session. But our job is to deal with it. And in New Hampshire, I think we do a pretty good job of that. There are also threats that are surfacing to our election system and process. And I think all of you have probably heard about the amount of misinformation and disinformation that is circulating about elections. And that is made extremely prevalent with the advent of social media within the last decade. Information travels very quickly now, and not only does it travel quickly, individuals that think alike or have certain beliefs have been able to find each other, and they've created critical mass. And so they're able to push these ideas that they have, whether it's accurate information or not. And so that's a challenge, trying to make sure that as election administrators, we get accurate information out there so that the voters can understand what's actually going on. There are false narratives out there about our election process and whether it can be trusted. And the unfortunate thing is we have leaders in our national parties, and it happens in both parties, that make statements that would lead people to believe that our elections are not accurate, and the results from an election don't reflect the outcome. It is difficult to make statements like the person that was elected is illegitimate for whatever reason, or the election was stolen when there's no good proof of that. And then from the statements, conspiracy theories grow, and they are not helped when there are parts of the election process that are not completely transparent. That would be, people question voting machines and whether they count accurately. And it's because the voter can't actually see what's happening inside the counting device. There are systems, electronic systems that are being utilized in other states, and we're looking at them in New Hampshire, electronic poll books and the newer version of ballot counting devices. Some of those haven't been thoroughly vetted, and we've seen failures of those systems occur in other states, and that's never a good thing when that happens, because it feeds the conspiracy theory issue. But I believe there is a place for those systems, but they have to be properly vetted and make sure that they're going to work properly if we're going to use them. There are concerns about hacking and foreign actors in government. A lack of civic education is problematic. And fewer people are willing to be poll workers. It's a much bigger problem nationally than I think it is in New Hampshire. But even in New Hampshire, the individuals that are working at the polls are elderly. We need an infusion of youth to participate in that process, but it's time consuming and the challenges are great. And sometimes the poll workers have to deal with difficult situations and individuals. So the solution to those things, from my perspective, just in a broad way, is that the process has to be as transparent as possible. There's nothing to hide in the election process. There shouldn't be any secrets. And everything that is done in New Hampshire at a polling place is done in the open. And we have to educate our voting population that that is the fact, that they can watch the process from start to finish. And hopefully, if we can do that, we'll improve the confidence that the voters have in our process. Now, I've got just a couple minutes left, and I want to address, this is a great example of, misinformation and things that will cause a lack of confidence in our election. Is that a week or so ago, you may have seen an article that showed up in the New York Times about a study on cost of voting or ease of voting among the states, and they gave New Hampshire last place in their ranking of that process. So this is a study that was done by a professor, Scott Schroffnagel, at Northern Illinois University, professor in the Department of Political Science, and he was joined with Michael Pomonte, who is a research associate with States United Democracy Center, and Quan Lee, a data scientist in the Department of Public Administration at Wuhan University in Wuhan, China. And if you go through the report, they have a number of criteria that they use to state their case. And just some examples, no voting for incarcerated felons, no online registration in New Hampshire, no registration drives allowed. I mean, they are in New Hampshire, but a supervisor of the checklist has to be present. Pre-registration for 16-year-olds isn't allowed in New Hampshire. No automatic voter registration. Election day is not a holiday. No early voting. No all-mail voting. No all-mail voting centers. No drop boxes. And the list goes on. What's missing from those are all items that go to the ease of voting, making it incredibly easy for the voter to participate. But what's not mentioned on this list is anything dealing with the security side, making sure that voters are properly qualified to vote. And New Hampshire, I think, has a really good balance. And can we improve things? Of course we can. But the proof, as I've said, is in the pudding. A UNH poll, actually several over the last couple of election cycles, show that voters generally, overall, 98% of voters believe that it's easy to vote in the state of New Hampshire. That's the number that is most important, at least from my perspective. And in terms of voter confidence, in 2020, there was a poll, 90% of the voters in New Hampshire have confidence in the results. And in June of 2020, that confidence was 84%. So voters in New Hampshire have confidence in the system. They believe it's easy to vote. And our percentage turnout, especially in presidential elections, in the last 4 elections, we've been in the top 3 in the country based on voting age population. And in the 5th year before that, we were 4th. Those are the metrics that I think we need to use as what's important. New Hampshire does a great job, but it's unfortunate that studies like this come out, and then we have groups running around saying, see, New Hampshire is awful at what they do, when I believe the opposite is true. So I'll stop there, and I'll be happy to take any questions.
Thank you very much, Secretary Scanlan. If anyone in the audience has a question, please raise your hand. We have time for about 2 questions. I'll bring the microphone over so that way folks online can hear as well.
Any questions online?
Let me check online here. There's a question. Has there been any historic evidence of voter fraud in New Hampshire, to your knowledge?
There are examples of inappropriate voting in every election. There's usually 2 or 3 individuals that have violated the law, and the AG's office, when they find that, they'll prosecute it, and they have gotten convictions. but it is a very small number. There's no evidence that I've seen of any organized or widespread voter fraud taking place in New Hampshire.
Thank you. Sam.
Hi, thank you so much. My name's Sam Wong, and I'm visiting from Princeton University and enjoying it immensely. My question for you is, these kinds of fears of fraud can be addressed by leadership figures within a party, and you've just enunciated some pretty rational principles. I can think of Secretary of State candidates who have a pretty plausible chance of winning this November, who are very far from your point of view, yet are members of your side of the aisle. And I wonder if you could talk about the role of peer pressure among leadership figures in the party in setting a tone that you've just described.
That's a really good question, and I don't understand the peer pressure, why national leaders can make certain statements and then have such a following of individuals when the evidence just isn't there to support the position. It all comes back to politics and control and winning elections. And unfortunately, there are candidates out there that are willing to follow the crowd to get elected, even when they know that what is being said is not accurate. In New Hampshire is fortunate in that the Secretary of State is elected by the legislature, and it's a smaller pool of people that hopefully know how the office works and what's needed in terms of the person that should be elected by them to run it. But in many other states and some of our neighboring states, the secretaries of state run at large on the partisan ballot. And so they have to appeal to the electorate that is going to put them in that position. And, it doesn't happen in New England because, most of the secretaries are from the Democratic Party, but I've seen in states further west where, there are candidates running for office that, that are supporting the narrative of a former president of the United States, and we have to get away from that. The position of Secretary of State and the office is too important, and when there is conversation about election laws, it shouldn't be just let's make it easy to vote. It's let's make it easy to vote, but what are the qualifications that we can put on that to make sure that the system is secure? It has to be a dialogue, and the solution should be coming from both parties together, not whichever party is in power.
And with that, we're ready for our next speaker, but thank you so much,
Thank you.
Secretary Scanlan. Going to briefly switch PowerPoint slides here. Bear with me one moment, please. Our next speaker is Representative Barbara Griffin. Representative Griffin received her bachelor's degree in accounting from Northeastern University, and she received her master's in social work from Boston University and her law degree from Suffolk University. She's worked in accounting and business management until she graduated from law school, and her first law job was clerking for the Superior Court of New Hampshire. She's licensed in New Hampshire and Massachusetts and has been practicing law for the past 30 years. She was first elected to the New Hampshire House of Representatives for the town of Goffstown in the 2014-15 term, and she is currently in her fourth term. She also serves on various local committees throughout her community. While in the House, she has served on the Judiciary Committee, the Ways and Means Committee, and the Election Law Committee. She was also the Speaker Pro Tem in her second term. Currently, she is the chair of the Election Law Committee and chair of the Special Committee on Redistricting. Representative Griffin lives in Goffstown with her husband where she enjoys hiking, skiing, and horseback riding. So without further ado, please join me in welcoming Representative Barbara Griffin. Thank you.
Thank you very much, Kyle. Hopefully I can navigate this. I'm pretty bad at these things. I will just say very quickly, I know why Secretary Scanlan went from the timber industry to Secretary of State. It's so he could end elective office. It's so he could ensure the continued generation of paper to continue the timber industry in New Hampshire. I will tell you, as a practicing attorney, every year I wondered what the heck those legislators were doing when I had to buy, and I'm dating myself, the pocket parts for the RSA books, which had the updates for that session law, and you would go to look at what the update were. It'd be some nonsensical change, and you'd be like, what the heck are they doing up there? And that's still what they're doing up there, is making change after change after change. So we all have to buy paper. So moving around here, how do I scroll this, Kyle? I'm pushing.
Down arrow buttons.
Is it moving? I've done something my husband would.
It's all right here.
My husband would say, as only I can do.
Maybe let me try this. Apologies. There we go.
So it's the mouse.
Yeah, we'll use the clicker. Thank you.
Okay. All right. So we're here in New Hampshire. Not all of you are from New Hampshire. You've already heard we have the first in the nation presidential primary. You may not also know we also have a constitution that's older than the U.S. Constitution. We are the biggest state legislative body in the country. We might be the third biggest in the nation, in the world, and we still meet in the original chambers. A couple of fun facts in regards to our maple sugar industry. That is a point of much contention here come February and March. And we have the shortest coastline of any state that has a coastline, which is interesting. As chair of the redistricting committee, I heard a lot about keeping the seacoast area together. It's 10 miles. We also obviously have this state motto, live free or die. All right, so we're here to talk about election law. I'm going to move fast because I want to do redistricting too. These are our top 10 issues as they appear. And I will say they repeatedly appear before the election law committee in one way or another. We're dealing with campaign finance, how you can vote, what the proof of vote should be in regards to domicile residency. You just heard some talk about that. Registration, alternative methods, redistricting. It goes on, and we see some of the legislation repeatedly to the point where we will get calls from lobbyists in regards to certain agendas, and we'll go, well, that's maybe a second year issue. The first year we're going to be focused on this kind of thing, and those will be things like you heard about ranked choice voting, the National Popular Vote Act. They're recurring issues here in New Hampshire. So what happens with legislation in New Hampshire? This is a gross overview. I have a little more detail on the next slide, but basically a bill is introduced. It goes through the same process you hear about at the national level, and ultimately, if it makes it through it, it is either passed into law or vetoed. In regards to the specifics, all right, Kyle, oh, here we go. A bill is introduced by a representative asking it to be drafted. It could be as simple as, I want a bill, and I think we just had this, that you need to report if you hit a cat on the side of a street with your car. That becomes a piece of legislation by virtue of OLS. They are assigned to a committee. You heard Kyle mention the Election Law Committee. Election Law is one of 20 standing committees. Every bill introduced in the House is assigned to a committee. The committee schedules a public hearing. Every bill gets a public hearing. There may or may not be subcommittee work. There is a voting session, and there is a motion made where it goes to the entire House floor of 400 for a vote. Those votes are either going to be, this is a great piece of legislation, it ought to pass as amended, or it should, as we say, die, inexpedient to legislate. It can also be retained. Legislation is then passed on to the other body for a similar process. If it gets through both bodies, it then goes to the governor's office, who can either sign or veto the bill. We tend to have a governor who likes to sign bills. Historically, not all governors sign all bills, and they can become law without signature. This, if you go to the general court webpage, and this is sort of geared maybe for law students who are right up the street from the general court, you can pretty much find out anything you need to know about a piece of legislation in New Hampshire by going to the general court and the House home. Or the Senate home, depending on the bill, and you can actually chime in to what we're doing up there on any given day with the live streaming. If you want to find particular legislation on election law, you can either input the actual bill number, this sort of box is on the home screen for both bodies and the general court, or you can do an advanced search. The right side of your screen is the advanced search screen, and in this particular case, I've chosen 2021. Each session is 2 years. You need to specify the year. And I am asking the system to tell me what bills might have been in front of the House Committee of Election Law. Well, in 2021, your result would show that there were a total of 37 bills before the House Election Law Committee. And this would be the list of all the bills since that year is done. It also gives you a summary of what occurred. You can see on the left, there is a bill number. Constitutional items would come first, followed by House bills and then Senate bills. There is a docket, there is a link to show you the current status, and you can actually look at the text of the bill by clicking on one of those options. In this particular case, I chose to look at HB 77, an election law bill which had to do with requiring town clerks to update daily a notice of who has signed up to run for an office during the primary process. I will tell you, one of the things that has amazed me as a legislator is how self-interested politicians are in regards to what's going on with their office. Whether you want to sign up or stay in, they want a constant update as to who else might be signing up or not signing up. And so this was proposed for every town clerk to upload this information every day. I serve on municipal boards. I'm like, what are you doing? These clerks have enough to do. People were like, everybody has a right to know. We shouldn't be down there. The Secretary of State comes and testifies in our public hearing and says, not every town clerk is open every day in New Hampshire, by the way. They can't do it every day. So what happens is there are amendments done. It passes out of the House, that's pink. It goes to the Senate, which is the green. And then it goes on to eventually be adopted. In this particular case, this bill had a little bit of everything. So you see on the left, as introduced, you see as amended. Legislators and attorneys can't address anything in writing without making it more wordy. That's just a fact. And then on the right, you see it as amended. And you will note that we've sort of marked at the bottom what the amendment is. Look at what the Senate did. They did exactly what the House did. Well, no, they added something about broadband. Now, you may be saying, what does broadband have to do with an election bill? The answer is nothing. It's because the Senate doesn't have rules like the House does, and they can add things that didn't make it through another bill to a bill that they know is going to make it through the process. And voila, we now have HB 77, which will become law shortly after voting, and it will address two completely different subjects. As I said, our governor tends to like to sign bills. That's Governor Sununu on the left. On the right is the House Session Chamber. I would invite you, if you're a law school student, to wander down one day when session is or not in session. It is a terrific building. We have legislators come from all over the country to take a look at the building. There are a number of very unique things. This is the House chambers. I point this out because you can see the dais in the middle where the speaker stands under the portrait of George Washington, the portrait of Lincoln, and three other famous figures are there in the hall. I have stories about all of them. I can also tell you how many ceiling tiles there are, because as some of the debates go on, you need to do something to keep yourself busy. So there are 5 sections. If you can see from left to right, section 1, 2, 3, 4, 5. We actually sit in the New Hampshire House partisan. We have the majority party all to the right as the speaker looks at the hall, the minority party to the left. When I first went out there was bipartisan seating, so Republicans and Democrats were mixed. This is important if you're a School of Law student, because that seat means something. Your legislator, who gets paid $100 a year, can also pay an extra $7, I think, to get a license plate from DMV. If you're from other states, maybe you want to do this, and we can drive around with a license plate that has our seat number on it. So when you drive around and you see a state plate that says Legislator 3-21, that means they sit in Section 3, seat number 21. All right, so let's talk a little bit about redistricting. You're going to hear about that this afternoon. I wanted to address it. Redistricting in New Hampshire had actually 5 different exercises that need to be done. 2 of them were congressional districts in the House of Representatives. You can see here where the House of Representatives, we have more representatives than any other state. We have a representative for every 3,443 people. In regards to congressional districts, we have 2. There are only 5 other states with only 2 congressional offices. And if you notice, we've had it, I've got the data down here from 2010. Our state was only a couple of 100,000 people. We are now in each district 689, which obviously gets us to about the 1.3 million that we are, but our growth has obviously been somewhat consistent with the rest of the country. We continue to only have 2 reps. Now, in regards to redistricting for congressional seats, there are things called independent districting commissions. You're going to hear about that this afternoon. That is a bill that repeatedly comes before the House of Representatives. It's been coming before the House of Representatives for over 10 years. Not this past session, but the session before, there was a bill that made it through the House and Senate in regards to redistricting, and it was vetoed by the governor on July 31st of 2020, and that's the veto message to the left. I will say that in this state and sort of consistently across the country, when you see objection to these commissions, the argument is this is a constitutionally directed action of your elected body. It is their responsibility, and they should not be assigning it to someone else or some other body. I will also point out that in nearly every bill I have looked at for independent districting commission, there is a provision for what to do if there cannot be an agreement or an enactment of it as drafted by the commission that provides for court action. And I want you to remember that. So this session, what we did here in New Hampshire was there was a special committee on redistricting appointed in February of 2021. That's the first year of our session. And it was 8 Republicans and 7 Democrats. There was a website launched. You might recall the census data was late this past year. It didn't actually come out. I think it might have actually come out the end of August. They were saying September, but it was months after it normally is. The committee began its work in regards to it by adopting guidelines. And basically the guideline, the criteria is population. We also needed some software to do it, because in the House of Representatives, we have something called floterial districts, which is not handled by Dave's Redistricting or other software that might be out there. We had public hearings on what should happen in redistricting in each of the 10 counties around the state, and then maps were presented to the committee. Those maps come out of the committee just like a regular bill. That process that I described for HB 77 was exactly the same, and it goes to a House and a Senate vote, and then from there it will go to the governor. Criteria is population-based, as I said. The voting rights of 65 does not apply to New Hampshire. If you go to national symposiums, you hear a lot of talk about that. We don't have to consider it. I won't go into the details. You have on the right the constitutional provisions for this, but basically it provides that the House of Representatives has to be a certain number, 375 to 400, and in forming districts, you keep them as small as possible with county lines being preserved. This is a little different from other states in regards to what we do here. We do not do redistricting on census block data. We do it by community, being careful in regards to what lines we cross. In representative districts, we do not cross county boundaries. In congressional maps, we can. All right. Okay, quickly, this is a sort of a graphic of how we get to 400 reps in the House of Representatives. The 2010, 20, and 20 census figures, again, are there on the right. And you can see what's happened is in our state, in our counties, Rockingham and Hillsborough are clearly the biggest counties. with Rockingham County showing the most growth, and Coos County, which would be the North Country as we would describe it, has been decreasing in population. So when we're doing redistricting, we are not always accounting for increases in population. We're accounting for decreases, which makes the public not happy because it means they're going to have less representation as they see it than they currently have. In regards to the congressional districts, what you see here on the left is a map from 1880. And as you recall, the population of the state from that previous diagram was less than 400,000 back then. And that was a congressional map that was drawn then. And the map in the center was the map going into this redistricting process when the population of the state was 1.3 million people. So what you can see is that sort of I guess you would say the least change method had sort of been done over the course of the years, because we still have this graphic, and you heard the arguments during the process of preserving the seacoast area. There's that 10 miles of border. The map on the right is one of the proposals that came out of the committee to the floor. And the argument for this map was that the population deviation was appropriate. And if you're dealing with New Hampshire and federal issues, this is really the core of our population and transportation network in New Hampshire. What you see on that yellow line is something called I-93. It takes you from Massachusetts to Vermont. So what happened in regards to our redistricting? As soon as a map was passed from the Congress, it hadn't even made it to the Senate, a lawsuit was filed in Superior Court alleging that it was unconstitutional based on the one person, one vote. 10 days later, the Supreme Court invoked supervisory jurisdiction over the process. On our committee, we have a former Supreme Court Justice, Chief of the Supreme Court, who could not recall when this jurisdiction had been invoked by the Supreme Court of the state. So it was a very unusual tack, so to speak, in what the process would be. We had oral arguments presented before the Supreme Court on May 4th, and on May 12th, the court issued an order basically saying, if you don't do it, we will. And what was happening throughout this process was that the governor was saying, I don't like the map. And the House of Representatives and Senate was going ahead and passing maps. So on May 26th, there was a vote on a second proposed map, which the governor announced he was not going to sign. I don't know that those were his exact words. And it was ultimately vetoed, with the special master releasing a court-approved map. So you have on the left a table comparing what maps were looked at, but here you have on the upper side the minority leaders, which were in the center, the Democrats, which was presented to the court. On the right, you can see the plaintiff's plan. So these were what I would say is Democrat plans. On the bottom, you can see the majority Republican plans that were presented to the court. You can see on the left, it was sort of like, well, hey, let's do it east-west. If we're trying to sort of divide the state and sort of say, why are we still using an 1800 map when our population distribution and economics are substantially different? Let's do east-west. And then we had another couple of least change, I would argue, maps, with the special master plan being in the upper left. I think the total communities moved were 4, and as any lawyer will tell you, the court did not do exactly what the plaintiffs presented and not exactly what the respondents presented, but in fact came up with a different 4 towns to move to make the population equal. So the pre-redistricting map is on your left. The present map, the special redistricting map, is right there. I don't know if you can see up here, I didn't realize you were sort of seeing my cursor all over the place. I apologize. This is actually a town, which is sort of interesting. It sort of gets included. And when we had a public hearing about it not being part of the rest of that group to its south and east, we got a lot of local objection. So it stayed as a funny little hook. So what's next? Is there going to be another redistricting? I will tell you, I think there will be. The reality is that the failure of a legislator to pass a map doesn't mean that they can't do it again, try it again. So I fully expect that the next session of the House will have a new map presented for the congressional districts, regardless of what the outcome may be as to the actual election. And we'll see where that goes. There is some discussion as to whether or not it has to be done in the next session, or whether or not by not doing it in the next session, you have essentially acquiesced to the process, and your ability to bring a new map forward later in the 10 years leading up to the next census has been waived. So what would the lessons be? I would say in regards to this process, which of course takes into account the legislative process, and I wanted to address this because I know you're going to be hearing about this afternoon. I don't care what process you use, whether it's an independent redistricting committee or districting committee, whatever you call it, or the legislature, you're going to end up in court. There are still court cases going on. There is still a court case in New Hampshire, actually, this past week. If you're from New Hampshire, you might have read the Superior Court just dismissed a case in regards to the Senate and Executive Council seats. There is still a court case pending in regards to representative districts that has not been ruled on. These things end up in court in this state, all over this country, regardless of how you get to the final proposed map. Incumbency matters. When you're dealing with the legislature, you need to get the votes to pass it. And if the people sitting doing the voting are being affected by what you're proposing, you better consider that when you present it, or you're not going to get anything passed. There is a natural resistance to change. We know that in our houses, with our children, our spouses, or our friends. It is certainly true in representative government, and it's partisan. Election law is partisan. I've had an opportunity to be on a number of panels, and there are times some of us suggest that maybe we need to recognize that, put it out in the front, and then maybe we can start having the discussions we need to have about getting processes and policies in place that really do implement the will of the voter. So with that, I want to thank you for your attention, and I'd be happy to take any questions.
Thank you very much. We have time for a couple questions. Any questions from the audience here?
Thank you. Brad Cook. You mentioned flotorial districts for the House, and I've been doing this for a long time, and I think I know something about politics, but when I went into the ballot box in the primary in Ward 1 in Manchester, I knew the two people in my district, but the flotorial people I'd never heard of. What do you think of the flotorial districts as a policy matter?
I think that given our Constitution with the dictate that we have 375 to 400 representatives, it's hard to not have them. I think that's the reality of it. We end up in a lot of discussions about it. And for those people who are watching who don't know what we're talking about, you have a base district, which has to be the 3,443 people to get to your representative. Some of our communities are obviously smaller than 3,443 people. So you can have a base district that's more than one community. I come from a community, Goffstown, which is big enough to be its own base district. But if I divide the population by 3,443, it's not even. So I've got to get that representation for those other people from somewhere else. And you end up with what Attorney Cook is referring to as going to the polling place and not recognizing a name on your ballot. It's simply a math fact if you're going to continue this exercise. I'm not sure it's bad, because I suggest to you, if you ask most people if they know who they're voting for, the answer will be no. They might have gotten a mailing, somebody might have talked to them about it, but if you ask them if they know them, the answer is no. And as a matter of fact, we found in congressional districts, many people had no idea what congressional district they were in. And you could see by the lines in our congressional district, as you drive around the state, on the border edges, you will see signs for a candidate that are 2 or 3 towns away from the district that you're actually in.
Time for one more question.
Hi. Derek Muller, University of Iowa. Iowa and New Hampshire obviously have some important says in presidential elections. Right now, the Democratic National Committee is rethinking the process of what the early primary and caucus states might look like. I just wonder, as the legislature is considering what its own statutes say, up against what party rules might say, what you're thinking in the legislature, anticipating what might happen in the future.
I can tell you that the legislature has relied heavily upon the Secretary of State's office in regards to defense of its position. And I expect that to continue. Obviously, as a state, we don't have a huge amount of control over what the parties themselves will do. The Republican National Committee, I think, has affirmed its commitment to the first in the nation. We're waiting on the Democrat. I don't know of any discussion of legislation to deal with that. I think our legislation is pretty clear. It's going to end up getting moved. At some point, we're going to have a conflict that's going to have to be resolved, though, I think, as the states vie for that. But I'm confident that our Secretary of State will just deal with it. And of course, in New Hampshire, we don't understand that whole caucus thing anyway. So, you know, whatever you do is fine.
Well, thank you very much, Representative.
Thank you, everyone.
Please join me. We're going to get set up for the next panel now. Okay, we are ready to begin our third panel. Unfortunately, I'm not sure that one of our speakers has been able to make it in quite yet, but we'll proceed with two of our three panelists here. I'm pleased to introduce first Henry Klementowicz. Henry is a senior staff attorney at the ACLU of New Hampshire, and Henry's work focuses on litigation and state house advocacy in support of civil rights and civil liberties, particularly in the areas of voting rights, governmental records, due process, and the freedom of speech. He joined the ACLU of New Hampshire after almost 3 years of working in a large New Hampshire firm, and before that he clerked for the judges of the Rockingham Superior Court. He has represented clients in the New Hampshire Supreme Court, the Superior Courts, all divisions of the Circuit Courts, and the United States District Court for the District of New Hampshire. He received his law degree from Georgetown University Law Center, where he was a notes development editor for the American Criminal Law Review, and he received his bachelor's degree from Columbia University. He's a New Hampshire native and lives in Portsmouth with his wife and son. And our second speaker is Liz Tentarelli. She is the president of the Nonpartisan League of Women Voters of New Hampshire. She has been a league member since 1997. During the legislative sessions in Concord, Liz often attends committee hearings to testify in the name of the league on election law, incarceration, and public education issues. As a result of Liz's leadership of the League's study of women voters in New Hampshire's correction system, she was appointed by Governor Hassan to the Citizens Advisory Board for New Hampshire Correctional Facilities for Women in 2015, and she was reappointed by Governor Sununu in 2022. She received her master's degree from UNH in 1974, and she had a career spanning over 30 years teaching high school and college students, and for 14 years has been semi-retired as a substitute teacher. So we'll start off with Henry, and then we'll go to Liz, and then we'll do Q&A. So without further ado, join me in welcoming Henry. Thank you very much.
Thank you, Kyle. My name is Henry Klementowicz. I'm a lawyer at the ACLU of New Hampshire. We're a nonpartisan, multi-issue advocacy group in the New Hampshire affiliate of the American Civil Liberties Union. And at the affiliate, a lot of my work focuses on voting, so that's what I'm here to talk about. We're typically doing voting work in sort of three buckets. We have our advocacy at the State House, which I'll talk about. We're in court, often challenging laws as they get passed. And we also do Know Your Rights presentations throughout the state to help explain to people what their rights and responsibilities are with respect to voting. So from my perspective, I guess I'll just start by saying I agree with Representative Griffin that election law has become sadly and increasingly partisan. We work on a lot of issues from criminal justice reform to housing policy issues. And sadly, I think it's fair to say that one of the issues we work on that's the most partisan is around elections. So to sort of set the stage, as the secretary said, a report recently came out that found New Hampshire was the 50th easiest state to vote in the country for reasons such as No online voter registration, no automatic voter registration, no third-party voter registration drives, no pre-registration for 16-year-olds, no excuse absentee voting, no early voting, and what from my perspective is a clunky registration by mail process. But on the other hand, we also have, infinitesimally small instances of voter fraud and high voter confidence. So as of April of this year, the Attorney General's office had told me that of the over 1 million votes that were cast in the September and November 2020 elections, they had opened up 0 enforcement proceedings related to wrongful voting or voter fraud. As the Secretary said, voter confidence in New Hampshire remains very high. We're at 80% or 84% of people in New Hampshire believe that our elections are safe and secure. The governor has said that, the Secretary of State has said that, his predecessor has said that. And yet, every year we see at the State House efforts to make voting more difficult. From my perspective, we usually see about 50 or 60 bills filed with that committee every year, and they sort of get whittled down to 1 or 2 bills that sort of have the juice to make it across the finish line every year. In 2017, that was Senate Bill 3. Sorry, Liz, I know you're gonna, I'm gonna hit that briefly because I know Liz is gonna talk about it, which was a bill that created new and lengthy and confusing voter registration forms that was struck down by the New Hampshire Supreme Court in 2021 and ultimately cost the taxpayers of New Hampshire over $4 million in legal fees, which went to the state's outside counsel, and also the fact that they had to pay attorney's fees to the plaintiffs. We saw 2018 House Bill 1264, which was a bill designed to make it so that the act of registering to vote now had associated with it the costs of domesticating a driver's license and car registration in New Hampshire. The purpose of that, I think, was really to target college students who lived in New Hampshire but didn't buy a New Hampshire driver's license but still wanted to vote here. We have Senate Bill 418, which was passed last year, which is pending a couple court challenges, that creates a new category of affidavit voters. I don't want to get in too much into the details, but that bill is pending as well. We also see every year efforts to change the domicile statute to exclude college students from voting. We see efforts to remove the affidavits that one can use to prove any of the 4 qualifications of voting. We see efforts to increase the criminal penalties associated with anything resembling voter fraud. And this just sort of continues every year, despite the fact that New Hampshire already doesn't have basically any of the standard voting conveniences that you see in every state. So in some ways, that's a blessing. You can't cut early voting, or you don't have early voting. You can't reduce the number of polling stations where there's only 1 per town. And you can't get rid of no excuse absentee voting where you already don't have it. In addition, a couple other things sort of worth mentioning, I think, are the role of the redistricting process. So like everywhere else in the country, we just got through the legislative process of redistricting anyway. So, by way of background, I'm sure all of you know this, but in 2019, the US Supreme Court closed all the doors to federal courts for claims of partisan gerrymandering challenges. And that's an issue that's been left open to date by the New Hampshire Supreme Court, whether and to what extent our state constitution protects against partisan gerrymandering. So there was a lawsuit that was actually dismissed yesterday, Brown versus Scanlan, that Representative Griffin had talked about. Basically, it's not a case I'm involved in, but if you read the complaint, the plaintiffs in that case alleged that through the redistricting process, the legislature drew state senate and executive council maps so egregiously partisanly gerrymandered that, for example, Republican candidates could win 48% of the statewide popular vote for each body and yet still win supermajorities in each chamber because of the way that the districts were drawn. I don't have any particular knowledge about that case, but I would be pretty surprised if it were not appealed. So I think we'll be getting some answers from the New Hampshire Supreme Court soon on what our state constitution says about partisan gerrymandering. Obviously, a number of states have found their state constitutions either explicitly or implicitly prohibit partisan gerrymandering. States like North Carolina, Pennsylvania, and Ohio have struck down their maps as under state constitutional theories. So we'll see if that happens. There was an impasse litigation case that was resolved with respect to our congressional districts. I think this is also a case of partisan gerrymandering. So the legislature had passed a couple different maps trying to redraw our 2 congressional districts. And we received a lot of national flack for the fact that New Hampshire was the last state in the country to enact congressional plans, even though we only had to draw one line. And basically it's because the governor in his veto message, he said this on MUR, that he thought that the way the congressional districts were drawn, you all saw the map, some people think that this was about preserving the Interstate 93 communities of interest. The governor thought it was about creating one safe Republican seat and one safe Democratic seat. When the Republicans took control of the state legislature after the 2020 election, the head of the New Hampshire Republican Committee said that he could guarantee they would send a conservative Republican to Washington, the first congressional district, because they controlled the redistricting process. And from my perspective, that's basically what the legislature tried to do, and would have gotten away with it had it not been for that meddlesome governor. Ultimately, that case went to the New Hampshire Supreme Court. The state of New Hampshire took the position that even though there were about 18,000 people, too many in the first congressional district due to population changes, actually it was fine and we should continue using the existing maps. The Speaker of the State House and the President of the New Hampshire Senate took the position that the independent state legislature theory, which I know you'll be hearing about later, prohibited the New Hampshire Supreme Court from addressing the matter because the electors and election clauses of the US Constitution reserve the power to district solely to state legislatures. That was rejected by the New Hampshire Supreme Court. Both of those arguments were in a May 12th opinion. It came out on my birthday, actually, that we saw the New Hampshire Supreme Court reject the independent state legislature theory. So that was pretty exciting. And then ultimately they appointed a special master to draw the maps, which he did by moving 5 towns in the North Country from one district to another. The final thing that I'll talk about, just sort of briefly to hit on, is since we have a legislature that really only works 6 months a year, the things, 5 minutes, thank you, that I and some of our coalition partners have been sort of following has been the Special Committee on Voter Confidence created by the Secretary of State's office. And I know there are members of that committee here, so I will be respectful of what I say. But basically, as I talked about, New Hampshire has high confidence in our elections. We have extremely low instances of voter fraud. And yet this committee was impaneled to deal with, what was perceived by some to be a crisis of voter confidence in New Hampshire. And I think has sort of unfortunately ended up, at least in part, platforming election deniers. So, New Hampshire is not immune to the same thing that we've been seeing across the country, which is people wrongly continuing to believe that the 2020 election was stolen. And so you have people who are coming in and presenting evidence that's not been corroborated by any court or any government agency or any media reports that have looked at it and explaining, that there have been huge amounts of voter fraud. And I think, I'm not an expert in communications, but I worry that the process of giving a platform to folks can actually perversely, and I think unintentionally probably, increase voter, I don't know what the opposite of confidence is, I guess, fears or concerns, rather than allaying those. And so from my perspective, what I'd like to see increased voter confidence would be fair maps, not drawn by partisan political actors. As Representative Griffin said, there was an effort in 2020 to establish an independent redistricting commission that was vetoed by the governor. It did pass the state Senate unanimously, passed the New Hampshire House Election Law Committee unanimously. And so I thought was a pretty good bill that really could have helped, but sadly, not all saw it that way. I'd like to see, more and continued leadership from high-ranking government officials explaining the voter process like the secretary did today and explaining why we should have confidence in it, rather than using it as an opportunity to let perceived fears of voter fraud that aren't borne out by the facts become the basis for legislating more restrictive voting laws. And I think that's a sad trend that we've seen across the country, is a political candidate says, there was a massive fraud and I lost. And even though no one can actually point to that fraud, a lot of people believe it, and then the fact that people believe it is used as a basis to restrict people's rights to vote. And that I think is happening in New Hampshire too. So with that, I'll turn it over.
All right, thank you, Henry. And thank you for inviting me here. I'm not a lawyer. I'm having fun among a bunch of you, though. My name is Liz Tentarelli. I'm president of the League of Women Voters of New Hampshire. We're an all-volunteer organization, and I'm kind of representing not only that here today, but also all the many other NGOs and informal organizations that seek to help the average voter understand the process. So I often do presentations similar to Representative Griffin's about how bills become law and how redistricting works. I never do it as fast as she does, which is probably to the benefit of my uninformed audience. You are certainly an informed audience. But let me tell you, first of all, that the League of Women Voters has as its mission empowering voters and defending democracy. We're a direct descendant organization of the women's suffrage movement. We formed 102 years ago when the suffragists realized that they were about to get the vote secured with the 19th Amendment, but their work wasn't done. Now that women had the right to vote, they needed to learn how to use that vote, how to register, how to cast a ballot, how to study issues so they could vote from a position of knowledge. And so they simply changed their name in convention to the Nonpartisan League of Women Voters. I wasn't part of that convention, but here I am still representing them. So in the 102 years since 1920, when 8 million women voted for the first time in a federal election, I believe voting has gotten more and more complicated, mostly because legislators make it so by passing laws that the average voter never thinks about. So let me take you back to 1920 when those first women were registering to vote. We have records in the Cheshire County Historical Society in Keene that show some of the complexity that those first women voters faced. First of all, to register, they were asked to give their full names. Now, in 1920, a married woman's full name was not Mary Ann Smith, for example. It was Mrs. Richard H. Smith. And how dare you, young man, ask me these personal details of my first and middle name when you're asking me to register to vote? So that was a problem. And then women were asked for their birth dates, including the year. And women didn't do that in 1920 and reveal that personal information. There's a record of one woman in Keene who was asked to take a literacy test as part of the registration process. Now, that was asked of everybody who was registering then, and we know that in southern states it was vastly abused in order to suppress the Black vote. But that woman in Keene stood at her full height and looked at the young man registering her and declared, "Young man, I was your third grade teacher. Of course I can read, and I made sure you can too." Well, all right, what else? A big discussion in 1920 centered on poll taxes. The conundrum was that for decades, marriage was considered a joining of two people into one, and that one person was the husband. So should a married woman also be required to pay poll tax, or was she covered by her husband's poll tax? Coverture applied to many things in a married woman's life, and should it also apply to the poll tax was the dilemma. Well, we no longer have poll taxes nor literacy tests, and for at least the last 40 years, women have given as their full names their own name. Maybe we still fidget about how old we are, but that's a different problem. But now, voting registration requirements in particular, have become more and more document dependent. We are asked for proof of age. That's fine for a man who has a birth certificate. But what about the married woman registering for the first time in a town, and the name on her birth certificate isn't the name she uses anymore? So does she need her marriage license too to prove that connection? We're asked for photo proof of identity, both at registration and since 2012, whenever we vote. So that's fine for most of us. We pull out the driver's license. But I spent days and days in 2012 going around to senior citizens groups and disability rights groups explaining our new photo ID requirement and what those people could use, people who did not have driver's licenses, making sure they understood what they could use and still be able to vote. Now, I'll give New Hampshire legislators credit for thinking of that problem, that some people just don't have licenses, and making a number of options available to prove identity. But it's still a challenge for the poor or disabled who can't afford a car, don't drive, have difficulty getting a non-driver ID from the DMV, who don't have all the documents the rest of us do. Now, student IDs are included in the acceptable list of photo ID requirements, options, which is great for young people who haven't yet taken driver's ed, don't have licenses. With the cost of driver's ed and insurance, that's becoming more and more students. But what the New Hampshire legislature tries to do every few years in this back and forth that Representative Griffin talked about, there are attempts to keep college students from voting in the college towns, the towns where they're spending 9 months a year. And they try to get rid of that option of allowing the use of student IDs to vote. So I'll get back to that notion of voter restriction in a moment. But the most document-dependent requirement in New Hampshire is proof of domicile. And Henry mentioned Senate Bill 3 in 2017. The League of Women Voters was one of the parties that sued the Secretary of State and the Attorney General over that bill. We fought that in court because for many voters, no such documentary proof of domicile exists. So think of my neighbor's 95-year-old mother who gave up her house in the city to move in with her daughter in my town. Even her mailing address for her government documents is her daughter's post office box. She has no lease, no deed, no property tax bill. In that sense, she is stateless. We won that court case. not necessarily on the basis that I argued, that some voters would be disenfranchised because they simply lack such documents. And that the very real challenge to my organization of trying to explain this to people would deter potential voters. No, we won because the language of the law, which must have been drafted by lawyers, and the resultant voter registration form itself were so dense, convoluted, and incomprehensible that the average voter was unable to understand what they were signing, and that in itself is illegal and a discouragement to voters. That bill engendered a lot of opposition in its public hearings on various grounds, but it didn't stop the legislature from passing it and the governor from signing it. So why did that kind of restrictive legislation make it so far? Well, it was this specter of widespread voter fraud that was hovering in the top of the hearing rooms. It was the sponsors of the bill talking about white vans filled with tons of voters from Massachusetts coming up here ready to fake their addresses so they could vote fraudulently, like they've got nothing else to do. I'm sorry. Anyway, that specter hung over that bill. The Secretary of State denied there was that kind of organized voter fraud. The counter argument from the sponsors was, well, if you don't require proof of domicile, we don't know that there wasn't that kind of fraud. And it went round and round. So even the Secretary of State's and Attorney General's facts didn't matter. Sadly, the court victory that we had with SB 3 didn't change the fact that a list of those required domicile documents still exists in election law. And it has been pulled up several times in the last few years by, I just changed my notes from Yahoo's to election skeptics on the record. Okay, so that's better, yes. So election skeptics keep returning to that list. And I love it when I'm in the hearing room when that happens, because then I can say that is not the law anymore. Struck down in 2021. So from the viewpoint of my organization, League of Women Voters, voting is the right by which we secure all our other rights. It's the key to defending democracy. It gives each of us a voice, even marginalized people. But the challenge for League of Women Voters and other pro-voting groups is making this increasingly complicated process user-friendly. I don't want to add to my already dense How to Vote in New Hampshire brochure the new affidavit ballot law that Henry referred to that goes into effect next year. It won't apply to very many people, but for those to whom it will apply, it makes voting a 2-day process. And I'm sure if I start explaining that to somebody, well, that's not going to be very good. You know, they're going to be discouraged. The ballot will be identified, opened in public, your votes deducted from your town's tallies. People don't like that. Secretary of State Scanlan mentioned the secrecy of the ballot as critical. And that is threatened by SB 418. If I, as a league representative, have to explain it to people, do you imagine those people will feel welcomed in the community of voters? For every hoop that must be jumped through, voting becomes less a communal activity, something citizens do because it matters, and it becomes a chore or even maybe a test that possibly the potential voter will fail. So the language of the law is complicated and nuanced for many reasons. I understand that, but I hope that those of you here today who one day may be drafting election laws or acting in court for those laws I hope you'll keep in mind what the purpose of voting is: to allow all citizens to have a part in choosing who will represent them, to make them feel vested in the process of government, and to make their voices heard. And none of that should be so complicated that a potential voter leaves in discouragement, muttering, "I can't do this." With that, I will turn it over, and I think you're going to get introduced here.
Yes, our third speaker arrived, and we're grateful that Mr. Todd Hendricks is here. So allow me to introduce him. Todd is a data and research analyst at the NAACP Legal Defense Fund, where he specializes in statistical inference and algorithmic redistricting. Over the course of the 2020 redistricting cycle, he performed racially polarized voting analyses to support litigation research in nearly 24 jurisdictions, from the congressional to school board level. And before joining the Legal Defense Fund, he worked for a technology startup developing analytic software to support renewable energy asset management. A native Texan, he earned his master's in public affairs degree from the LBJ School at the University of Texas at Austin, and his bachelor's degrees in political science with honors from the University of Houston. So without further ado, Todd, welcome.
Thank you, Kyle. I took improv in college, actually, and I didn't realize it'd come in handy on something like this. I used a lot of improv this morning to get here. If you go out in the parking lot, Kyle, and see a U-Haul van, that's my rental car. So that's the kind of morning I've had. Yeah. But it's a pleasure to be here. As Kyle said, I work for the Legal Defense Fund. We're the oldest civil rights organization in the country. And it's been an interesting redistricting cycle for us. Most of our work is in, this cycle, it was a lot in Louisiana, Alabama, and South Carolina were our kind of primary states. And we did some work in Mississippi and Georgia as well. I want to kind of paint the picture of how we were, thinking about, coming into this cycle. For background, in 1982, the Congress, believe it or not, was bipartisan at one point, and they overwhelmingly amended Section 2 of the Voting Rights Act, at which point, the law was pretty strong. In 1986, the Supreme Court ruled on that amendment, and it was the first time that the court interpreted the new Voting Rights Act, and it was a good ruling. Thornburg v. Jingles is the name of the case, and it's still the law of the land today. There's really three evidentiary things you need to prove to get in court to file a Section 2 lawsuit. The first is the district that you're proposing needs to be geographically compact, meaning that the plaintiff group needs to be big enough and spatially dense enough to demonstrate that they could actually have a district in the new plan, and you have to propose that district. The second and third thing that you have to show, both are pretty closely related. That's what Kyle referred to as racially polarized voting. That's what I do. So I live in this Jingles world where I'm looking at these things all day, every day. And I'll note that, things have gone as we would expect. It's been difficult to advance minority representation in the places that we've worked. But we've had a little bit of success, I'd say. We expanded Gulfport, Mississippi's city council. I was excited to work on that. And I would actually say that the way we've worked in the Alabama congressional plan and the Louisiana plans we've done a great job. Hopefully, some of you had a chance to listen to the oral arguments on Tuesday for Merrill v. Milligan, which was the Alabama congressional case that we're working on. It was interesting. Hopefully we can get to that, Kyle, but I'll just say that the last thing I'll say is the Louisiana congressional plan. The thing about redistricting, Liz, is that, there's thousands of maps being drawn all over the place, and it's hard to follow these events, but Louisiana was the most incredible thing that I've experienced. And I say that because we were there on the ground. We had a team of attorneys. I'm not an attorney, but we had a team of attorneys at the very beginning of the legislative session, going to the different hearings, testifying, saying, hey, we've got 10 maps that comply with the Voting Rights Act. You can't say that you can't draw a map. We've got plenty for you to choose from. And, the legislature didn't respond. So we were working the legislative session. Close to the end of the session, the governor said, if you don't draw 2 Black congressional districts, I think you're going to violate the Voting Rights Act. And the legislature ignored him. On a purely racial line vote, all of the white legislators supported the plan. All of the Black legislators didn't. And it got vetoed by the governor, which means they had to go back and redraw, meaning they had to draw 2 districts. They spent a lot of time hemming and hawing about why they couldn't do that, went back in session, passed the same map that they passed before. And we filed the lawsuit shortly after, went to trial. The trial judge found that indeed there was a Section 2 violation. And then Louisiana, of course, appeals to the Fifth Circuit Court of Appeals, which is, a very conservative court. And the Fifth Circuit Court of Appeals agrees with the trial judge. And it's a great opinion. He said, you guys, showed everything you needed to show. And it gets appealed to the Supreme Court and stayed because, the court said, hey, we're going to rule on Merrill, and that's going to have a lot of bearing on the Robinson case. But, the sequence of events that I just laid out, this was 4 or 5 months of just back and forth, incredible effort. So I'm really proud of the fight that we brought to that. Last thing I'll say is I'm writing a paper for the Symposium. I've got a little bit more work to do on it, Kyle. And there's really, the way I'm framing it is there's 2 cases before the court that are going to be impactful for redistricting in our view. Merrill v. Milligan, and of course, we're going to talk about Moore v. Harper, this independent state legislature doctrine. I can't even say it with a straight face. I think what we're seeing with those, when you take those 2 cases together, is a shift from federal power to the states. And what I try to do in in my paper is articulate on the ground, technically, how that's going to be complicated. And Dr. Wang, I see that you're also looking at that. I'm looking forward to your research. Well, the argument that I'm making is that racially polarized voting basically precludes political opportunity for a vast swath of the American South, for minority voters. And so with that shift of power to the states, I think it's imperative that we have some kind of policy solution to respond to that, because it's not going to be pretty. So that's the premise of what I'm saying in my article, and thanks again for letting me be here.
Thank you all very much. We have about 15 minutes for questions with the panel. So I'll start with in-person attendees first. Are there any questions for either Henry, Liz, or Todd?
I'm just wondering what you think the best solution is, because there is a huge swath of the country that is very concerned about election integrity. And I understand what you're saying. You were saying, we shouldn't even open it up or give them a platform. But I think things such as voter ID is something that I think a lot of people think we need to have. And I know I was born out of the country to US citizen parents, and I had a situation where my driver's license expired and my passport was expired and I had lost my social security card. And I was in a state where they had a really stringent voter ID law that had just passed. And I could not get my driver's license renewed because the voter ID law was so stringent. And so it was much, much easier for me to get a new passport than to get my driver's license renewed. So I know how hard it is, but I also think, we probably do need to have voter ID because, it's a problem. People are very suspicious when there isn't a voter ID. So I'm just wondering what you think the best solution is to be able to have it easy, but also have an ID.
So I quite agree that we've gotten used to the idea of voter ID over the last 10 years, and in New Hampshire, the legislature wrote the law so that there were options for people who didn't have a driver's. Like, what if you lose your driver's license under a DUI? Do you not physically have it anymore? Does that mean you should be denied the vote? I don't know. I don't know if that's an issue. I think New Hampshire's law makes sense if we were to adopt one more thing. That is to make it easier for somebody who doesn't drive to get a non-voter ID that would last for more than one election cycle and that could be gotten locally. Now, again, we need all that lawyer language to make this happen, but it would be possible. There are states where the voter ID laws are far tighter than New Hampshire and require entirely a government issue photo ID. And what happens when someone loses it or when it expires or when they're out of state. So I think we can work with this in New Hampshire and that voters now understand it. But you can't keep layering things on to that voter ID in terms of more and more documentation. You've proved who you are. Now let me vote is what should be our logic. There are states that years ago used to issue a voter ID card, some kind of document. I've never even seen one, but I was told that by other league members. Maybe that's what New Hampshire could do or other states could do. So I'm not opposed to voter ID because you are absolutely right. We do need security. That notion of out-of-state voters coming here just for the heck of casting ballots has got to be laid to rest. And the voter ID is one part of that. So thank you for that question.
I'll just add, part of the problem with putting restrictions on how people vote in response to perceived fears of evidence is that you do that and the fears remain. We have voter ID in New Hampshire and we still have suspicions about it. I'm not sure if there are any states that don't have voter ID. That hasn't stopped everyone who's election skeptics. That hasn't stopped election skeptics. And just, we can make it harder to vote, and we do every year. That doesn't seem to change any of the skepticism. So maybe it's worth examining what's actually driving that skepticism, and is it actually just people wanting to win elections?
Any other questions?
Hi there. I have a question that is possibly obscure, but possibly of interest. And it combines interests of the ACLU and of the NAACP Legal Defense and Education Fund. And it gets into the topic of floterial districts, which are fascinating. I noticed that the New Hampshire House has changed hands 6 times in the last 8 elections. And the current margin is 26 seats, if I'm reading correctly. And there are many more floterial districts. And this raises in my mind the possibility that these districts, if not carefully drawn, could confer an advantage that's unfair, especially because the candidates are often not well known. And so I'm curious about what the thinking is among good government advocates in New Hampshire about these floterial districts, and if they've been looked into as to whether they treat the parties fairly. I'm sorry about the somewhat inside baseball, but you know, we've got experts here, so I get to ask.
Dr. Wang, is that a multi-member structure? I'm not familiar with.
It's a layer of maps that float on top. So like I live in Portsmouth Ward 5, and I'm actually in 2 House districts. So there's one that's my ward in the neighboring town. That's the base district, and then there's another floterial district that's like 4 towns. And so I vote for 2 people who are running in different districts. So my view on floterials, and there's an interesting history behind them because the New Hampshire Supreme Court at one point called them an unsound redistricting device. But it turns out that the combination of 400 representatives for 1.3 million people and our unwillingness to break up towns or city wards makes them necessary. Because if you have a town with 4,000 people, there's only a couple ways that you could give someone like 1.3 representatives. And so I think that, I don't know how you would do it under current law without getting rid of floterial districts, but I agree with you that they do add more room for sort of nefarious gerrymandering goals. I'll tell you, one of the lawsuits that's pending against the state house maps that Representative Griffin had alluded to is based upon a provision of the New Hampshire Constitution that says every town that's big enough to get its own representative and not be in a multi-member district should, and that's never really been enforced by the New Hampshire Supreme Court because it turns out it might also be mathematically impossible. But if that were enforced, and if the room the legislature was given to draw floterials was diminished, I think it could lead to less of an opportunity for partisan gerrymandering. I will say, my understanding just from talking to people who live in New Hampshire is that everybody hates floterial districts because they think it makes them too far away from their representatives. So I think there are other nonpartisan biases that do act in the legislature to minimize floterial districts. But it certainly is a space, I would agree with you, that kind of tinkering.
A frequent phone call or email that I get at League of Women Voters office is from voters to say, I'm looking at my sample ballot and it says I'm in Merrimack District 5 and Merrimack District 23. Which district am I in? And I try to explain to them, you're in both. And I go through Henry's explanation. And with that one-on-one explanation, people understand it. But it is another of those complexities of election law that discourages people because they're saying, well, I know that my district is this. It's my town and my neighboring other little town. And yet, who are these other people on my ballot and why am I voting for them? But I agree with Representative Griffin and with Henry that mathematically they're necessary. I think in this cycle, there was enough public discussion, public input that the floterial districts that were created, for the most part, were kept as small as was reasonable and as local as was reasonable. And so, you know, it's just, I just keep explaining it to people, that's all.
And also, we make like contact your rep tools to like vote on this issue, and that makes it way confusing for people when they type in their address and they see they've got 8 reps in 2 different districts.
The ACLU has a partisan report of the of these flotarial districts. So you've got data handy to figure out whether they impose an undue partisan advantage.
Right. So we found that in general, the new House plan took the number of GOP-leaning seats from 196 to 214. So I don't know how, I don't think that was all flotarials, because you can also do it with creating different multi-member districts. But for sure, we did find, our analysis showed that there was a partisan effect of the new state House plans.
But not as bad as the Senate or Executive Council.
We have time for maybe one or two more questions.
So the study that ranked New Hampshire last for ease of voting, I just was looking at that, and it appears that there's a high partisan correlation between how people expect presidential elections to go and where ease of voting falls on that spectrum, with the redder states tending to be much more onerous for ease of voting. Whereas I look at New Hampshire and, this state seems to be purple shading slightly blue in presidential elections. What do you think explains this disparity between kind of that very simplistic expectation versus reality? And then, there were some anecdotes that you mentioned of people who have a really difficult time with actually getting to vote in New Hampshire. Yet there's this high level of confidence and kind of seeming happiness with voting access in this state. So could you maybe address that dichotomy as well?
We are indeed a purple state. The number of Democrat and Republican voters is nearly equal, with the largest number of voters being the undeclared voters. And so if you think of us as a split state politically, we're also split in our attitudes towards voting. We say, boy, this is complicated, and yes, I'm going to vote. Maybe it doesn't make sense. I mean, we voted as a state in 2020. On the state level, we have Republican House, Senate, and governor. And on the federal level, we have Democrat senators and representatives. We're just a little bit crazy in New Hampshire. And we split our feelings, our votes, our attitudes evenly without making sense. That's my take.
I'll just add, yes, New Hampshire has voted for Democrats since 2004, I think, for president, but it's not the presidential electors that set voting laws in New Hampshire. It's the state legislature, which has been much more Republican. And I'll also add, there is an element of history to this too. I think New Hampshire does have a history of in-person voting that doesn't necessarily exist out west. And so there are features beyond just partisan nature that affect how people have historically voted in the state, how they feel comfortable voting. But whereas the states around us have been making changes towards no excuse absentee voting, for example, we have not. So in 2020, the legislature passed a bill to expand the definition of disability for absentee purposes to include anyone who has any concerns about COVID can vote absentee. That didn't happen this year, right? There were bills to have no excuse absentee voting or to codify that guidance. That didn't happen. So the current guidance from the Secretary of State's office is if you have COVID, you can vote absentee under the disability rubric. Or if you so limit your day-to-day life under the personalized guidance of a healthcare professional, you can vote absentee if you're concerned about COVID. But if I just were COVID is spiking right now, I don't want to be in person to vote absentee, I want to vote absentee, that would not be a reason in New Hampshire to be able to do that. Whereas in some of our surrounding states, it would be.
I have one online question specifically for Liz. If you could please elaborate on the problem with the Senate and the executive maps.
Those maps were both drawn to give significant partisan advantage to the Republicans. We have been criticizing Executive Council District 2. We've only got 5 districts. We criticized District 2 for the last 10 years for being a packed district with Democrats so that the other 4 would go Republican. And so the new districts that came out make Senate District 2 look very different, but it's still a packed Democrat district with a significant bias for Republicans in the other 4 districts. And the analysis done on the Senate districts would have about 14 to 16 of the 24 seats very, very likely to go Republican, even though, as we've said earlier, we are a split state, a purple state.
And we're just about out of time here, so please, everyone, join me in thanking our panelists here today. It's my honor to introduce 2 outstanding scholars here for our 4th session. Our first speaker is FEC Commissioner Ellen L. Weintraub, and she has served as a commissioner at the U.S. Federal Election Commission since 2002 and chaired it for the 3rd time in 2019. During her tenure, she has served as a consistent voice for meaningful campaign finance law enforcement and robust campaign finance disclosure. She believes that strong and fair regulation of money in politics is important to prevent corruption and maintain faith of American people in their democracy. She has sounded the alarm early and continues to do so regarding the potential for corporate and dark money spending to become a vehicle for foreign influence in our elections. She has published articles in the New York Times, the Washington Post, and other leading outlets. She's a frequent speaker on news shows and at conferences both here in the United States and abroad. Commissioner Weintraub is a native New Yorker with degrees from Yale College and Harvard Law School, and prior to her appointment at the FEC, she was of counsel to the political law group at Perkins Coie LLP and counsel to the House Ethics Committee. And to lead a moderated discussion is our own Professor John Graby. Professor Graby directs the Warren B. Rudman Center for Justice, Leadership, and Public Service and is professor of law here at the UNH Franklin Pierce School of Law. He teaches a wide range of courses, including constitutional law and civil procedure. He also writes a monthly Constitutional Connections column for the Concord Monitor. He previously taught at Vermont Law School and has an appellate practice and clerked for 17 years for a number of appeals and district court judges throughout the geographic territory of the United States Court of Appeal for the First Circuit. So without further ado, I'll turn it over to Commissioner Weintraub and Professor Graby. Thank you.
See if I can get this mic pointed in my direction. Can you hear me? Is that working? Okay. Thank you, Kyle, for that kind introduction. Thank you to the University of New Hampshire for inviting me to this beautiful fall weekend in New England. I am a native New Yorker, but my father is from Newburyport, Massachusetts, so I feel like I'm actually a New Englander. 50 years ago, the country was racked by a political scandal that involved burglary, blackmail, bags of money. You can still go online to the Nixon Library and hear the tapes. Lordy, there were tapes. You can hear Richard Nixon in conversation with John Dean, who, when he told Nixon that money would be needed to pay off the Watergate burglars' blackmail demands, Nixon said, "You could get $1 million and you could get it in cash. I know where it could be gotten. I mean, it's not easy, but it could be done." It is chilling to listen to the voice of a president of the United States talking about how one would accumulate that kind of money for hush money. And they were literally bags of cash that changed hands. The country was riveted by the hearings, and the result was a lot of new laws because they felt like they needed to respond to this. The country was outraged by the corruption that was revealed. A president obviously left office. His own leaders of his own party went to him in the White House and said, "Dude, you got to go. This is not this isn't going to hold and you're going to get impeached if you don't resign. And that's exactly what happened. He resigned. And, you know, it's interesting to look back on what happened 50 years ago and think about more recent current events and whether we could even imagine that happening today. Also, this whole scandal was at about $1 million, $1 million. And people thought that was a phenomenal amount of money. In 2020, all of the political actors who were involved in trying to influence the election raised and spent an estimated $14.4 billion with a B, billion dollars, $14.4 billion. And that was twice what had been raised and spent just 4 years earlier. The money always goes up, but last time it really skyrocketed in ways that I think really took a lot of people by surprise. In Georgia alone, 2 Senate races were up, and it's true they had to have 3 elections for those 2 races because it went to a runoff, but still, $863 million was spent just on those 2 Senate seats. But don't worry, because the average winning Senate candidate only spends about $27 million. Now, the average loser in 2020 spent almost $25 million. So that's, you know, kind of sad for that person. That's a lot of money to spend to lose. And the good news is that small donors are up. In 2020, 22% of that money came in from what we call small donors, the under $200 donors, as opposed to 15% in 2016. So there's an increase in grassroots activity in money in politics, so that's a good thing. And amongst presidential candidates, both Biden and Trump raised roughly 60% of the money that they took in from small donors. Of course, that's not the whole story. We all know about Citizens United, 2010, big decision from the Supreme Court. I could go on at great length about the decision, but I won't. I'll just say that originally what people were concerned about was the notion that all of the massive amounts of wealth that is at the disposal of corporations in this country was then going to be flooding into politics. And that's not actually what happened, because corporations, they don't really want to be out front in politics. They have too many stakeholders. They've got boards of directors, they've got employees, they've got customers, they've got shareholders, and with that wide a range of stakeholders, they're not all going to agree. So corporations, you know, they give to the Chamber of Commerce, they try and give money through trade associations. They don't want to be out front in their political giving. I'm not saying they're not giving, they are, but they're not as out front about it. But what Citizens United really did was it supercharged the power of the mega donors. It was always legal for, going back to the Buckley decision in 75, 76, for a very wealthy individual to spend as much money as he or she wanted. But in the wake of Citizens United, these super PACs started forming where they could combine their resources. And with the Supreme Court's more laissez-faire attitude on money in politics, and its increasing restrictions on what the government could do to limit money in politics, these big donors started to really feel very empowered. In 2020, 376 donors, and by that I mean individuals and couples, gave $1 million or more apiece, 376 people. And there were a couple who gave over 100 million, over 100 million. In 2022, 19 donors already have given $10 million or more. In the decade between, a little more than a decade, between 2009 and 2020, 12 mega donors gave a combined $3.4 billion to federal candidates and political groups, accounting for $1 out of every 13 in elections. And let me say that at the Federal Election Commission, we collect all of the raw data about where the money's coming from and where it's going. But when I quote some of these analyses and statistics, my go-to source is the Center for Responsive Politics, opensecrets.org, who does a great job of crunching the numbers. In 2018, for example, they found that the top 1% of donors gave 96% of the money that went to super PACs. So we're talking about a very small group of people who are spending a lot of money.
And now it's become routine for these outside spending groups, so these super PACs, to outspend the candidates. That never used to happen. I mean, there were always some outside spending groups, even before Citizens United, but they never would be outspending the actual candidates. But that is indeed what is happening now. Now, the Supreme Court says that's fine, and it can't be corrupted, even if people are funding these outside groups to the tune of millions of dollars, because it's all independent. Let me tell you something, our rules on coordination are pretty porous and have not been rewritten in 20 years. They were last rewritten just before I came to the FEC, and there have been tweaks since then, but no major rewrites since then. And most notably, we have not done anything about our coordination rules since super PACs were created. And plainly, these rules were not designed to withstand the pressure of this kind of outside spending. So, as I said, $14.4 billion in the 2020 election. Open Secrets is projecting that this year, $9.3 billion will be spent on the election. And that is 50%, almost 50% more than was spent in the presidential election as recently as 2016. 2016, we spent $6.5 billion on the presidential election. It's always more money in the presidential than in the midterms. 2018 was a mere $5.7 billion. And 2014 was a piker, it was only $3.8 billion, but turnout was really low that year too, which I'll get back to. So there's vast sums of money being spent beyond the imagination, I think, of the folks who wrote the Watergate era laws that entrusted us at the FEC to follow the money, which I actually think was a phrase that was invented by a script writer for the movie All the President's Men. But the philosophy is true. We follow the money was how they figured out what was going on, and it is what we are set up to do. And of course, that's just the money we know about. There is a wealth of what we call dark money, money that is not very well sourced. At least not publicly. I'm pretty sure that the politicians who benefit from this money know where it's coming from, but the public does not. The New York Times recently reported that an electronics manufacturing mogul named Barry Seid gave $1.6 billion to a 501c4 called the Marble Freedom Trust, which is run by Leonard Leo of the Federalist Society fame. He's no longer with the Federalist Society, but he was formerly associated with that, and he's moved on to other projects. And I'm pretty sure that some of that $1.6 billion is going to end up finding its way into our politics. And the only way we know about this guy, who I literally had never heard of before. I mean, I have some sense of who the big donors are out there, but I had never heard of this guy before. And the only reason anybody knows about him really is because of two intrepid reporters at the New York Times. And Open Secrets has estimated there was about $1 billion in dark money in the first decade after Citizens United. This guy gave $1.6 billion all by himself, very cleverly through, his lawyers got about $1 million out of this. And I have to say, it was very cleverly lawyered because he gave stock in a company that was on the verge of being sold. The deal was already in the works. And because he gave it to a 501c4, none of it got taxed. And then they ended up, after the deal closed, with $1.6 billion to spend. So, where does that money going to accomplish, and what races is it going to find its way into? And will we even know that that is the source of the money when it does get spent? These are all very much open questions. Shortly after Citizens United, in 2010, a poll found that Americans overwhelmingly disapproved of this decision by 80% margins. More recent polls have shown that 77% of Americans say there should be limits on the amount of money individuals and groups can spend on campaigns. An August 2019 poll by NBC News and the Wall Street Journal found that 70% of Americans feel angry because our political system seems to only be working for the insiders with money and power. Another poll found that ending the culture of corruption in Washington was a top issue for 75% of voters contacted. And recently, I don't have the exact statistic, but this issue of money and corruption came up as a top issue for voters in this election, which The conventional wisdom in Washington is that voters don't really care about this issue. But I think voters really, it's reaching the point where voters feel like they can't ignore it anymore, and they're getting increasingly upset about it. And I should say that dark money is a bipartisan issue, which maybe gives us some hope that we might be able to someday address it, because for a while it seemed like the Republicans had more of the dark money, but in the last election, the Democrats won the dark money race, and with so much that it really caught the Republicans' attention. The Disclose Act, for example, which would try and address some of the holes in our disclosure system, is co-sponsored by Lindsey Graham, among others. But so maybe there is some hope for bipartisan support at some indefinite point in the future. I'm not going to say that's going to happen soon. One issue that I have been extremely concerned about over the past number of years is the prospect of foreign interference in our elections. We just recently heard that the Russians are at it again, and now the Chinese are getting into the act. We know that in 2016, as it said in the Mueller report, the Russian government interfered in the 2016 presidential election in sweeping and systematic fashion. And the goal is chaos. The goal is undermining democracy and our faith in democracy. The Russian chess grandmaster and human rights activist Garry Kasparov has been quoted saying, "The point of modern propaganda isn't only to misinform or push an agenda, it is to exhaust your critical thinking, to annihilate truth." And it's in this era of alternate facts, where it seems like half the country believes an entirely different reality from the other half of the country, this is increasingly an alarming reality. In 2019, I testified before the House Subcommittee on National Security of the House Committee on Oversight and Reform on the topic of protecting the nation's election infrastructure from cybersecurity threats and disinformation campaigns. But as I told them then, I've devoted my career to working to protect the integrity of our democracy, and I have not witnessed a graver danger to our political system than what was then the threat posed by foreign adversaries set on interfering with US elections, not just with hacking, but with undermining our faith in our democracy. That's the real infrastructure that is at stake here, is our faith in our democracy. The system doesn't work without trust, without faith that the results are going to be accurate, and that if you lose today, you can win in the next election. And I am really worried that we are barreling towards a day where no matter who wins, the other side is not going to accept the results. I mean, we saw what happened on January 6th. I hope that was an outlier. I hope it is never repeated again, but I can't really, I don't think any of us can guarantee it. I want to move to a quote from one of my heroes, John Lewis, late great John Lewis said, "Democracy is not a state, it is an act. And each generation must do its part to help build what we call the beloved community, a nation and world society at peace with itself." He said, "The vote is the most powerful nonviolent change agent you have in a democratic society. You must use it because it is not guaranteed. You can lose it." This was from his posthumous op-ed. This was the advice, the urgent message that he left us to be published after his death. This is what he wanted us to remember. In 2020, we had extraordinary, for this country, voter turnout of over 66% in the middle of a pandemic. It was an extraordinary effort by election workers across the country. I take no credit for this. The FEC does not run elections, but state and local officials across the country rose to the challenge and figured out innovative ways for people to vote. And unfortunately, some people found that frightening. And there have been a rash of laws since then to try and restrict on people's ability to vote. This topic came up a little bit earlier today, the difference between people who want to make voting really accessible, I put me in that camp, and those who think that if you make it too accessible, people are going to cheat. There is, we're lawyers, we rely on evidence. There is no evidence of any kind of massive voter fraud out there. It has happened. I'm not saying it's never happened. There was that race in North Carolina that they had to rerun, but it is extraordinarily rare. And for laws to be imposed to make it harder for people to vote in order to address a chimera, a conspiracy theory about corruption and voter fraud is really disturbing. As I said, in 2020, we had this great turnout, but that was unprecedented. And it was particularly amazing because it was during the pandemic, but we don't have great voter turnout in this country. Go to Australia. They know how to turn out for election. They have mandatory voting there, and they have something like 95% registration, and over 90% of the population actually turns out and votes. It is unbelievable. But we're not that unusual amongst a lot of other democracies in having voter turnout rates that are more like in the 60s. And it is there are real differences by generations. So. In 2018, that was a big turnout year for a midterm. It was the biggest midterm turnout in 70 years, I think. And in that election, only about half the population actually turned out to vote, despite the fact that it was considered a huge turnout. And of that, half of the population who turned out to vote. And sorry, I misspoke. That was the highest midterm turnout in over 100 years, since 1914. But people over the age of 65, 66% of them turned out and vote. In the 18 to 29 range, only 36% turned out to vote. And that is not unusual. If you go back to 2014, which was a really low turnout, that was the lowest turnout in 70 years. Only 36% of the people who could have voted actually bothered to vote, which is really shocking to me. I mean, I live in Maryland. Really, we don't have that many truly exciting races in Maryland. We had a hotly contested primary race for county executive recently in my county, but it's not like living in New Hampshire or Pennsylvania or any number of states that I could name. But I turned out to vote anyway. I can't imagine only 36% of the country turning out to vote. And yet that's what happened in 2014. And of that, included in that 36% was only 20% of 18 to 29-year-olds turned out and voted, which I think is really kind of mind-blowing. As I look around the room, I see, some professors as well as some students, and I know there are students listening online, and probably the students who are listening, only the people who turn into this conference are election law geeks. So, you guys probably all vote, but you need to talk to your friends, because this is like the best okay boomer moment you could have. Show all of us boomers that you can turn out and take over, because we need the energy and the passion of the younger generation to take over and take control of your future and the country's future. You wouldn't let your grandparents choose your clothing or your music or your romantic partners. Do not let them choose the government leaders who are going to set in place the policies that are going to dominate your lives. In 2019, we lost another great man, Elijah Cummings, representative from my home state of Maryland and a longtime civil rights icon. And he said in his last year of life, he knew he was dying. He had cancer, and he was still coming to work and doing his best for the country every single day that he could. He said, when we're dancing with the angels, the question will be asked in 2019, or let's say in 2022, what did we do to make sure we kept our democracy intact? Did we stand on the sidelines and say nothing? I do not want that to be my legacy. Don't let it be yours.
Well, thank you very much. I'd like to start by asking you. This
Have to
is
sit down and
oh,
make this
please,
perfect.
absolutely. My layperson's understanding is that the Federal Election Commission right now is not highly functional, and that there isn't a lot it can do about some of the problems that you described. First question is that true? And maybe could you elaborate a little bit on some of the problems that the commission faces?
Yes. Okay, is this on? Yeah, okay, good. So some people say the commission was designed to be dysfunctional. It is a 6-person body and 3 Democrats and 3 Republicans. By law, no more than 3 can be of any one political party. So some people say, well, it was just designed to split all the time and get nothing done. I think it was designed to compromise. I think that is the lost art of compromise. When I started at the FEC, I've been there for a while, there was actually a general understanding amongst all the commissioners that our job was to find 4 votes. We need 4 votes to do most things. And that was our job, was to figure out where 4 commissioners find some space in the middle. Maybe not everybody would love the outcome, but they could live with it in order to provide guidance to people who are trying to comply with the law. It's really important to have clear rules so that people don't trip over them and accidentally violate the law. And, you know, we actually got a lot done back then. And I think we still could if we had that commitment to finding the 4 votes. Problem is that as Washington has become more polarized and the country has become more polarized, the FEC is in some ways was a canary in the coal. Because if you're going to see polarization play out anywhere, it's going to be an unevenly divided body. Now you're getting, of course, you're getting my perspective here. If you had one of my colleagues, they would probably tell you a very different story, but you know, UNH invited me, so you get my version. One of my Republican colleagues is speaking at William and Mary today. I'm sure they're getting an entirely different story. The Republicans realized that all they had to do, since they never really liked these laws to begin with, and they have sort of a deregulatory mindset and don't like government doing much of anything, and particularly in this field, they realized that all they had to do was just consistently vote no. And there really would not be a whole lot that we could do about that. So if they gave up on trying to find 4 votes and just said, no, we get what we want, why should we try and find 4 votes? We get what we want if we just vote no and ignore you guys. So that's been an increasing problem, I think, over the last 12 years or so. Now, you know, there's been some turnover on the commission, and maybe there's the prospects for making some deals. I think I have to watch very carefully to see what kind of deals are possible, because some deals aren't worth having. You know, if they're not going to actually improve the law, then to make a deal just to have a deal is not something that I'm probably going to be terribly. But you know, I think it's fairly early days with a new group of commissioners. Other than me, obviously, I'm not a new commissioner, but I have a lot of relatively recent colleagues. Get some more done.
Well, good. I was actually going to follow up by saying, and yet you stay. Should that be giving us some hope? And it sounds like, you know, from what you're saying, that you do still have hope of improvement there.
I am a basically optimistic person. I believe in fighting hard for what I believe in, but I always like to think that there is hope, that there is the possibility for change, that there's the possibility for growth, and for people to work together for the betterment of the country. I think the work that we do is incredibly important. I think it is vitally important that the American people actually do know where this money is coming from, that is influencing every single decision. This is not an arcane topic, campaign finance. I guarantee you that it affects every single policy issue that is out there, whether you care about guns, whether you care about reproductive freedom, whether you're on either side of the issue, whatever the issue is that you care about, I guarantee you that money has a role to play in what happens. That these very big donors, there are very few people in Congress who are not going to return their phone call when they call. And, it's great that there are a lot of small donors, but you can't get a member of Congress on the phone if you're a $25 donor and you're a regular constituent, unless you happen to know the person somehow. I mean, I actually do know my member of Congress, but, who lives in my neighborhood. No, actually, my senator lives in my neighborhood. My member of Congress lives a little bit further away, but I know them both. But that's because I'm in, public life. Most people don't. And even I couldn't, call up my senator or my congressman and assume that I would be able to get them on the phone. But I can tell you that, these big donors, these billionaire donors, they can get pretty much anybody they want on the phone. And, the rich aren't like you and me. They have different concerns. They're worried about the marginal tax rate for millionaires, and what are the rules on hedge fund incomes. And they're not worried about how they're going to put food on the table, or how their kids are going to be educated, or whether they'll be able to get adequate health care. That those concerns don't affect them, but they affect the rest of us. And we want a government that is responsive to the needs of the entire population, and not just the people at the upper income strata, I think.
Thank you. I think it's fair to say, I just say this as a member of society. I think across the spectrum, there's a widespread sense that things need to change, that we need reform, we need change, and obviously there are really different ideas about that. But one problem is that the Constitution, as it's been interpreted, presents all sorts of barriers to change. Some people, and I'm not saying this would be a good idea or a bad idea, but some people would like to experiment with term limits, but the Supreme Court has said the Constitution doesn't allow that. Some people would like to see.
You mean for members of Congress, not for Supreme Court justices?
That's right, exactly, yes.
That's another idea.
Some people would like to see the courts get involved in partisan gerrymandering and see some of the standards that were developed in litigation that were rejected by the court used to try to bring about some change there. But again, at least the federal courts can't be involved in those claims, the Supreme Court has said. And then, of course, the First Amendment stands as a barrier to efforts to regulate in the area that you were talking about, the money river that flows through politics. Despite those barriers, do you see room under our Constitution for change and reform that could make a real difference?
I do. And let me say at the outset that I don't agree with the Supreme Court jurisprudence on the First Amendment and money in politics. I don't believe that corporations are just like human beings, and I don't believe that money is speech. But, I'm kind of stuck with, I recognize where I stand in the pecking order, and it is not above Supreme Court justices. So yes, we're stuck with the jurisprudence that we've got. Let me take a slight detour. It is not the only way that one could preserve free speech. If one looks north to Canada, when they were presented with similar questions to the ones that were presented to our Supreme Court about whether one wanted to allow for expenditure limits, for example, which were struck down that was one of the Watergate reforms that was struck down by the Supreme Court. In Canada, they said, well, if you allow the wealthy people to dominate the discourse so that other voices end up getting drowned out, then the voters are deprived of the opportunity to make a fair and informed choice. So in order to protect the voters' rights, in order to protect free speech and free choice in Canada, which are our goals too, right? In Canada, they said the way to do that is to have expenditure limits. And our Supreme Court said the way to have that is to have no expenditure limits. So, we should continue to remember that there's more than one way to think about these issues. Having said that, given where we are, I think the most important thing that actually is likely to get done, fingers crossed, and I believe would be upheld by the Supreme Court, is reform of the Electoral Count Act. I am nervous about even mentioning those words with Ned Foley in the room because he knows so much more about it than I do. But that there does seem to be movement on that in Congress, and I think it may not be perfect, it may not solve every problem, but it will help to prevent the kind of mayhem that some people were trying to cause in the 2020 election. So I think that is huge and important. Now, some of the issues that you raised are issues where the courts have said they're not going to get involved, but that doesn't mean that Congress can't get involved or that states can't get involved. So, there's a really good bill, the Freedom to Vote Act, that it hasn't made its way through Congress. This was the Manchin compromise. After H.R. 1, the voluminous bill that tried to solve every single problem in election law and campaign finance went down, Joe Manchin came up with a more streamlined version, and it had a lot of it still has a lot of great features in there, things that would make uniform and accessible voter registration across the country. It deals with voter IDs. There was a question in the earlier panel, and deals with them in a way that would make it easy for people, not as a barrier. People would have to have some form of ID, but it's not extraordinarily restrictive, so that more people would be able to establish that they had the right to vote. There are money in politics provisions in there. There are gerrymandering provisions in there that could affect the entire nation. And the Constitution, we always focus on the part that says time, place, and manner of elections goes to the states, but there's another clause. There's another clause there that says, but Congress can also regulate in this area. And, Manchin thought he could get the votes for it, and it didn't work last time. But if it did work, I think a lot of that, I can't guarantee that all of it would be upheld. There's also the John Lewis Act that is sort of a companion piece to that to try and fix the Voting Rights Act. Since the Shelby decision, when the Supreme Court struck it down, they didn't say then that you couldn't have a Voting Rights Act, just that Voting Rights Act was relying on outdated principles. And they kind of invited Congress, knowing that it was going to be extremely difficult to accomplish, to try and fix the problem. Given what's on the agenda for the court this term, I'm not 100% convinced that they would uphold any fix for the Voting Rights Act. I just don't know. It's sad, but I think that might be reality. But there's also work that can be done at the state level. A few years ago, a young woman in Michigan named Katie posted on Facebook, is anybody upset about this gerrymandered redistricting system that we've got? It really bugs me. And she started to get this overwhelming response. And she had no real background in political organizing. And she just decided, well, all these people are interested, let's see what we can do with them, and organized an entire movement in Michigan that resulted in a ballot initiative being placed before the voters of Michigan, and they changed the way they do redistricting. And that all started with one person. Never tell me that one person cannot make a difference. I totally believe they can, and Katie Fahey is a great example of that. There's part of the Freedom to Vote Act includes some campaign finance provisions like the Disclose Act and the Honest Ads Act that would improve disclosure and would expand some of our laws to cover the internet, which is a big, kind of open area, because when they wrote these laws, there wasn't an internet. So of course it's not included in laws that were written in the 1970s. I would hope that the Supreme Court would uphold those. It has so far been pretty strong on disclosure. There's the AFP v. Bonta decision that out of California that involved a charity, not a political group. The government was collecting a lot of data and then not actually doing anything with it, and then they had a leak of the data. So the facts were really bad there. I am cautiously optimistic that disclosure would still get upheld. And the entire structure of super PACs is based on this theory that they're going to be independent of the candidates, and that's why it's not corrupting. I mean, it is still law, as they said in Buckley, that there's an inherent risk of corruption when candidates themselves accept unlimited contributions. And right now, the contribution limit for candidates is $2,900. So It's always struck me as weird that you could say, well, if you give $3,000 to a candidate, that's corrupting. If you give $3 million to a super PAC that's doing nothing but trying to elect that same candidate, that can't possibly be corrupting. That makes sense to anybody? That has never made sense to me. And as I said, our coordination rules are pretty porous at this point. I think that either by statute or regulation, we could tighten up on those, and those should survive Supreme Court scrutiny, because they basically said that was the premise, that it was going to be independent. So, yeah, I think there's stuff that could be done. Can we solve all? And also we could tighten up the rules on corporate spending to the extent that there could be some kind of foreign influence on the corporations. I worry a lot about that. I proposed a rule at the FEC saying, okay, let's just look at corporations that are 100% owned by foreign governments. Could we agree, even if they're domestically incorporated, could we agree that those corporations should not be spending money in US politics? And I could not get 4 votes for that, which really kind of blew my mind. But I continue to hope that, I think there's room there to, some of that is in the Freedom to Vote Act and in the latest iteration of the Disclose Act. And I continue to hope that, we might see the light on that issue.
Thank you. I'm going to open it up and bring the mic around for questions from the audience.
Uh-oh, Ned's got a question. Don't ask me about the electoral count either, Ned, you know more than I do.
I don't know if I can get.
Thanks. You mentioned small dollar donations and grassroots funding, and if I heard you correctly, I sort of thought that was a good part of the system, and that used to be my view. I don't know if you saw the Tim Miller piece in the New York Times yesterday. Interesting, I thought, well-written op-ed on this point, but a bunch of people are, and you also talked about polarization and how that's a real problem in American society. I 100% agree with that. And I think it's fair to say there's a growing view among some scholars that it is small dollar grassroots money that is exacerbating polarization, insofar as the biggest recipients of small dollar contributions, if I'm accurate, tend to be at the ideological fringes of our spectrum, and when you combine the impact of that and the way we structure primary elections, there's multiple parts to our system that contributes to polarization. But is it accurate to think that although that was an idealistic reform to level the playing field, would it be better to think about within the confines of Citizens United, et cetera, to think about ways to channel money to more institutional actors like the political parties themselves, as opposed to candidates who the parties themselves may think of as, exacerbating governance problems because they're the more anti-government fringe or the anti-compromise fringe of their own parties. So, thank you.
I think that's a totally legitimate concern. I'm going to look for that piece in yesterday's New York Times. I was enjoying fall in New England yesterday, and I did not even read the newspaper. It's certainly true that small dollar donations, 2 of the top recipients of small dollar donations in Congress today are Marjorie Taylor Greene and Alexandria Ocasio-Cortez. So Donald Trump and Bernie Sanders both had a big small donor base. And I think that it is a fair concern. I think that for all that people complain about the fact that the parties have lost power vis-a-vis super PACs, I think that is somewhat exaggerated. It's not that it's not a concern, but I think it is somewhat exaggerated, particularly because there are huge super PACs that are associated with the party leadership that are spending money in the elections of their choice. So it's not true that these guys are without resources to compete against the super PACs. They're actually in the super PAC game, again, in part due to our porous rules on coordination. Congress a few years ago increased dramatically the amount of money that could be raised as long as it went into particular pockets. So they've got, their building fund and their recount fund and their convention fund, they've got all these separate pockets where they can raise 10 times the amount of money that they could otherwise raise. And the joint fundraising committees raise astronomical amounts of money. This is when you get a candidate and then in comes, say, a national candidate for the presidency, runs a fundraiser in combination with every state party organization. And they say they're going to divvy up all this money at the end of the day, and so it won't bust any contribution limits because every state party will get so much money. And even if one donor is giving hundreds of thousands of dollars, and that is what is happening, it's being divided up so the contribution limits aren't busted. But then what is happening in real life is it touches the bank account of the state party committee for about 30 seconds and then immediately gets sent back to the national party committee. So it turns into a multiple $100,000 donation from individual donors to the national parties, which they use for president, usually in the president. So there are, unfortunately, a lot of ways that people are circumventing the contribution limits. As a result, there's a lot of resources out there to be had. I think, honestly, and I suspect you may not disagree with me on this, that the better way of addressing polarization is gerrymandering reform. I think that this is a huge, huge issue. I can't remember whether it was Nate Silver or Nate Cohn. One of the Nates from the New York Times said, "This is the fairest map we've seen in a really long time." And by fair, what he meant was it is actually equally unfair. It's sort of equally gerrymandered on both sides. So there's roughly an equal number of locked-in districts across the country. But that just means that there are more and more people whose votes don't really matter. And there are more and more people who only have to cater to their base in their own party and don't have to worry about anybody else, anybody in the middle. And it is heartbreaking because there are issues on which Americans actually agree. There is common ground on a lot of the big issues confronting the country, but you can't get people in Congress to actually do anything about it because this side is only worried about their base and that side is only worried about their base. And so what you end up with is a bunch of people in Congress who cannot work together. There's nobody in the middle to talk to each other. So I'm not completely unsympathetic to the point of view that, small donors can be a driver of polarization, but I think maybe there are other ways of addressing it. What's what are you going to do other than that? So what's the alternative? Is it better to have the billionaires running the show? Money's got to come from somewhere.
We have time, I think, for one more question.
I wonder if you could talk about what I think is an unintended consequence about all this money in keeping people from being candidates and running for office.
Oh, I think that is almost certainly true. I mean, I can't imagine why would you want a job like that where you have to spend literally hours every day calling people up and begging them for money. That just sounds like a dreadful job to me. I can well imagine why somebody would want to be a government official setting policies and making laws, but to have to spend half of your life borrowing money from people and then to be subject to the completely insane scrutiny that every candidate, the microscope that you get put under. And, okay, some people, they deserve a little scrutiny, but, often what happens is not just the big scandals, the things that people really need to know about, but little things that get blown way out of proportion. And I mean, who among us would want to have their lives picked over like that with a fine-tooth comb by really unfriendly people who are then willing to blast every rumor that they hear about you all over the internet? We haven't talked about the internet at all either, and that also has been we had such high hopes that this was going to be a great way of democratizing campaign finance because it would be so much cheaper to convey, to get your message out on the internet. But it's also become a place where there's rampant misinformation and cruelty and yet another reason that good people would be discouraged. I mean, if we had a better, I would support a more robust public funding system that might make people of good faith and integrity might say, okay, I don't want to spend my days trading favors and begging for money in ways that people will think I'm trading favors with them. But if I could do it another way, if I could get the funds I need through some more ethical path, then maybe I would run. I didn't mention the democracy vouchers program from Seattle is another really innovative way of shaking up the system from the grassroots, and it's another good example of experimentation being done at the state and local level. In Seattle, they started this where Seattle citizens get four $25 vouchers to give to candidates for local office, for municipal office. And the interesting thing about this is it changes the dynamics of the incentive structure for what you need to do as a candidate. As a candidate, normally your incentives are to talk to people who you think will vote for you or people who you think will give you money, and that's it. And then there are communities where they don't turn out to vote, they don't have a lot of money, and there's no real incentive for candidates to go there. But with democracy vouchers, there's an incentive to reach out to every single citizen and try and find something to appeal to every single citizen. And, so I think there are ways that we could encourage people to want to run for office again, and that would also be improvements in our campaign finances.
Everyone, please join me in thanking Commissioner Weintraub. Welcome back, everyone. I'm very pleased to begin the second half of our symposium here at the University of New Hampshire Franklin Pierce School of Law. Our next panel focuses on what I refer to as post-election controversies, broadly speaking, and I'm very excited for our two presenters here, two scholars who I've admired greatly for many years. Our first presenter is Joel K. Goldstein. He's been a teacher and scholar of the American presidency, the vice presidency, and constitutional law for more than a quarter century. He is best known for his work on the vice presidency, including two books, The Modern American Vice Presidency, The Transformation of a Political Institution, and The White House Vice Presidency, The Path to Significance, Mondale to Biden, and many articles and chapters. He has co-authored a constitutional law casebook and numerous articles regarding constitutional interpretation, the Supreme Court, its justices, presidential succession, and inability. He is the Vincent C. Immel Professor of Law Emeritus at St. Louis University School of Law, where he taught from 1994 to 2019 before retiring. He is working on a political biography on former Senator and Secretary of State Edmund S. Muskie, and he works about the vice presidency. He's also working on other works for presidential succession, inability, and constitutional law. Professor Goldstein was born in St. Louis, Missouri, received his formal education in the public schools of University City, Missouri, and he also received his bachelor's degree from Princeton University, a bachelor's and a doctorate from Oxford University, and his law degree from Harvard Law School. Our second presenter is Professor Derek Muller. He is the Ben V. Willey Professor of Excellence and Professor of Law at the University of Iowa College of Law. And he is a nationally recognized scholar in the field of election law. His research focuses on the roles of states in the administration of federal elections, the constitutional contours of voting rights and election administration, the limits of judicial power in the domain of elections, and the Electoral College. He has published more than 24 academic works, and his op-eds have appeared in the New York Times, the Los Angeles Times, the Wall Street Journal, among others. He has testified before Congress. He has authored federal courts casebooks, which is published by Carolina Academic Press. At Iowa, Professor Muller teaches election law, federal courts, civil procedure, and evidence. In 2021, his second year teaching at Iowa, Professor Muller was selected by students as Professor of the Year. And so without further ado, I'll turn it over to Professor Goldstein to get things started. Yes, thank you.
Kyle, thank you very much, and thanks for including me in this really very rich discussion, and it's a pleasure to be up here with Derek Muller, who really is one of the experts in this area. The 12th Amendment provides in part that once presidential electors have transmitted their sealed and certified electoral votes to the President of the Senate, who of course is either the Vice President or the Senate President pro tempore, quote, "The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates and the votes shall then be counted." That counting clause is among the Constitution's flyover provisions. A few scholars have examined it, not too kindly. Congress applies it every 4 years, then it's forgotten. It's not taught, it's not read, it's not known. January 6, 2021 changed that. President Donald Trump's and Vice President Mike Pence's differing interpretations of this obscure 27-word constitutional text led to the most dramatic president-vice president rupture in American history. Pence had once praised Trump 14 times in less than 3 minutes, once every 12 and a half seconds. Try doing that sometimes. Now Trump trashed Pence to Trump supporters, and an angry mob invaded the Capitol building, with some advocating Pence's violent demise. Once it became clear that other roads to a second presidential term were foreclosed, Trump demanded privately and publicly that Pence use his role as President of the Senate during the electoral vote count to reject or defer submitting electoral votes for former Vice President Joe Biden to prevent Biden's election and to allow Trump to retain power. Trump claimed that Pence had constitutional power under the counting clause to do so. Trump's strategy was unprecedented, audacious, illegal, and unconstitutional, and Pence refused to cooperate. Congress appears moving towards legislating on counting electoral votes and to reconfirm in part the limited ministerial role of the President of the Senate in the process. Further clarity in law is a virtue, but the limited role of the President of the Senate was evident before January 6, 2021. The Trump-Pence drama wasn't the only or the main reason to criticize a public official that day, but this constitutional issue merits attention because the clause addresses how we determine who's been elected president and vice president, and it raises interesting issues about constitutional interpretation as it often occurs outside of the courts. And it suggests that constitutional change can add not simply new textual arguments, but can alter structural constitutional arguments as well. So I want to argue that although the textual and the historical arguments suggest that the vice president or president of the Senate has a ministerial role in the electoral vote count, that the structural arguments powerfully do as well, and that they have become stronger due to other constitutional changes that have taken place in many of our lifetime. In essence, Congress met on January 6 under the 12th Amendment and the Electoral Count Act of 1887, which provides procedures to govern counting electoral votes. There are problems with the Electoral Count Act, but its basic premise is that when states submit a single set of properly certified electoral votes, they should be counted unless they are not, quote, regularly given, essentially if the electors violated some constitutional requirement. The President of the Senate, who the Electoral Count Act makes the presiding officer, proceeds through the states alphabetically and takes objection as each state's certificates are opened. Objections must be written and signed by at least one member of each house. If objection is made, the houses separate for up to 2 hours to separately debate, and then each house votes. The state's certified electoral votes are counted unless both houses vote not to count them. Trump's congressional allies had committed to challenge Biden's electors from various states, ostensibly under the Electoral Count Act, but it became clear that those challenges would fail, since almost all Republican senators and all Democratic senators agreed that Biden had won, as did all House Democrats and many Republicans. The challenge under Electoral Count Act was going to lose. So Trump adopted a different Pence-focused strategy. Instead of the Electoral Count Act process, Trump implored Pence to override it.
Trump sometimes claimed that Pence, as president of the Senate, had unilateral power to reject certified Biden electoral votes from certain states, which would lead to Trump's election. When Pence refused, he asked Pence to send the certificates in several Biden states back to the states for further consideration, a move that would have violated multiple provisions of the Electoral Count Act and the Constitution. Since most of the contested states had Republican-controlled state legislatures, Trump apparently hoped that this send-them-back strategy would cause enough state legislatures to certify his electors in those states to allow their recognition instead of Biden's. Both strategies rested on Trump's position that Pence had unilateral constitutional power to reject Biden's electors and that the 134-year-old Electoral Count Act was unconstitutional and non-binding. Now, the counting clause has been criticized as ambiguous. The clause doesn't state who exercises the power conferred, who counts. Surely it would make things easier if the text specified a counter, but its failure to do so doesn't mean that its meaning is mysterious or make all interpretations equal. The Constitution often isn't explicit, yet even imprecise text can signal an answer. It seems telling that the clause specifically designates the President of the Senate as the recipient of the certificates and states that the President of the Senate shall, in the presence of the Senate House of Representatives, open all the certificates, but then it pivots to the passive voice, and the votes shall then be counted. If the Constitution meant the President of the Senate to count, it could have said so, but it didn't. Of course, it doesn't say that the House and Senate count, but why else are they there? Not simply as witnesses, which a few members, not the entire legislative body, could have provided, and not to perform the contingent election, because that only requires the presence after the count determines that no one has a majority. The two institutions are present so they can act institutionally regarding the opening and the count. Those who think that the President of the Senate is the counter find his or her role implicit in the grant of the duty to open the certificates. But we don't typically infer a robust power, like deciding which votes count, from the grant of a modest one, like opening the certificates. And it's easy to imagine examples where an opener doesn't implicitly get a follow-up function. From the provision, quote, "Dad shall open the refrigerator in the presence of his family," no one would infer that the follow-up clause, "and the food shall then be eaten," made Dad the sole eater. The text isn't a slam dunk, but the better textual argument points away from the President of the Senate as the counter. But when the text isn't specific, we look for other clues to its meaning, including history, both original and ongoing history or practice. Start with practice. For most of our history, Congress and the Senate's president have assumed that Congress has some limited power to decide what votes count. That's certainly true since the Electoral Count Act passed in 1887. It has governed the last 135 years and 58% of the presidential electoral counts. It's also true during most of the 19th century when Congress used various means to consider whether certain votes should count because, for instance, they were cast for a dead man or from a state that hadn't technically become part of the Union, or by an elector who may have held a federal office or voted for two people from his home state. The earlier an American's past one goes, the harder it is to figure out what happened. The available earlier records are incredibly cryptic. But beginning in 1793, they state that the two houses appointed tellers, quote, "who ascertained and examined the ballots and made a list of the votes which the President of the Senate then read." That sounds like the tellers did the counting, which might suggest the practice was grandfathered when the 12th Amendment was ratified in 1804. In 1797 and 1801, there could have been controversies over one state's electoral votes that would have affected the outcome. But no one objected to the votes, the tellers included them, and the President of the Senate announced them. Some argue that the Vice Presidents Adams or Jefferson counted votes which benefited them, but it's not clear from the available evidence that they did anything more than read the tally the tellers prepared, to which no one had objected. When text isn't specific, we should interpret the Constitution to reflect basic constitutional ideals. However you think such arguments cut in the past, changes in the constitutional nature of the vice presidency now point even more strongly against giving the vice president more than a ministerial role in counting electoral votes. Consider these 3 points. First, vice presidents will almost always preside over the electoral count in the future. Vice presidents have presided over 37 of the 59 electoral vote counts, or 63%, and over 87% of them since 1905, which is the last 50% of our elections. But formal constitutional changes will increase that percentage. President pro tempores usually preside because of a vice presidential vacancy. But the ratification of the 25th Amendment in 1967, which includes a provision to fill a vice presidential vacancy before the next election, now means that the vice presidency will rarely be vacant. Before the 25th Amendment, the vice presidency was vacant 21% of the time. Since then, less than 1% of the time, although that's not the only reason for that change. Second, unlike the vice presidency in 1789 or 1804, the vice presidency now is an integral part of the executive branch, closely associated with the president. By contrast, early vice presidents, through Alvin Barkley, who was Harry Truman's vice president from 1949 to 1953, those vice presidents were legislative officers. They regularly presided over the Senate. They were also politically independent of the president. Due to other changes in American government and politics, the vice presidency moved into the executive branch with the Richard Nixon vice presidency from 1953 to 61, and into the White House with the vice presidency of Walter Mondale from 1977 to 1981. They became close presidential advisors and troubleshooters. Those changes have persisted and become entrenched. But the changes are not simply a matter of institutional evolution, although repeated practice has its own constitutional force. They also reflect a new constitutional vision of the vice presidency, which is reflected in the 25th Amendment to the Constitution. The 25th Amendment, which allowed the president to nominate a new vice president, provided simple procedures to transfer temporarily presidential power to the vice president when the president is unable, and to act with the president's cabinet if necessary to declare a president unable, was premised on a new constitutional vision of the vice president as an integral part of the executive branch, as the president's close ally and associate. The discussions and reports surrounding the amendment reflect that vision, as do the provisions themselves. Third, vice presidents will increasingly preside over electoral counts where they are candidates for vice president or president. Vice presidents have run for re-election in 18 of the 59 elections and presided on 15 of those occasions. They have run for president in an additional 8 elections, presiding over 6 of them. Accordingly, vice presidents have been on the ballot for 26 of the 59 elections, presided over 21 electoral vote counts. Those numbers will increase. Only 5 of the 24 vice presidents from 1789 to 1900 ran for a second term, 21%. 13 of 24 from 1901 to 2021, or 54%, did. After Martin Van Buren's election as president in 1836-37, only one vice president, John Breckinridge, received a presidential nomination during the 125 years until Richard Nixon was so nominated in 1960. Since 1960, 4 sitting and 2 former vice presidents have been presidential nominees. The creation of a means to fill a vice presidential vacancy and the greater significance and visibility of the vice presidency makes it likely that future vice presidents will more frequently seek re-election or the presidency. Since 1980, all 7 vice presidents have sought a second term and presided over an electoral vote count in which they had a personal interest. From 1981 to 2021, vice presidents presided over 9 of the electoral counts when they sought either re-election or the presidency. These 3 points strengthen the constitutional structural arguments why vice presidents should not have the significant power regarding the electoral vote count that Trump envisioned. There's a separation of powers problem. Constitutional change makes it likely that vice presidents will almost always perform the president and the Senate role in the electoral vote count. That's a legislative role that envisions independence from the executive branch, Yet the vice president has become an integral executive official. Pence, but not Trump, understood that on January 6th, he was a legislative officer bound by legal duties. The founders rejected a parliamentary system in which the legislature would choose the president, but they also rejected a system in which the executive would self-perpetuate. There's a conflict of interest problem. Vice presidents will routinely be on the ballot as a vice presidential or presidential candidate, yet the Constitution envisions impartiality in counting the votes consistent with the principle that no one should judge his or her own case. And most importantly, it's simply ludicrous to think a democracy committed to the rule of law would give a vice president and a candidate the power that Trump envisioned. Trump's substantive theory regarding Pence's power offended basic constitutional principles implicit in what it means to be a democracy based on the rule of law, one which diffuses power to prevent tyranny and relies on deliberative decision-making. Yet the procedural posture that Trump envisioned was also inconceivable. To do as Trump insisted, Pence would have had to unilaterally declare unconstitutional a 134-year-old statute which had governed the last 33 presidential elections. Then he'd have to take a very aggressive interpretation of his own constitutional power at odds with practice. And notwithstanding the opposition of both houses of Congress, including most Republican senators, act to benefit Trump and himself. I focused on the vice president because he or she is likely to serve as president of the Senate. But the president pro tempore of the Senate presiding isn't an answer if the role envisions significant power to judge electoral votes. That office has its own issues, but such a role is one that should not be entrusted to one individual, not in a democracy based on checks and balances. And in focusing on the vice presidency, I don't mean to suggest that we shouldn't be deeply concerned about congressional misbehavior, especially after what we witnessed in 2021, when congressmen egregiously abused the process. When the role is properly understood as ministerial, vice presidents who perform a ceremonial role after being defeated for president or for re-election, or when their party has lost, can serve a positive function in uniting the country and modeling commitment to the rule of law and democratic process. That was certainly true of Nixon in 1961, and Al Gore in 2001, and Biden in 2017, and Pence in 2021. In 1957, Herbert Brunel, a Republican politician and President Eisenhower's first Attorney General, said, and I quote, "Ultimately, the operation of any constitutional arrangement depends on public opinion and upon the public's possessing a certain sense of what might be called constitutional morality. Absent this feeling of responsibility on the part of the citizenry, there can be no guarantee against usurpation," end quote. Law is important, it's critical, but laws and procedures won't save us if public servants don't subordinate personal and partisan considerations to constitutional principle and law. And they are more likely to honor law if we, the people, practice constitutional morality and praise those who do follow constitutional principle and law and hold transgressors politically accountable. Thank you very much for your attention.
Well, thank you for the kind invitation to participate today. It's been great so far. It's great to be beside Joel, who just knows more about the vice presidency than just about anybody else, and thinking about the Electoral Count and potentially Electoral Count Reform Act coming out of Congress. It's a dynamic time for this area. So I'm going to focus on very much a work in progress, thinking about something, two topics that are top of mind for me. One of them maybe more so than the other, at least in the public's consciousness, election subversion and writs of mandamus. Election subversion has been a topic sort of bandied about over the last 2 years. I can hardly imagine why. But it's also a term, as Professor Lisa Marshall-Manheim has suggested, employed far more often than it has been defined. It's a term that's used kind of for everything. But some scholars, Rick Hasson has suggested it's really sabotage by election officials leading to an election loser being declared the election winner. or Professor Mannheim described it as an attempt to exploit a breakdown in the rule of law to install an otherwise losing candidate into elected office. Or Professor Rick Pildes, the risk in the states of partisan manipulation of vote totals or the refusal to certify election results as potential election subversion. And all of these definitions are really circling around a handful of common traits. They're dealing with concerns about post-election actions by election officials that defy sort of the accepted legal process for tabulating or votes or resolving disputes, ultimately designed to benefit the losing candidate in some way. And so the term has been used for lots of things, been tossed about for partisan gerrymandering, for all kinds of actions, but I want to sort of focus on that, right? Thinking about this risk of subverting the election results, right? We have the results and what happens there. And there are a lot of people very concerned about this. You know, when I testified a couple of months ago in support of the Electoral Count Reform Act, obviously one thing that people are worried about is precisely this scenario, right? The scenario about what do we do when these results get into Congress and there's the risk of not counting them? Or how do we identify what the true counts are from the states? Or what happens if someone in the states refuses to certify the results? And so do we need to come up with sort of new mechanisms to resolve these things? And my suggestion was, and is, maybe there's some hesitation before we inject new mechanisms without recognizing sort of the existing ones that may work very well. And then maybe ways of strengthening those mechanisms as they exist to address this particular concern of election subversion. Now, there are many different ways that election results can be undermined, that election officials might attempt to subvert election results, but that's sort of beyond the scope of this paper, and really focusing instead on a much narrower band of things, right? Thinking about that narrower band of subversion, sort of the refusal to tabulate votes, refusal to certify an election. So part of this is opening, kind of describing what this mechanism, I'm just kind of drilling down on one mechanism known as the writ of mandamus. What is it? What does it do? It's Latin, it's old, right? So it does something, it's been there, but it's useful. And this is part of what academics sometimes miss out on, is like the real lawyering, the kinds of remedies, or the kinds of briefs, or the kinds of things that you're filing in the courts, right? But also not just describing like this is what the real lawyering is, it's also saying, well, what can it be used for, right? To point that it's an effective tool in limited circumstances to prevent election subversion, that it can be used perhaps more broadly than currently conceived if we develop legislation that reduces election officials' discretion in certain places, that makes it easier to apply the writ. And it can be coupled with trade-offs from Congress and directives from Congress that therefore place a federal duty and obligation upon state officers in federal elections, both congressional and presidential elections, and that then require some compliance at the back end through these state courts and state remedial mechanisms. Okay, so mandamus comes from a Latin where we get mandate. It just orders an official to perform mandatory or purely ministerial duties correctly. It traces all the way back to the Magna Carta, where it says, "To no one will we sell, to no one deny or delay the right of justice." So this is an 800-year-old concept, and it comes out of the legal tradition, not the equity tradition. And for those of you who might not be as familiar, or one else who haven't quite gotten there in your civil procedure class yet, the courts of England, right, sort of had this legal track with legal remedies, typically monetary relief, we think of it as damages or looking backward. And then later, the chancellor would sort of develop these opportunities in equity to solve problems where law was inadequate. And you kind of have this two-track system of justice where you could go seek legal remedies or you go seek equitable relief. And the equitable relief was often very flexible. We can declare judgments, we could issue injunctions, order you to do something much more sort of command-based. Whereas the legal remedies were much more sort of the jury declaring your rights and perhaps awarding damages. But mandamus is so old, sort of predates equity, and it's actually one of these legal remedies, and it's flexible and it's broadly applied in a variety of contexts. In fact, when I'm looking up some of the history of it, it extends all the way to, issuing a commission to the organist in a particular parish in the Church of England so that the organist can maintain his job, right? I mean, it is as that specific. And it's really designed to direct public officers and public officials to comply with the law, to comply with their duties. Now, This does not allow the courts to step in for discretionary functions. To the extent that there's some discretion to be within the exercise of the office, the courts are not going to step in. But to the extent that there is a clear legal duty, a clear legal obligation, so a lot of weight is put on that word clear, right? A clear legal duty, then the courts can step in and order public officials to do something. Famously in the United States, an early Supreme Court case of Marbury versus Madison, where even perhaps the first year law students have bumped into it in con law. It might be a little early in your con law semester, I don't know. In constitutional law, where the notion is that it's the emphatic province of the judiciary to say what the law is, and that if a law passed by Congress is inconsistent with the Constitution, it's unconstitutional, and the court has the power to declare that, all sort of very famous propositions. But most of the case is actually about Bill Marbury, the guy who's supposed to be entitled to his judicial commission. The Secretary of State doesn't get it to him. And it's a new Secretary of State, James Madison, who comes in and refuses to deliver the sheet of paper to him. And so much of this sort of discussion from the Supreme Court is sort of walking through what mandamus looks like in the United States, slogging through the fact that, yes, you're entitled to this commission. Yes, you're entitled to your job. And yes, we can in fact order these officers in the government to hand pieces of paper over to you so that you're able to get your job. Now, at the end of the day, they conclude that this particular statute was unconstitutional, but nevertheless, the principle of mandamus applies very early from the framing. And it's used, right, quite broadly, again, not just thinking about the organist and the parishes and the Church of England 400 years ago, but it's used today in the United States. And it applies widely in election law disputes. I'll sort of mention three examples briefly. First, the writ of mandamus has been used in states when the decision to certify candidate nominations or petitions for ballot access. So in 2004, the Michigan State Board of Canvassers deadlocked 2-2 about whether to certify an initiative petition proposing a definition in the state constitution of what marriage meant. They said two members of the commission believed that the proposed amendment was unconstitutional and therefore was not going to certify the amendment. Goes to the Michigan Court of Appeals. It says, no, you have a clear ministerial obligation to certify this on the ballot. You don't have the discretion to decide what's constitutional or unconstitutional. Michigan State Board of Canvassers in 2021, again, dealing with a question about a ballot initiative, whether enough signatures were gathered for a question of limiting the governor's power during emergency situations. They collected a number of signatures, but the board deadlocked 2-2. Two of the members said, well, we need some more time to investigate these signatures. Michigan Supreme Court unanimously says, no, you don't have this investigative authority absent some sort of specific legal duty. You have to go certify this. And in fact, again, mandamus in Michigan are consistent ones. They just, again, issued a writ of mandamus relating to an abortion-related amendment on the ballot that will be appearing in November. Second, the canvassing of votes is ministerial. That is, when you are tabulating the votes and coming up with a vote total, that is a ministerial act. In Colorado, there was the outcome of a city council election that turned on 47 irregular ballots, and they were trying to figure out whether or not they should judge these write-in ballots to put them in that final tally. And the court said, no. Once these ballots have been counted in some fashion, all we're doing is adding them up, tallying them in the canvas. That is a ministerial act. You're not supposed to go investigate whether or not these were lawful or unlawful votes. Finally, certifying the election or certifying the winner of an election is ministerial. In Ohio, there was a municipal election that turned on whether or not a candidate was eligible to run in the election. They ultimately let him appear on the ballot, but there were some questions about whether or not he should be certified as the winner at the end of the day. And originally, the Secretary of State said, no, we're not going to certify him as the winner because we have questions about his eligibility. Ohio Supreme Court comes in and says, no, you're just declaring the winner. Whoever has the largest total number of votes, that's all we're doing. You're just adding it up and making a declaration. So for all of these sort of matters, these are sort of ministerial tasks. Now, there are some times where there might be discretion granted to election officials in some of these places. One can imagine in a canvass where we're trying to ascertain the intent of the voter, there might be some sort of discretionary function there. But in many of these cases, these are simply ministerial acts that election officers have. So we have this sort of flexible tool that we can use to address the actions of election officials from the courts. Well, so what? That's a court order. And what happens if the election official defies it? Right, that's the next sort of question and step we have. So the common law, we sort of have two readily available remedies. The first is you could attach the property that was at issue, because it was often property that might be at issue, in order to compel compliance. The second is that you could use your contempt power. And I'll come back to that in a moment. Essentially, the court's contempt power to compel compliance. But we have a recent, very vivid example in Otero County, New Mexico this year that sort of highlights the point. They were supposed to, the county commission gathered in June of 2022 to tabulate the votes and certify the election winner. The commissioners had a number of concerns they raised in rather opaque language. And all unanimously said, we're not going to certify the results. And the county attorney warned them there would be consequences. One of them said, and so what? Then they're going to send us to the pokey? At which point a writ of mandamus was filed in the New Mexico Supreme Court, saying essentially this was a ministerial obligation. This is not a discretionary function. Order the county commissioners to do their job. New Mexico Supreme Court did so. And then kind of came out the legal advice to the members of the commission of what happens if they didn't comply. So this is just New Mexico specific, but similar mechanisms apply in other states. One is New Mexico authorized a $250 fine for anyone who disobeyed it. Now, this $250 fine, as far as I can find out, was enacted in 1884. So I don't think it has been updated for purposes of inflation at this point. But so maybe, and also maybe not a sufficient inducement. The second is that you can incarcerate the person until they comply. So that can be a tempting solution for the court, but also sets up a significant power struggle between the court and potentially executive actors, followed by potentially the fact that they'll just wait a few days and maybe wait it out and hope that the election passes and enough chaos has been sown. Third, you can, for those officials, can be removed from office and replaced. In New Mexico, these are county commissioners who also served as sort of year-round commissioners. They weren't just the board of canvassers. And at least two of the commissioners publicly expressed, you know what, we're kind of worried that the governor, who is not of our political party, is going to replace us with people who will serve you all in the indefinite future on a variety of other tasks in ways that we will no longer be able to serve you. That was a sort of sufficient inducement to get them to comply. And finally, New Mexico has a rule of civil procedure known as Rule 70, similar to the federal rules and similar to what most states have, that essentially orders that if it allows a court to direct a party to perform a specific act, and if the party fails to comply, the court may direct the act to be done at the cost of the disobedient party by some other person appointed by the court. So essentially, you can short circuit the election official who is being recalcitrant and simply move down the line to somebody else who, with the court order, will be treated as having done that act in the first place. So again, the so what after the mandamus is what can we do to enforce it? And I think there's a variety of flexible mechanisms there. I'll just very briefly mention then two other things at the federal level, and then I'll get to some of the sort of normative or bigger picture questions. Congress has, in a couple of contexts, created federal obligations on state officers. And this is a contested proposition. On the one hand, in constitutional law, if you're familiar, there's a case called Prince versus the United States, which essentially says that there's an anti-commandeering principle baked into the United States Constitution. Congress typically can't order state officers to do things. The flip side is that, well, this is an election, which is not just a generic sort of thing that happens under the Constitution, but a very specifically delegated sort of source of authority in the states. And Congress has, from a very early period of time, placed obligations on state officers to carry out responsibilities. So one of those is that in Senate elections, and this comes out of Reconstruction and some real concerns about whether or not state legislatures are doing their job in electing senators at the time, was that you have to, as the executive of the state, and has to be countersigned by the Secretary of State, send out a certificate of election for Senate elections. And there have been multiple cases in recent years that have invoked this proposition in Illinois and in Minnesota in 2009 to say, well, you know, the executive officer has failed to sign that certificate of election, please order him to do so. And everyone has sort of accepted that this is something that Congress can place as an obligation upon state election officials to sort of certify the results of the Senate election. The second is in presidential elections, which tracing as far back as 1792, Congress has placed an obligation on the executive of the state to send the results of the election onto Congress. And through a variety of mechanisms, I think this is a constitutionally appropriate exercise of congressional authority. And again, something that can then be enforced in the state courts to the extent that there's a reluctance or a failure to do so. Now, mandamus is not a magic wand that solves all of our problems, right? There are a number of limitations to it. And this is the parts of the paper that I haven't quite built out as much yet. But one of them is to point out that it does not extend to those areas of discretion. So it is a limitation. It needs to be a ministerial duty where there's not some sort of flexibility for the election official. The second is that many states have identified some sticking points about the separation of powers. Sometimes the state Supreme Court said, well, we can order lots of people to do lots of things, but we're very reluctant to order the governor to do anything. Sometimes we're also reluctant to order the legislature to do anything, as sort of a matter of separation of powers. I think this is not as significant a concern when it comes to the federally created obligations for federal elections, because again, the separation of powers concerns dissipate. Once Congress has created a federal duty on the governor, I think no longer are we worried about those potential limitations that state Supreme Courts have. Third, one question I'm going to have to address is how is this any different from sort of generic injunctive relief? That is, we have injunctive relief, which allows you to order officials to do something. How is that any different than mandamus, which allows you to order individuals to do something? And one of my answers, I think, is going to be the fact that in many states, they create jurisdictional hooks for where you can sue and under what circumstances. And typically when you're seeking an injunction for somebody to do or not do something, you have to file in a trial court with then a right of appeal and then going to the state Supreme Court potentially, with potentially multiple layers of review. In many states, they identify the state Supreme Court as being a place of original jurisdiction in certain kinds of disputes involving mandamus and public officers. And that allows you to bypass all the lower court process and go directly to the state Supreme Court, just like they did in New Mexico. And you can have an order from the highest court in your state within 24 hours ordering that state election official to do or not do something. There is a concern that I have about a moral hazard arising with an excessive use of mandamus. That is, if election officials really want to be recalcitrant or hesitant, will they increasingly be incentivized to do so and say, well, listen, we'll just sort it out in the courts. And once the court order comes in, say, well, my hands are tied, I can't do anything else about it. Or say, I'm not going to do it, go order someone else to sign this certificate. I am worried that mandamus potentially increases the risk of election subversion with the outlet of the courts as being the mechanism by which we resolve that. But at the same time, we're sort of in between a rock and a hard place about how we try to ensure that we have election officials comply with the law without sort of incentivizing them to do so. And finally, the paper is going to offer a couple of suggestions to strengthen mandamus. One suggestion is reducing election officials' discretion. That is something no election official ever likes to hear. Election officials like to have the most flexibility and discretion as they can in terms of doing their job, except to the extent that it creates chaos, in which case they want more order and more clarity and more description. But ironically, right, it's a number of laws enacted in the last couple of years. Georgia's Senate Bill 202, for instance, much maligned in a lot of popular media and press in 2021, emphasizes that the State Board of Elections lacks discretion in a number of areas of promulgating emergency rules and regulations. Or Iowa Senate File 413 expressly provides the county commissioner does not possess home rule with respect to the exercise of the powers or duties related to the conduct of elections. And in fact, these laws are constraining local discretion and actually make the writ of mandamus a more effective tool against local or perhaps even statewide officers. And another is finally to provide more clarity for directing other officials to perform the task. I think this is the least intrusive way of resolving these disputes, rather than incarcerate the governor or the Secretary of State. It's probably assurance of the Secretary of State in the room, right? Rather than incarcerate them or fine them, the solution perhaps ought to be in these sorts of egregious situations to simply roll down to somebody else, to have some other person perform the task. Many states have an express provision, much like Rule 70 of the federal rules or a comparable one, and others, I'm still developing the research about what states do or don't have, but others might it might behoove them to have more express provisions to allow that as sort of the least intrusive and most effective way of ensuring that we don't have election subversion. So with that, thank you very much.
Thank you very much, Professors Goldstein and Professor Mueller. Time for questions. Do we have any questions first from participants in the room? Professor Foley.
Joel, I've got one for you that's slightly related. It's related to your topic, but a little bit different. I was very intrigued with your discussion of the 25th Amendment and how that has made the vice presidential office more housed within the executive than the original Constitution, which clearly emphasized the legislative role of the vice president as Senate president. And then you also talked about the pattern of practice that has put the vice president so much more in the White House as an Oval Office advisor. And that strikes me as interesting, not just for the reasons that you specifically mentioned, but this debate that's in our society right now on executive privilege. And one of the things that's been struck by me, who sort of comes at this from the election world, thinking that, whatever conversations that a sitting president and a sitting vice president have concerning the vice president's function under the 12th Amendment is not an Article II function. It's a 12th Amendment function, and the vice president's role is an Article I role. And so even if there is executive privilege attaching to Article II functions, it doesn't attach to any of those conversations. I think that's still correct analytically, but I have to say your account of augmenting the Article II nature of the vice president at least makes me want to think that a little bit more. And I just wonder if you'd want to take the occasion to think about how your analysis affects that issue as well.
I don't think it does, Ned. I think that, if you read the debates on the 25th Amendment, it was clear that the discussion and the premise was that the vice president's part of the executive branch, working with the president, close political ally, taking on all these assignments. It was even the premise before it was actually happening, to the extent that it later began happening with Mondale. But I think that I think that when the vice president acts as the president of the Senate in the electoral count, I think he or she is performing a legislative function. I think the problem is that on the one hand, formally in that particular role, he or she is a legislative actor. In reality, the vice president really is an executive person. He's the president's right-hand person. And so I think there's this dilemma between the practicality and the legality. And so I think that, I'm not an expert on executive privilege, but I had the same thought that when President Trump was talking to Vice President Pence, I don't understand intuitively how that could be protected, because he was talking to him as the president of the Senate, not as the number two person in the executive branch. As the number two person in the executive branch, he had absolutely no power with respect to the Electoral Count Act. Reb Brunel, who's written a lot about the vice presidency, talks about the vice president as a constitutional chameleon who performs different functions, and in this context, I think would be a legislative officer. I don't know if that helps, but
thank you.
Other questions? Any questions online? Would you like to respond?
I have one for Derek, if I may. I wonder if there's any danger that states that sort of are high on sort of election denialism will also weaken their mandamus protection, since I assume that the state legislature has power over the extent and the shape and so forth of the mandamus remedy. Is that a problem, or is that something that we should worry about?
Yeah, it's certainly a risk, although I don't know how many, that might be 6 or 7 steps ahead for a lot of these legislatures to be thinking about. I haven't seen anyone sort of concerned about this for 2024, although it might be that they suffer a mandamus loss and suddenly they want to start trying to figure out how to choke that off. I mean, Ned's written, I know you just stepped out, but thinking about maybe a greater risk of, well, rather than having the executive do these functions, rather than the Secretary of State canvass the votes, we as the legislature are now going to canvass the votes, or we as the legislature are now going to tally it. So Arizona had floated something like that very briefly. So I think that right now there's probably more of the risk of lodging what we might describe as some of these ministerial obligations back in the legislature. But you're right that there is a risk in the future that whether it's through jurisdiction stripping or other kinds of actions, the legislature might do so. Now it hasn't, it's telling to me in states like Pennsylvania and North Carolina that have had these state Supreme Court disputes over partisan gerrymandering, that the states haven't come back and said like, well, we're going to strip you of jurisdiction. That's kind of a nuclear war moment in many states to strip state courts of jurisdiction. And so maybe it's coming in the future, but so far I haven't been seeing that as a concern.
Other questions for our panelists, either in person or from folks online?
Thanks, Kyle. So just taking it one step further, what if the vice president didn't follow through and perform his ministerial role, or what if the mob on January 6th, caused a disruption that prevented that act from taking place? What are the protections in place to regain control of what's going on?
The what ifs are hard. In a lot of conversations leading up to 2020 and probably up to 2024, at some point the law runs out. And at some point you're really dealing with questions of military control or things like that. I mean, under the Constitution, it's sort of pointed out, no matter how long you delay, you get to January 20th, there's a hard stop. And at that point, you have acting President Nancy Pelosi, or acting President Chuck Grassley, or acting President Pat Leahy, which is, I'm not sure exactly what Ted Cruz had in mind when he proposed objecting and delaying the certification, right? But there's like a hard constitutional cutoff at that point. Had the vice president sort of indulged some of these concerns, I think the recognition is in the joint session, there would have been a movement to overturn the ruling of the chair and just sort of proceed. An alternative would have been a prompt impeachment of the vice president at that moment from the House of Representatives, a trial by the Senate, and sort of move on. Again, these are sort of fantastic scenarios, right? In sort of the most realistic scenario where Pence, and we were discussing this over lunch a little bit, where Vice President Mike Pence sort of says, well, I have this other sheet of paper from Arizona. Why don't you all sort it out? This set of electors that says they were for Donald Trump. There would have been 2 hours of debate and the chambers would have voted, and both chambers would have voted that the Biden electors were the legitimate electors and they would have moved on. So there's so many ways to sort of spin out the hypotheticals. But I think all of them end with a presidential term that ends on January 20th and some other dispute resolution mechanism happening in that sort of 2-week period before we get to that point.
And the fact that you had so many Republican senators who followed Senator McConnell's lead and saying that the election was over, Biden had won, I think probably had an impact on Vice President Pence, but it also made it a lot less likely that he was going to do what the president wanted, even if he'd otherwise been disposed.
We have time for maybe one last question.
So for us non-lawyer types, this Electoral Reform Act in Congress, do we really need it or don't we?
I'd say yes. I mean, I think there are a number of ambiguities that have been open, some of which we're starting to sort of received some attention and potential exploitation in this past election, and that just have needed to be answered for a long time. So one is, just to name sort of one off the top, the Presidential Election Day Act of 1845 says, well, here's when you hold the first Tuesday after the first Monday in November is when you have a presidential election, but if the state has failed to make a choice, you can appoint them on a later day. For those states, and I think New Hampshire is one of them, where you required a majority winner, and if you had a plurality in the original election, you had a runoff, and you could have then a majority winner in the second election for president. We don't do that anymore. We don't have like a definition of what fail to make a choice means. We don't know whether the legislature can self-declare, has to pass a statute before election day. So there's inherent uncertainties, and this is one provision that was invoked in 2020 and potentially used in Florida in 2000, although we never got there. Say, well, we failed to make a choice. Let's show up as a legislature and do our own thing. That to me is pretty dangerous, pretty uncertain, leaves a lot, even if not legally problematic, a lot of open questions for the public, as the legislature suggests it has this authority. So one of the things that the Electoral Count Reform Act does is says there's one day of holding election. You can't move it. Your laws have to be in place by this day. If there's an emergency, you can potentially modify the period of voting, and that's it. So I think that shores up an incredibly important component of our system, again, in a way that we haven't had to sort of worry about, but it's been lurking around out there for 200 years. So just that is just one example of the many sort of small things the bill does that I think will be very helpful for elections for the next 150 years. Again, it's a very old bill. When you're tweaking these things like it, you want something that's going to sustain for generations. And I think it's what the Electoral Count Reform Act is.
Some of the language in it also is incomprehensible. It's very hard to figure out. And another thing that the proposals do, although I think the Senate and the House are a bit different now, as I understand it, is that is to raise the threshold for the number of objectors that you need. So it's not simply one from the House and one from the Senate, but it's a substantial percentage, and that could have made a difference, particularly in the Senate, which tends to object less frequently. And even in 2020, I mean, I think on Pennsylvania, I think it was Hawley the only objector, although not, I think.
Although there were 8 votes, I think.
But he's the only one who signed the objection. Right. This would require a substantial percentage to actually object.
With that, thank you both. Please join me in thanking. It's my great privilege now to introduce someone, hard to believe I've known for 15 years now. Wow, where does the time go? Professor Edward Ned Foley holds the Eversole Chair in Constitutional Law at The Ohio State University. Yes, we have to emphasize the article, where he also directs its election law program. He is contributing opinion columnist for the Washington Post, and for the 2020 election season, he served as an NBC News election law analyst. His most current book, Presidential Elections and Majority Rule from Oxford University Press, excavates the long-forgotten philosophical premises of how the Electoral College is supposed to work, as revised by the 12th Amendment to the United States Constitution. And he also uses this historic analysis to provide a feasible basis for reform of state laws that would enable the Electoral College to operate according to its majority rule's objectives that it was designed to achieve. Professor Foley clerked for Chief Judge Patricia Wald of the U.S. Court of Appeals for the D.C. Circuit and Justice Harry Blackmun of the United States Supreme Court. He has also served as the state solicitor in the Office of Ohio's Attorney General, where he was responsible for the state's appellate and constitutional litigation. Professor Foley is a graduate of Columbia University School of Law and Yale College. Please join me in welcoming Professor Foley.
Thank you, Kyle, for that kind and generous introduction. And it is such an honor and privilege to be back, well, to be here, but back with you and to have watched your career blossom in the way that it has. It was wonderful to be colleagues with you at Ohio State, and it's nice now to be on your turf here in New Hampshire. So, and what a great event and a great conversation. I'm so glad to be part of it. So what I'm going to do today is present a modified version of ranked choice voting. How many of you have heard of ranked choice voting? And it's now practiced in Maine and Alaska. And I'm going to offer a modification of it that I think is an improvement. You'll decide whether that's true or not, but at least it's worth comparing. And it grows out of research that I've been doing over the last couple of years, designed to deal with the increasing polarization that we have in our society, as we were talking about earlier today. I need to say right at the outset that this particular proposal and idea has been generated from correspondence with Eric Maskin, who is a Harvard economist, and so some of that correspondence was inspiration for this idea, so I owe a debt of gratitude to him for that. So it's called total vote runoff, and we'll explain what that means, but we'll review some things to get there. So what I've been observing this year in the midterms is this three-way split that's occurred in American politics. I think this should be familiar to all of you. For the most part, I mean, again, we've got 50 states and lots of variation, but for the most part, the Democratic Party is hung together, has not divided into its factions as it might, in terms of a clear winner has emerged out of the Democratic primaries, but the Republican Party has really split into two subgroups, the so-called MAGA wing of the party, with candidates endorsed by former President Trump, has been dominant and has won a lot of these inter-party fights. But there has been another Republican, a sort of traditional GOP alternative that came close to winning the primary in some of these states, but didn't. So one race that's on my mind is the Arizona governor's race. The Democratic nominee is the current Secretary of State, now running for governor. And as you know, the winner of the Republican nomination for that race is one of the leading election denialists around the country. We've been talking about the risk of election subversion and election denialism. But we shouldn't forget that there was another Republican candidate endorsed by Vice President Pence, endorsed by Governor Ducey, that was more of the traditional wing of the Republican Party, but that came up short. And so, you know, that candidate's not on the November ballot. The November ballot is a choice between the MAGA candidate and the Democrat. And the major point here to think about it, I think, is that, and this race has been considered a toss-up. If you read Cook Political Report or the other prognosticators, this could go either way. And so, you know, maybe the Democrat will win, but maybe the MAGA candidate will win. And if the MAGA candidate wins, the takeaway will be, well, that's who the Arizona voters want. But not necessarily true. I mean, the Arizona Republican voters in the Republican primary preferred the MAGA candidate to the traditional GOP candidate. But it is quite possible that the November general election voters in Arizona, if they had been given the choice, instead of voting for Lake, if that's what they end up doing, say, well, you know, we would have preferred that other Republican candidate that we didn't get a chance to vote for because they got knocked out in the primary. So again, we've got this three-way split in the electorate, in the electoral process, and it's repeating in lots of places. So same thing in the U.S. Senate race in Pennsylvania. This one is getting a lot of national attention. You must know that Lieutenant Governor Fetterman is the Democratic nominee. Oz is the Republican, Dr. Oz, right? The Republican nominee endorsed by Trump. You know, that Republican primary went to a photo finish recount, where again, the more traditional, more Chamber of Commerce, business community type Republican came very close to winning, but didn't win. Again, the November voters aren't going to get that choice. You know, if you listen to the polls, and who knows what the pundits are saying, but apparently that race is also tightening. Cook Political Report just put it back into the toss-up column. We'll have to see what comes out. But again, McCormick is not going to be on the ballot in November. If Oz ends up winning, maybe McCormick would have won by a bigger margin. Similar thing happening in North Carolina, not quite as close, but so we've got a strong Democratic nominee, former Justice of the Supreme Court, a Representative Budd, one of the early election denialists for embracing Trump's big lie early on. Knocked out in the Republican primary was former Governor Pat McCrory, who was trying to represent the more traditional wing of the Republican Party. Here in New Hampshire, this is the more recent primary, just in terms of chronology. You've got a version of this. Your incumbent senator is the Democrat. The race was pretty close on the Republican side of the nomination. The more MAGA election denialist candidate won. I gather he's totally flipped on his belief in election denialism, although the Washington Post this morning has a story where he's been a little bit whiffling and waffling about his retraction there. So we'll see what happens between now and November. In any event, there was another candidate. I gather the president of the Senate and the state legislature was the more traditional Republican, again, close, but not close enough. Who knows what the outcome is going to be in November, but that third candidate's not an option. Contrast that with Alaska, which has this new ranked choice voting system with the so-called top four system, where you have a nonpartisan primary leads to a ranked choice voting ballot in the general election. There was this special election to fill the vacancy of the House seat, and it ended up being a three-way race because the fourth candidate dropped out. And you had a Democrat, you had Sarah Palin, famous Sarah Palin, who was endorsed by Trump, representing the MAGA wing of the party. And then you actually had a genuine three-way race because the more traditional party establishment Republican Nick Begich was also on the ballot for a three-way split. So this phenomenon is repeating itself all over the country. So abstracting from that, I want to think about a hypothetical that could be anywhere. This is going to be built most out of my own state of Ohio, but you can process it in any state you want to, or just think about the generic issue. And the point is that, we simplify as to the ideological left-right spectrum. You've got a chunk of voters on each side and some voters in the middle who lean one way or the other. And so again, there could be a three-way split, but under the conventional electoral system of a partisan primary followed by a plurality winner general election, we can talk about what that means in a moment. You're going to get a Democratic candidate and in Ohio a MAGA candidate. So we've got Tim Ryan, the Democrat, running against J.D. Vance, again Trump-endorsed election denialist candidate. And given the way this race turned out, you might imagine incumbent Senator Rob Portman saying, "Hey, what about me?" I mean, he obviously decided not to run. Was it personal reasons? He's tired. He's not that old. He's not that unpopular. Did he want to just deal with the issues of a MAGA-dominated Republican primary or whatever? But Jan, just think hypothetically that he said, "Wait a second, I could beat either of these guys one-on-one in November." And I think in the Ohio electorate, that is true. Again, whatever your own personal politics are, whatever my personal politics are, I think the nature of Ohio, given, more red-leaning than, blue at this point, and given the track record of Portman in his own elections, meant that if it were a one race between Ryan and Portman would probably prevail pretty easily. I mean, again, these are artificial numbers. You'd have to decide for yourself. But most political professionals in Ohio think that the race is tight right now, precisely because the Republican nominee is a MAGA candidate like J.D. Vance, not a more traditional candidate like Rob Portman. Now, if the one-on-one race were the other way, and just again, imagine giving voters the opportunity to say, which of these two do you prefer? Have any of you gone to the eye doctor where the eye doctor says, which looks better, this or this? Which looks better, this or this? You could, if there are three candidates in an election, you could run an election that way. It'd be a little more complicated, but in terms of trying to figure out what is it the voters want, if the voters were given the choice between Ryan and Portman, what's your choice? Okay, now Portman versus Vance, what's your choice? Portman is going to clobber Vance one-on-one among the general election November voters, because all of the Democrats in Ohio don't want either one of them. But then they'd rather have a more moderate Portman, more traditional Portman than the denialist Vance. But of course, Portman or somebody like him can't come out of a Republican primary these days because the primary voters are going to be dominated by the MAGA wing of the party. So instead of those two one-on-ones, what we're going to end up is with the other one-on-one, which is going to be Ryan and Vance. And again, this one is tighter than most people had thought about it. And it's tighter because there is that middle of the electorate that, might be more sympathetic to Ryan, but may ultimately end up voting for Vance, not having the option of that third option that's just not there. So, with that kind of as a background, let's think about the Alaska system. So let's assume the exact same set of voter preferences, but now the voters are going to be able to translate those preferences into a ranked ballot of the kind that Alaska uses. So what does that look like? So we're going to say, and again, this is oversimplification for purposes of illustration, but let's just say 30% of the electorate would rank the MAGA candidate first, the more traditional Republican second, and then the Democrat third. That would be, in Ohio, again, Vance first, Portman second, Ryan third. The Democrats, on the other hand, would say we want the Democrat first, hold our nose for the traditional GOP candidate second. We really don't want that MAGA candidate. So the preferences runs in the opposite direction. Then there's that middle of the electorate that might be a little bit split. In a state like Ohio, if you've got roughly 20% of the electorate favoring the traditional GOP candidate, their second choice might be loyal to the Republican. They don't love Vance, but they'd rather have another Republican than a Democrat. But there will be a sliver of the electorate that wants a traditional business-friendly Republican like Portman, but does not want somebody as out there as Vance, and said, okay, Ryan's a decent Democrat, we could vote for him. So that's what maybe the ranked choice ballots might look like. So how does the ranked choice voting process work in a state like Alaska or Maine for that matter? And it's what's we can call the instant runoff tabulation of the winner off of the ballot. And again, some of you were probably already familiar with this. So what instant runoff voting does is identify, first of all, it asks the question, does anybody win a majority of the vote in terms of first place votes on the ballots? And if so, they're declared the winner. But if not, you eliminate a candidate in order to have a runoff. And the way the instant runoff works is it eliminates the candidate with the fewest first place votes. So in this example, that would be the traditional GOP candidate because they only get 25% of the first place votes. What happens after you eliminate that candidate is there's a vacancy in those first place slots on those ballots, and it moves whoever is in second place on those ballots into first place, given the elimination of a candidate. And just, it moves the ballots over, as it were. And so it then looks and redistributes those votes to whoever had been in second place and is now moved into first place to recalculate the result. Again, looking to see whether there's a winner of a majority of the ballots after that elimination and recalculation. And sure enough, now the MAGA candidate picks up that 21%. The Democrat only picks up the 4%, given the second choice preferences, and we have a majority winner, which, given these ballots, these hypothetical ballots, is the MAGA candidate. And the point of this example is to illustrate that the instant runoff methodology can replicate the results of a traditional party primary with a traditional electoral system if these are the kinds of preferences that we see on the ranked ballots. But there's another way to calculate the winner off of the exact same preferences, and that's what I want to show you, and that's what I'm calling total vote runoff. If you know a lot about election science and you're really interested in this, it's using something called a Borda count to identify the weakest candidate, but Americans don't know what the word border means. Instead, let's talk about the concept of finding the total votes that a candidate gets off of the ranked choice ballots, because the ranked choice ballots for any voter has a lot of information on it, not just who's in first place. So this system, the total vote runoff, is identical to Alaska ranked choice voting or Maine ranked choice voting. It's absolutely identical in every respect except how it identifies the weakest candidate to be eliminated in any particular round of sequential elimination. That's the only difference between this method of ranked choice voting and the one that's used in various states right now. So again, the first thing you do is you look, has anybody won a majority of first place votes? No, so we have to eliminate somebody. How do we eliminate somebody? We eliminate the candidate with the lowest total votes out of the ranked choice ballots. How do we calculate total votes? Well, we allocate votes for each position a candidate is on a ballot. If a candidate is ranked first on a ballot, in this 3-candidate example, that means they get 2 votes for being in first place. Why? Because they're beating 2 other candidates. If you're in first place and there are 3 candidates, and being in first place is ahead of 2 others. Or if you think about how that a ranked choice ballot reflects the same information that those head-to-heads that we were talking about means a voter who ranks the MAGA candidate first would, if asked, do you prefer MAGA or GOP, would say, I prefer MAGA, 1 vote. Do you prefer MAGA or Democrat? Prefer MAGA, 2 votes. So 2 votes for being in first place. Likewise, you get 1 vote if you're in second place. Why? Because the second choice on that ballot is ahead of 1 other candidate, that's the 1 vote, but behind another candidate, so no vote there. Again, they would win one of the head-to-head comparisons for being in second place. That voter would vote for GOP over Democrat, 1 vote, but not vote for GOP over MAGA, so only 1 vote. If you're in third place, you don't get any votes because you're not beating anybody else in the election. So how do we know a candidate's total votes? It's how many votes each candidate gets on each ballot, and you sum it up. So here are all of our first place votes. We multiply them by 2 for the reasons that we just said. Here are all of our second place votes. Again, they may come from different ballots, but you just find all your second place votes. You don't do any summing because only 1 vote for being in second place in a 3-candidate election. There you sum your total votes. And then here's where the basic methodology of instant runoff voting, like Alaska, works. You eliminate the candidate with the least total votes. That's the MAGA candidate in this example. After eliminating that candidate, again, you do what we were doing before, which is you move your candidates over into the vacant spots. Now, do we see any candidate having being in first place on a majority of ballots? Answer, yes. Turns out the traditional GOP candidate is now in the majority of all first place ballots. That's the same candidate who we saw would have won the series of head-to-heads. So the total vote runoff process in a ranked ballot format emulates what the voters will be telling you in the eye doctor concept of an election, if you will. So that is the system. I just want to show you really quickly. It can handle, and this is the advantage of doing it in ranked ballot format. You do not want to have voters go to eye doctors, because if there are 4 candidates, 5 candidates, 6 candidates, if you think about the math of this, the number of one-on-one comparisons starts to multiply. With 4 candidates, it's 6 head-to-heads. With 5 candidates, it's 10 head-to-heads. Way too much to ask voters to do. But if voters rank 4 candidates like they can in Alaska or so forth, you just put that on your ranked choice ballot, and the total vote runoff process works methodologically the same way, regardless of the number of candidates involved. And so just to show you that really quickly, this is essentially the same election or hypothetical election that we just saw. Instead, now I've added a 4th candidate called progressive. So we've got the traditional Democrat, but a little bit more centrist, added a progressive. And remember, the Democrat got 45% of first place votes in the 3-candidate example. Basically, what I've subdivided that out, and this 25 number is, where the voters like Democrat first, progressive second, traditional Republican third, then MAGA. And you got 15% of the electorate wanting the progressive first, then the Democrat, then the Republicans. And then there's, 5% of the electorate wants a centrist Democrat like Tim Ryan, but maybe doesn't want somebody who's, too progressive or semi-socialist or whatever, and so would cross party lines a little bit. Anyway, again, you can play with these numbers. I think you get the concept. Same methodology as before, although in this case, first place votes count for 3. Why? Because now being in first place beats 3 other candidates instead of just 2 other candidates, right? So if you want to think about this math, it's like if there are n number of candidates, if you're in first place, it's n minus 1, because in first place is beating, 1 fewer number of candidates than the total number of candidates in the election. Again, you can think of that in head-to-head terms, or you're thinking that about just positionally, the first place candidate is ahead of 3 other candidates. So, multiply first place votes times 3. Second place votes are now worth 2 points because a second place in a 4-candidate race is positionally ahead of 2 other candidates. And so you can calculate them the same way. And now third place votes are only worth 1 point. Always being in last place, now how many number of candidates gets you 0 points, because in last place you're not beating anybody else. So same thing as before, we just sum up the total number of votes. Again, we first asked, did anybody win a majority? No, nobody won a majority. Then we eliminate the candidate with the least number of total votes, happens to be progressive in this example. We do what we were doing before. So, I could go slower, but you guys are picking this up. And then once you eliminate the progressive, this should look familiar because now the numbers are exactly the same as the 3-candidate example, and just the process follows the way through to get to the same results as we got before. Last point, and then I'd love to have a conversation or answer questions about this. What about if voters don't want to rank all the candidates? How would you handle that? You would give the candidate the same number of points that they deserve for being in that place on the ballot, regardless of whether or not their candidates rank below or left unranked. In this example here, the MAGA candidate still gets 3 points for being in first place in a 4-candidate election, even if that's the only candidate ranked on those ballots. Why? Because again, we know that the voter prefers the MAGA candidate to each of the other candidates. If asked, do you prefer MAGA or any of the other candidates, they will always say yes. So they should earn that n-1 number of points for being in first place. But since the voter isn't ranking any other candidate, no other candidate gets any points. So the idea is 0 points for being ranked last, or 0 points for not being ranked at all. And this example only gives you somebody who's a voter who ranks in first place and leaves the rest of the ballot unranked. Imagine if some of these progressive voters ranked progressive and then Democrat, but didn't rank anybody else, there'd be 3 points for the progressive candidate on those ballots, 2 points for the Democrat for being ranked in second place, again, because they prefer the Democrat over the 2 unranked alternatives, so still earns 2 points. I think it's pretty straightforward. You calculate the results in the same way that we were doing before. These numbers are pretty similar, but not identical because of the blank, the empty spaces on some of the ballots. We do see that the progressive candidate still in this hypo is eliminated first, but just to get to the end of the process here, I just want to show you, after the MAGA candidate gets eliminated with the next lowest number of points, in this situation, these are now the final vote totals. So under this system, the Democrat would beat the traditional GOP because once it's down to the final 2, the Democrat wins a majority of the voters who express a preference as between those two candidates. It's not a majority of all voters in the electorate because some of the voters chose not to express a preference between those two candidates, but it's still a majority as to the direct competition between those two. So, and this relates finally to the point about what is the risk of strategic manipulation of this process. It's the point I discussed in the draft of the paper and we'll develop more. But in this example, if the MAGA voters and the MAGA candidates thought that they were helping themselves out by only voting MAGA in first place and not voting for any other preference, they actually hurt themselves because, again, if the assumption was that they would like a Democrat less than a regular traditional Republican, that attempt at strategic manipulation actually ends up that the candidate they like even less ends up winning the process. So that's the system. And I very much look forward to your feedback, thoughts, and questions. Going to sit, stand?
Oh, I just left the microphone up here. That's fine. I'll start with audience questions. Andrew.
I have two questions. So you mentioned one form of strategic voting, and you have assessed that your system is relatively resistant to it. Are there any other kinds of crazy strategic voting that need to be considered? Because I can imagine maybe there are other kinds of attempts to game the system with strategic voting that...
Absolutely. And, I welcome not just today, but in an ongoing, scholarly and policy-oriented conversation around this. What the literature of voting system design tells us is there's no system that is completely immune to strategic voting. There's a famous, mathematical theorem that proves that. And one of the interesting things that came out of the Alaska special election was, at least from my perspective, some strategic behavior that was at least unanticipated by me about how the two Republican candidates would knife fight each other in order to avoid being the first candidate getting dropped out into the way in which Alaska does sequential strategic elimination. So you always have to think about, what would game theory behavior say? What would candidates, voters try to do to try to win under the system? I would never say that this system is immune to strategic voting. I would say it's, given this example and some other examples like it, there's some properties of it that would require, and this gets into some technical details about the relationship between this system and something called fusion voting, which we could talk about if we wanted to, which is, in other words, especially with a three-candidate dynamic, if you think of team red and team blue on left and right, and there's a centrist candidate in the middle, with this kind of math, you would be at a strategic advantage to build a coalition with the center. Otherwise, you might be getting left out if the other side builds that coalition. But I think there's some more work to be done in terms of trying to analyze and model the strategic behavior. No doubt about it. Final point is, in the world that we live in now, with this threat of election subversion, election denialism, are we better off with this kind of system? Or are we better off with the Alaska system? Or are we better off with the system that we have? That's the debate that I want to encourage us to think about.
Okay, thank you. So you said there's a paradox that no form, but that paradox only applies to ranked systems.
No, it applies to all voting systems. What is it, the Gilbert Satterwhite paper? You guys, some of you people in the room know this better than I do, but there's two famous papers that were written simultaneously, I think in the 1970s, that mathematically prove that any voting system is vulnerable to some form of strategic manipulation. It's an outgrowth of Arrow's theorem, which proves there's no perfect electoral system, but the secondary papers prove that any system is subject to strategic manipulation of some kind.
My other question, which is not a mathematical question. So you've illustrated that the basic electoral mechanism is voters rank all their choices. And then we have different systems for interpreting those rankings. And what we saw this year, I think in both Maine and Alaska, is that as soon as the results were announced, then people started complaining about the method. So,
I mean, Alaska did not need to announce first round results while it was still waiting to tabulate second round and third round. I mean, that is a choice. I mean, I agree with you that in thinking about what electoral system any jurisdiction should adopt should be a combination of some of the things that I was discussing about and some of the practicalities of like, okay, how are you actually going to administer and run it? Some of the delay in Alaska was caused by how you do vote by mail absentee voting, not necessarily.
I wasn't talking about the delay. I'm talking about outcome-driven dissatisfaction with the process, which is really a complaint about the outcome, but directed at the process. And so is this ever going to be stable? Not as a mathematical question about how the process works, but as a political question.
Yeah, no, I think that's a fair point. I mean, you know, in a world in which even with our current system, we have significant political forces refusing to accept defeat and flying in the face of reality, just denying the truth of what the voting outcome is, you know, that's scary. What I am worried about, though, is that our current system is replicating or it's creating electoral victories for election denialist candidates that is not really representative of the will of the majority. So if the election denialists are going to deny anything that they lose, you might as well have them deny a system in which actually finds what the majority want. But I take your point that obviously the public needs to understand the system in order to have confidence in the system. You know, the Republicans out of Alaska said, how can we trust ranked choice voting if our candidate, you know, we had two candidates, their combined first place votes was 60%. The other candidate, the Democrat, with roughly 40% of the first place votes, they win. That can't be a fair system. They're actually sort of right about that. The fairest system would have actually elected a Republican. It just would have been the Begich Republican, not the Palin Republican. So we need to, as a country, we need to do a lot better in sixth grade, teaching every American the basic mathematics of voting so that when the voters themselves, when they're no longer in sixth grade, but they're adults, they can say, what's a good system for us? We don't educate citizenship to understand the kind of, you know, trade-offs in choice here.
For those of us on the ground who have to administer these systems, I imagine the day that this gets enacted in New Hampshire, Secretary Scanlan and I will be heading for the retirement door to try to beat each other out the door. But more seriously, I'm sort of serious about that, but isn't this subject to the objection? And I'm all for driving everybody toward the middle to get people together and get consensus. I think that's one of the key things in our country, but isn't this subject to the criticism of it's kind of result-oriented? Because we don't like what's happening now, so we want to design a system that'll force a different result?
I hope, I mean, I take your point, and it shouldn't be. I mean, I think, you know, it is an impartial system in that it doesn't inherently favor left or right, red or blue. It takes the preferences where they are and aggregates them. But it is true that any electoral system some electoral systems find the median, you know, the preference of the median voter better than others. That relates to this issue of polarization, right? I mean, you can design an electoral system that tries to find a strong left and a strong right and figure out where the public is relative to strong left or strong right. But that doesn't, you know, that system is in some sense impartial because everybody's vote counts equally, but the way in which it deals with the preferences hollows out the middle. On the other hand, this kind of system, you know, finds, you know, the point of showing the head-to-head shows that if you ask all the voters, do you prefer Rob Portman or Tim Ryan, Portman wins. You ask by a majority. If you ask all voters, Rob Portman or J.D. Vance Portman wins. So this system finds the more centrist choice that can command a majority against all alternatives. And yet that centrist candidate is objectively the weakest candidate in terms of first choice preferences, right? Given these numbers that I showed you, Portman was only able to command 25% of first choice votes as the incumbent, because why? He doesn't have the Republican nomination, and that counts for an awful lot. And he doesn't have the Democratic nomination, which counts for an awful lot. So if you want a system that is strong two-party system, red versus blue, no matter how polarizing that choice is, that you want a different system. And so I think each society has to figure out what it wants at each time and place. I think we're at a moment in American history where, because of polarization, we would do well to try to find a more, centripetal system than centrifugal system, if I've got that terminology correct.
A real runoff system together. I know it takes more elections, more confidence in a system that says, hey, nobody got 50%, the top two are going to know.
Sure, I think mathematically there's a lot of similarity between what Alaska is doing with instant runoff versus what California and Washington State are doing with an actual, I mean, they call it a top two primary to the general, but it's a functionally that makes the November election a runoff. Georgia has a runoff that occurs after November. So, the whole point of an instant runoff, it's designed to replicate an actual runoff, but do it instant runoff of one ballot. But if you like the idea of a runoff, you can disaggregate it and say, let's have a preliminary vote, find two candidates, and just have a final head-to-head. That then depends on what's your method for picking the top two that get to the final runoff. You could use a simple plurality system like Washington and California do, or you could do something called approval voting, which is what St. Louis does at stage one, which if we had time for it, or you could use either version of ranked choice voting at stage one to winnow the field a little bit differently to two contenders, which might not be the same two based on simple plurality. So the mathematics really matter at how you identify a winner from a multi-candidate field.
Last question. Okay. My question has to do, Ned, with voters and educating them about this system, because even if I'm 100% in your camp, and I think I am, I'm just going to give you a personal experience. I was a faculty.
I'm sorry.
Can you hear me?
I heard everything, but right. I heard you were in my camp, and I like that. Yeah. But I didn't hear the but or the if.
How to educate voters about this system. So here's my, even if I'm 100% in your camp and I'm 99% there, I had the following experience. A dean came to me and said, Gene, you're the election law person. We're trying to hire faculty candidates. We have this very bad rule. We need to adopt a new one. Could you please explain to our faculty the voting rules? So I came and I had a blackboard and I put, Borda on one board and Condorcet on another and IRV on a third and approval voting on a fourth. And my colleague said, well, which one's the best? I said, none of them are the best. Each one has faults. And I tried to walk them through the math very slowly in an hour faculty meeting. I don't think I helped anybody.
Wait, an hour?
There were a lot of numbers on the board, and
this is law faculty.
This is law faculty, and they said we just want to rank them, and then we want to have the one who gets the most votes. That's the person we hire. I kept trying to say to them, you understand that there's a Nobel Prize winner who's explained this, but my colleagues did whatever else they did at healthcare law. I don't know, whatever other topics they did, and this was, they wanted an answer. So I realized that something that we understand very intuitively is very difficult for a person coming to this to understand. Now I'm trying to extrapolate that experience where I had faculty colleagues to voters who are very, very, very low information folks for many issues. And I wonder how something like this could be sold to voters. I don't know the answer, but I wonder if you know of any data of how people in Alaska or Maine or Portland react to that system. I'm kind of going on something that Andrew started, and I want to know how you're going to sell this to somebody.
So try to be.
Say this being in your camp, right?
Yeah, no, I hear you, and I want to be respectful of time, but I guess what I would say is the point of this presentation is to say that any jurisdiction that might be considering adopting what Alaska or Maine have done, which is a big if, right? Not other states have done it. And as someone who's a fan of that, I mean, you have to get through a hurdle to whether or not you want any kind of ranked choice system or not. And that itself involves public education and the complexity of any ranked ballot. I'll acknowledge that there is additional complexity here in calculating the total vote in order to do the elimination that you have to do with any kind of ranked choice voting system. But the question is the concept of the total vote that much harder to understand? And is the trade-offs worth it? And I think the way in which I would try to sell it to the public is to say, the concept of instant runoff is to eliminate the weakest candidate to find the one who should eventually win. Shouldn't you identify weakest in the way that makes the most sense, given all the information that the ranked choice voting ballot and process does? If all you do is look at your first ranked numbers to see who's weakest, you're not looking at all the votes that the voters have submitted on their ranked ballots. And whether you call it the border count or you call it this, that actually better defines what weakest means in a multi-candidate field. So eliminate the weakest border score and do everything else the same. Now, if you don't want any ranked choice voting, you're not going to be choosing between these two alternatives. If you decided you're interested in ranked choice voting, maybe you want to say, let's go with instant runoff Alaska style. But I think you should do that with your eyes open. And if you're particularly deciding you want to do that because you think it solves the problem of polarization, I think you need to worry about this hypothetical, because unfortunately, I think it's realistic. And the point of showing you that map with all of these races is to show you that I think we're at a point where the electorate will be that instant runoff results will replicate regular results because of the way in which the electorate is currently split. So I think that's all I should say at this point.
I'll try and be quick. So 10 years ago, I used to be a fan of range voting, which is a form of approval voting where you get to give every candidate, a number on a scale of 0 to 5, and you can give as many 5s as you want or as many 2s. And then I ran an election among my engineering school colleagues, in choosing who should get a certain prize out of several candidates. And I explained to them, give each candidate between 0 and 5. And they all voted like 2s and 3s. So they're not using the range. So then I got less enthusiastic about ranked voting.
I think ranked voting is a lot better than range voting.
But it seems to me what you've got is ranked voting, but in choosing which candidate to eliminate, you're effectively using range voting, which I think is sort of interesting and not necessarily bad.
We really have to wrap up because of time, but we have some really great opportunities for a reception later on today where we can keep the conversation going. The theme of this panel is issues in redistricting, and I'm very excited to have two wonderful colleagues here to talk about this issue in different respects. First, I wanted to introduce our initial speaker, Dr. Jonathan Service. He's a postdoctoral fellow at Carnegie Mellon University, and he teaches for the Institute of Politics and Strategy there. And he also teaches undergraduate and master's degree students for the university. He joined the Institute of Politics in 2020 after receiving his PhD in political science from the University of California, Irvine. He received his undergraduate degree at the University of Nevada, Las Vegas, and undergraduate degrees at the University of California, Irvine. His 2020 doctoral dissertation is titled A Quantitative Assessment of the Electoral College, 1790 to 2020. He has assisted 3 federal courts in voting rights and redistricting cases related to redistricting and racial minority voting rights. He served as redistricting consultant to the Pennsylvania Legislative Reapportionment Commission, in 2021. He most recently served as the New York State Supreme Court as a special master, redrawing the state Senate and congressional districts. His co-authors could not be here today, but I also wanted to recognize Bernard Groffman and Scott Matsudo for their contributions to the forthcoming paper. Our second speaker is Professor Sam Wong, a professor at Princeton University, where he has taught and conducted research since 2000. He's appointed in neuroscience, but he's also affiliated with the program in law and public affairs, the Center for Cognitive Science, the program in quantitative and computational biology, and the Center for Information Technology Policy. He is the author of over 100 scholarly articles spanning fields including neuroscience, mathematical biology, and election law. In addition to his scientific career, Dr. Wong is committed to the application of math, data, and law to improving American democracy. His current work focuses on making elected officials more responsive to voter preferences. He analyzes American politics at the Princeton Election Consortium and addresses electoral reforms through the Princeton Gerrymandering Project. So without further ado, I'll turn it over first to Dr. Service.
Thank you, Kyle. And if I wasn't such good friends with Sam, I'd be intimidated by his CV, but I'm very glad that this is the first time I've actually sat on a panel with Sam ever, even though we've collaborated on several papers and have teamed up to try to help democracy in any way we can. So today, I want to present some work. It's a paper that we're starting to develop based on the outcomes of this redistricting cycle. And as Kyle said, my co-authors are Bernie Groffman and Scott Matsudo, who is a recent JD from the New York Law School. And we thought it was important if we're going to have an article in a law review, that we should have somebody who knows the law really well. So he's hopefully going to help check to make sure we get everything right. So just a quick rundown of what I want to talk to you about today. I kind of can describe it in like three sections. First, how did we get here? Where are we and where are we going? So we'll start first how we got to where we are when it comes to partisan gerrymandering. This is a list of court cases from the National Conference of State Legislatures that starts in 1946 with Cosgrove that ruled that apportionment cases were not judiciable. So the Supreme Court at one time said that policing partisan gerrymandering, so to speak, was not judiciable. We couldn't do it. The federal courts could not do it. Well, in 1962, they heard this case, Baker versus Carr, where they overturned themselves. And they said, oh, by the way, it is judiciable. We can police malapportionment in federal courts. And so keep that in mind, that the court can reverse itself. The Supreme Court can reverse itself. So so you have these Baker versus Carr cases which police malapportionment, which is sort of the traditional way in which partisans gained advantage through our redistricting schemes. The first court case after that came in 1973 out of Connecticut called Gaffney versus Cummings. And there, Connecticut they wanted to use political data to ensure essentially proportional representation. And the court allowed that to happen. In 1986, there was a case, Davis versus Bandemer. In that case, there was a challenge to Indiana's state legislative plans as partisan gerrymanders. In that case, the court ruled that partisan gerrymandering claims were not, they were judiciable, but they did not find the claim to be sustained because there was no standard by which to judge what is a partisan gerrymander. But that gave hope to people who were hopeful that the courts would step in and ensure some sort of political fairness. Skipping ahead to 2004, and we really are skipping, there's nothing going on in between these cases. The courts are not hearing, the US Supreme Court is not hearing any cases on partisan gerrymandering. So from 1986 to 2004, there were no cases. But in 2004, the court heard this case, Beath versus Jubileer, out of Pennsylvania, my home state. And it rejected the claim in Pennsylvania of a partisan gerrymandering, again, because there's no manageable standard by which to judge when something is too political. This case is a little bit different, though, because now the court has changed, and a plurality of the court has suggested that actually partisan gerrymandering is not judiciable, forgetting about what we said in Bannerman earlier. But Justice Kennedy at that time voted with a majority to vote to say that the plan was not a partisan gerrymander, that plan was not a partisan gerrymander, but was reluctant to go so far to say that there was a plan that couldn't be ruled unconstitutional. And so that left open the possibility that they would still find this mystical, magical, manageable standard. There was one more case in 2006. It was a challenge to Texas, and they did a mid-decade redistricting. LULAC is what the court case is called. They, again, rejected the claim that it was a partisan gerrymander. Again, no standard. And they reiterated the fact that, quote, fairness is not a judiciable, manageable standard. So social scientists, lawyers, mathematicians, nobody's been able to find the way in which a court can have a bright line test when something goes from being fair to being unfair. Finally, that brings us to 2019, to Rucho. There is one case before that in 2018, Gill versus Woodford, which the court basically stayed and came back to the facts in this Rucho case out of North Carolina. And in that case, the North Carolina court had ruled that the map that was drawn by the Republican legislature was a partisan gerrymander. In fact, the drawers of the map in North Carolina had stated that it was a partisan gerrymander and that they drew only 10 Republican districts because they couldn't figure out a way to draw 11 Republican districts. They drew as many as they could. But in Rucho, the Supreme Court said, sorry, there's no standard. Therefore, it's not judiciable in federal courts. They rejected all possible avenues for bringing a partisan gerrymandering case, including the First Amendment, the Equal Protection Clause, the 14th Amendment, or even Article 1, Section 2 of the Constitution. So it's just done. There's no federal court intervention. So in that court opinion, the majority also recognized, quote, excessive partisanship in districting plans lead to results that reasonably seem unjust. So the court itself is saying partisan gerrymandering bad. But they also said, without qualification, that there is no appropriate role for the federal judiciary in remedying the problem of partisan gerrymandering. Whether such claims are claims of legal right, resolvable according to legal principles, or political questions that must find resolution elsewhere. So yes, bad problem. Sorry, we're not going to do anything about it. So that means that there potentially are other places, jurisdictions that can do something about this egregious partisan gerrymandering. So again, the court has been claiming that there's no manageable standard. But it's our view that that was far too simplistic of the Rucho majority, because after the 2010 round of redistricting, several state courts had begun overturning their own plans. So not federal courts, now state courts. And they did this by reading in language from their own constitutions or the laws of their individual states. So the first case of interest here is a case called League of Women Voters versus the Commonwealth. And so what you see on the screen here are two maps, the one on the left being the map that was ruled unconstitutional, and the one on the right is the one that replaced it. And after the 2010 round of redistricting, the Republicans in Pennsylvania controlled both houses of the state legislature, and the governor was a Republican. So they had a unified government, so to speak, trifecta government. And they drew this plan. I do not have overlaid over this like the county lines, but essentially grabbing populations from anywhere they could in order to pack Democrats into 5 districts and ensure that Republicans would win the 13 other districts in this, or 12 other districts in the state, sorry, 12 so
13 at the time.
Yeah.
It's at then 13.
So, and in every election between 2012 and 2016, Republicans won those 13 districts, and the Democrats won exactly 5. That includes the times when the Democrats won more votes than the Republicans. That includes the times where they won less votes. It didn't matter what vote share the Democrats were getting. They were only going to win 5 districts. They've set them into a permanent minority. And the Pennsylvania Supreme Court read in language that existed from their very old Constitution, from Article 1, Section 5, that says elections shall be free and equal, and no power, civil or military, shall at any time interfere to prevent the free exercise of the right of suffrage. Of course, nowhere in there does it say anything about partisan gerrymandering. But nonetheless, the court was able to read their Constitution to interpret that to mean that partisan gerrymandering was not acceptable in the Commonwealth. And they overturned that map. They brought in experts who came in and used the kinds of standards that, again, social scientists and mathematicians had been bringing to federal court. They took it into the state court using that evidence and ruled that indeed the plan that was adopted by the Republican legislature in 2011 was indeed a partisan gerrymander. So after Rucho, so that was before Rucho, that had already started to happen. But after Rucho, state courts began interpreting their own state constitutions and crafted state-specific standards to police partisan gerrymandering. And there's 2 ways in which this can happen. There's direct language that you can find in your constitution. So in Florida, there's explicit language about the permissible role of partisanship. And then there's this older language, things like the free and equal clause, or sometimes the free and open clause of state constitutions that can be used to police partisan gerrymandering. So after Rucho, there's this new division of labor between federal and state courts. So in federal courts, racial gerrymandering is still justiciable. The court will still hear cases of claims of the Equal Protection Clause where there's violation of minority rights in federal courts, but they're not going to do that for partisan gerrymandering. But state courts will do that or can do that. And I think it's worthwhile to note that state courts generally don't police racial gerrymandering, though you can imagine that they could. New York recently passed their own Voting Rights Act into their state constitution, and Pennsylvania it has language that is very resembling of the federal Voting Rights Act in their constitution as well. So depending on what the US Supreme Court does in some of these racial gerrymandering cases could also change what the rule of state courts are there. So there's this double standard from Rucho too. It says that, while they're saying that these claims are not justiciable in federal court, they also said that they weren't going to toss these complaints about redistricting to echo into a void, right? So they left some options available to states, such as amending their constitution and having legislation placing power to draw electoral districts into the hands of independent commissions, mandating particular district criteria for their map makers, or prohibiting drawing district lines for partisan advantage. So those are the 3 things I'm going to focus on. But the double standard here is, some ways, is that now there are claims being brought in Moore versus Harper that actually in congressional redistricting, only the state legislature has the power to draw the lines, not state courts. But in the Rucho decision, the majority explicitly said that state courts can do this. So an important difference between the previous decade and the current decade of redistricting is that many more states have commissions that they have been set up to take the power away from the legislatures for drawing their districts. So 8 states, Arizona, California, Colorado, Idaho, New York, Michigan, Montana, and Washington have commissions that draw the lines. The 3 other states have backup commissions, Connecticut, Indiana, and Ohio. And this was seen as a way to take the power or the self-interest away from legislators in drawing their lines. Of course, that's been with mixed results. The map in New York was overturned by the state court, which I'll come back to. And the map in Ohio, it's a complicated rule that they have in Ohio, but essentially the legislature had the first crack at it. They had to get a supermajority and failed to get a supermajority. So it went to a commission, which is essentially a political commission, who refused to draw a fair map. The state courts have said, that's an unconstitutional partisan gerrymandering according to our Constitution. But the state court has no power to actually implement their own plan. And so it went back to the legislature, and the legislature drew their plan on a simple majority vote. And that plan will exist for 2 years. And then they'll have to redraw the plan after the midterm elections. 14 states have language that have some kind of prohibition on partisan gerrymandering in the direct language. This kind of language has things like you can neither favor nor disfavor an incumbent, a candidate, a party, or a group, some combination of those. You can't use partisan data, or some constitutions require, like Arizona's requires competitive districts. 26 states have this indirect language, this free and equal, free and open kind of language in their constitution. And again, Pennsylvania was the first state to use this language. Immediately after Rucho, the state courts did not hold a new trial. They had only briefing. And in that briefing, they used the evidence from the Rucho decision in the federal courts to show that there was a claim of partisan gerrymandering, used that evidence and forced the legislature to redraw the maps for the congressional districts in North Carolina. So what's the difference between the previous decade or previous decades and this decade? So one is this rise of commissions. Many more states have commissions. This other thing that's sort of different between 2010 and 2020 is the number of states in which you have unified government, where the legislature is the same party of the governor. So in places where legislatures still have that power. And what you really want to look at here is on the 10-year period, so 2010, 2020. So here, and you can see the Democrats had very few trifecta governments in 2010 compared to Republicans. The number of trifecta governments for Republicans is only slightly down in 2020, and the number of Democrats is up. And so one result of this decade's redistricting is that Republicans don't have that huge advantage that they had in the previous decade. The advantage is much smaller. We also had a delay in the census, which is, very critically important to understand this cycle's redistricting, because for those of us who actually were drawing lines, as I did in Pennsylvania, it was a long wait to get this data. We really couldn't do anything until we had the census data that normally is delivered by April 1st and didn't come until August 12th. And even then, it was only coming in sort of this preliminary way. We weren't sure what was going to be the final version from the census, because there was this administrative failure of the census over the last several years that they were trying to undermine the census. And so nobody was really truly understood whether we could trust the data that was delivered on August 12th. Indeed, it turned out to be the right data. But that delay of 4 months causes serious problems for redistricting, a very complicated and political process. Another thing that has changed is that we no longer have Section 5 of the Voting Rights Act. Section 5 required states that were under preclearance to have their plans verified by the Department of Justice ahead of time. And that meant that in places that had significant minority populations that had districts that were required by the Voting Rights Act, we're going to, largely draw those districts because they had to be approved ahead of time. And what we saw in this decade was that they failed to draw those minority districts. And in America, the correlation between the voting habits of minorities and Democrats is extremely high. And so when you don't have minority districts drawn, according to the Voting Rights Act, you also cause a partisan gerrymander. So we believe that Alabama and Louisiana should be both considered racial gerrymanders, but also partisan gerrymanders. And because of the census delay, it meant that policing and the no longer having preclearance, you have more Section 2 cases potentially out there, but less time to actually do something about it. And what we see is that the US Supreme Court, even though Alabama and Louisiana successfully were challenged, those plans were successfully challenged under Section 2, the Supreme Court put stays on those and are allowing the unconstitutional maps to be used in the next cycle. And so in this 2022 election that's happening in less than a month, we're going to have these two states have unconstitutional maps, and then other states that were not able to actually police their Section 2 violations are going to be used with these maps that are potentially illegal. And of course, the court heard the Alabama case just earlier this week. And so that map, as of right now, and that map and the Louisiana map are scheduled to be redrawn after this election. But depending on what the US Supreme Court rules, ultimately will decide that. So I don't know what the time is.
Your time right now.
Oh, okay. So I'll stop then and let Sam go.
Is there some punchline that you want?
No, you can go.
I'm sorry.
You're good. I didn't see it.
Oh, she's been pulling aside. Yeah, I'm watching her like a hawk.
Why don't you throw something at me, Sam? We're friends.
We are friends. And I think during question time, I think you do have things that may come up during question period. So I think that'll be good. All right. Thank you so much, Jonathan, who I will now refer to for the audience online as Dr. Servas, because that's we're on the record, we're recorded. Very important to be respectful. Okay, so we are now in the mid-afternoon, and we're in that time in the afternoon, so I'll try to not be too long. Dr. Servas said something interesting at one point where he pointed out that in Colgrove versus Green in 1946, questions of apportionment were deemed not justiciable. And yet 16 years later in Baker versus Carr, it turned out that they were. And I find that fascinating, that questions that we now consider fundamental, one person, one vote, the equality of population of districts, these questions evidently can be viewed differently by the Supreme Court over the span of a few decades. And I take some positive feeling out of that. Today, my topic is the independent state legislature doctrine. And most of you have heard of this, the idea that state legislatures face relatively few constraints on their ability to draw districts. And this is a fairly dramatic proposal. And my main message to you today is that is partly good, which is that I think it's my own view based on analysis of data, is that it is unlikely this year produce doctrine that needs to be unwound. So unlike Colgrove, which stood for 16 years or so, this is a situation under which I think that for strategic reasons, it is relatively unlikely to produce doctrine. I suspect that that's not going to happen. Now, I'm not a lawyer. I'm a scientist. I'm a data guy. And so I'm not going to present you with a legal argument as to why that's the case, but I am going to present to you an argument based on data and a raw calculation of who stands to benefit from this doctrine. And I think, as they say on the web, the answer may surprise you. So, then you click it and then you click through, right? So the fundamental issue in analyzing such a situation is that different states have different rules for redistricting, different levels of reform, and different mechanisms by which an injustice can be redressed. And all of these difficulties mean that it's necessary to basically analyze all 50 states. This is a deep dive that in the format of today's presentation, you can be grateful that I will not talk about all 50 states. So, but let me just remind you of what is at stake here. This is just a simple cartoon example of a hypothetical population between supporters of one party or the other. And let's call them the greens and the purples. And if you were doing this at home on Zoom, you could take a screenshot of this and I'll count to 5 in my head and let you screenshot it. Oh, it's still, what are you talking, it's like right up there.
Online, they're not.
Hey, have I been like giving a talk with Jonathan's slides?
Just briefly, I sincerely apologize. I'll fix this here momentarily.
I just can't even. Okay, yeah, luckily I've been just like, it's all lined up. I'm gonna do this, I'm gonna do this, now I'm gonna do this.
My sincere apologies here. This should work now.
Okay.
Yes, I'll confirm on.
Okay, now everybody online, take a screenshot of this while we're doing this. Okay, I'm gonna assume that's okay. So the idea here is that you could screenshot it, you can do it with your camera here, and ask, okay, if you wanna draw 6 districts here, could you draw 6 districts that advantage the green side, or can you draw 6 districts that advantage the purple side? And the point of this, if you are good at looking at these things, is as follows. It is possible to draw reasonably attractive districts that either advantage the green side to give them 5 districts. Is it okay now, Kyle? Okay, so 5 green districts and 1 purple district, and the same population pattern, and I assure you that it's the same. You can kind of uncross your eyes and figure out that it's the same pattern. Or you can have 4 purples and 2 greens. And what that means is that it's obscured by the little annotation thingy up there, but what it means is that gerrymandering puts up to half of a state's seats up for grabs. And so that's the kind of thing that's at stake. And so although we get worked up about things like voter ID and other things that are of course essential to our democracy, it turns out that there's this choke point, this narrow bottleneck through which democracy is in fact vulnerable, and it's made vulnerable every 10 years. Now, this is an American achievement. We have at least one comparativist in the audience, as they say in political science, there are Americanists and comparativists. If you look at a survey of experts about government that was published a few years ago, it turns out that gerrymandering is a uniquely American achievement. If you ask people to rank, experts to rank, how bad is gerrymandering in different countries? In Israel, there's no problem because in Israel it's proportional representation. In the United States, it's quite bad because legislators often draw their own lines. And so this is a problem that we have in our own country, and it's fairly specific. There are some other countries. In the last few years, Hungary has escalated in this ranking. Hungary turns out to have terrible gerrymandering, which is a whole other story. Now, we hear about gerrymandering a lot in the press, and we hear about it as a factor that reduces competition and also favors one party or another. And Ellen Weintraub accurately pointed out that reducing competition is always bad and is sometimes obscured by fans of horse race. But I'm going to be a horse race guy just for a moment and point out that something good happened in the last 10 years. The good thing that happened in the last 10 years at the congressional level is that the United States House of Representatives went from the least majoritarian national question to the most majoritarian. Where 10 years ago, one party, the Republicans, were able to win a majority in the House with as little as 46.3% of the vote. And this year, the best estimates are that it's more like 49%. And if we believe the House of Representatives to be truly representative, we would like that number to be close to 50% so that neither party is favored. And right now it's not perfect, but it's a smaller advantage for one party than is present in these 2 other national questions. And so I would say that in a limited sense, that's good. It doesn't address questions of competition. It doesn't address questions of court action and so on. But at least for this brief moment, we have a relatively good equilibrium where the partisan advantage is less than a third as large as it was 10 years ago. Now, that is in part because of a national stalemate between the parties. There are a few things that Dr. Service talked about, one of which is the action of state courts. Another is the rise of independent commissions. And then third, a little bit of divided government here and there. And those factors have led to be harder to commit gerrymanders. And now what we see here is just a slide showing in the 2010s, 10 years ago, there were 7 extreme gerrymanders as determined by statistical standards that my group has applied. But in this most recent cycle, there were 9 to begin with, and then that's been trimmed down by courts down to 5. It's not great, but anyway, it's better than 10 years ago. So we're at some kind of stalemate, but now something has come up to threaten that stalemate. Now, as I said, I'm a scientist, and that's my disclaimer. I have a different way of looking at these things. When we talk about checks and balances, a diagram appears in my mind. And the diagram that appears in my mind is the one that's up here on the screen in front of you. And the idea here is that when one body influences another body, you can represent that with a pointy arrow, like voters who may themselves be polarized will vote for legislators who they themselves may be polarized. The president may appoint judges, and those judges stick around for a while. And so this little math thing, this integral sign here, dt, that means that they stick around for a while. And so these arrows are causation. Checks on power are these things that look like the opposite of arrows. They're like these blunt things. Imagine them as like when you put a foot on the brake in your car. When you put a foot on your brake on the car, your foot's like this. And so these blunt symbols here are brakes on power. And you can see here that the fundamental thing that we're talking about here, partisan gerrymandering, is the state legislature dealing itself into power through redistricting, building itself a lasting advantage that lasts for a decade. And you can also see here that these three square things that are pointing at the state legislature are, in fact, let's see if I can get it, to work. Let's just do it with the annotate tool. Right, so we have state and federal judges who may, in fact, constrain the legislature by striking down a plan. The governor may veto a plan, and independent commissions may take the place of the state legislature and take away their power. And so those three mechanisms, those checks on state legislative power, are means by which runaway state legislative power can be constrained. And I'm just showing you this because this is the way I think about it in my mind, and I'm sure you have your own model of it. The reason I'm showing you this diagram, this kind of funny flowcharty diagram that's engineering style, is that I made this before the independent state legislature doctrine reared its head. And I found out that this diagram actually turned out to be kind of useful, not in a good way. Okay, so now there are some what I would call threats to redistricting based rights. Dr. Service talked about these, and I'm just going to use shorthand, and this is fine that I use shorthand because he's explained them pretty well. One is the Purcell principle. If you get too close to an election, you wouldn't want to disrupt the conduct of the election, so you leave things alone. And this Purcell principle has been used more and more in a fairly variable, is there a problem?
And it's always too close.
Thank you. Yeah, all right. From the audience, thank you. You know, you can travel to another place, but I always bring Princeton with me. That's Dr. Appel in the audience for those of you who are on Zoom. Okay, so Purcell, the principle that the election's getting too close, and therefore you should probably leave well enough alone. This year, I think it's safe to say that there's some fair amount of hostility to the Voting Rights Act. There has been for some time, and Section 2 is next on the chopping block. And I think I'm not telling any secrets when I say that proponents of Section 2 are probably going to be in for a pretty sad June when the decision comes down. But today, my topic is the independent state legislature doctrine. And the independent state legislature doctrine, let's see if I can do this, fundamentally asks the question, it uses the Supreme Court's power over these things to ask the question, do state legislatures, are they subject to other branches of government and other bodies when making their decisions? And so the idea here is that the Supreme Court, in exercising its power over redistricting, may itself start to exercise knock-on effects to these other safety valves, these other brakes. For instance, they may say, as Chief Justice Roberts said in a dissent in Arizona versus Arizona Independent Redistricting Commission some time ago, he said, the word legislature means legislature. And what that means is you can't give the power to an independent commission. Were that to be interpreted the way he advocated in that on the losing side of the 5-4 decision, independent commissions would lose their power. Another more aggressive interpretation would be the idea that even the governor himself or herself cannot block a legislature's action because the word governor does not appear inside the word legislature, right? So this is I'm giving you the broadest possible interpretation. So now what I want to do is I want to show you, first I want to just briefly mention that if you want to read about this more, I rather enjoy this history of this independent state legislature doctrine, which you can't see it because of the captioning, but it's by an author named Hayward Smith. And I encourage you to look up this article. It describes the history of this doctrine. And I just want to point out very briefly, without getting too much into it, that the doctrine emerges from the phrasing of Articles 1 and 2 of the Constitution, where state level power to regulate federal elections is given to legislatures. And that's what I just said. And there's a long history of this being interpreted in terms of other bodies having authority over the legislatures. They include the very first state constitutions and the very founding of the Republic. They also include cases in the last 100+ years that are, I think, well known to scholars of election law. You can look up the Hildebrandt case. You can also look up Smiley versus Holm. And these are all cases that reinforce the idea that state legislatures can be reined in by forces acting within the state. So then the question that is more or less live now is, how much of the role does the word legislature leave for state courts? And the two cases that are, or at least until recently, were live before the court. The Supreme Court were Moore versus Harper, which you heard mentioned a few minutes ago, also Costello versus Carter. Now, as Jonathan said, there are principles in state laws and constitutions that can, in principle, be used to regulate state legislatures and partisan gerrymandering. All 50 states have guarantees that are equivalent to the First Amendment protection of freedom of speech. Nearly all of them guarantee freedom of association. And there are also guarantees of equal protection. And then there's a guarantee in 28 states that does not appear in the US Constitution of free and equal elections. These guarantees, in principle, can be used by state courts to, in fact, do what was asked of the Supreme Court in the Rucho case, and they declined to step in. And the theory is fairly straightforward. It is that basically articulated actually quite well, ironically, in Gill versus Whitford. The theory is articulated by John Roberts, the idea that there is, in fact, a 14th Amendment. Let's see, I'm going to move Kyle over here so that people in the room can see. A 14th Amendment principle of unequal voter power and equal protection argument. And then Justice Kagan says, well, the First Amendment also does it through viewpoint discrimination, right? You should not be penalized according to your partisan viewpoint. And so these principles were articulated clearly and in a very nice way by both sides. Ironically, even by Roberts in his Rucho decision, still actually does a reasonably good job of describing these harms, even at the same time declining to act. So all of this reasoning is available to state courts. Now here's some grading. My group at Princeton came up with a simplified method of grading maps, and we came up with this. It was covered by Axios. And what the Axios people did is they made it into an attractive table. You can see here that some states with independent commissions or some otherwise neutral process got A's and C's, and this is all based on statistical measures. So we have an automated pipeline that the plans go through. We didn't, we looked at the plans, but it's an automated process. And these F's here, this bad report card, consists of states where single party control is present. And these trifecta states where only one party had control all came up with plans that were extreme in their favoring of one party or the other. But what I want to point out here is that what's blocked here is, pause for a second, it says New York behind the caption. But what I want to point out here is that several of these plans were in fact struck down or modified substantially. New York, Maryland, North Carolina, all of those were in fact struck down by courts. Ohio, they tried, but there are some difficulties, which I think we've heard about already. So this is the mechanism that then is at stake. And now I'm going to very briefly in the remaining minute or two talk about how these may play out if we were to take the independent state legislative doctrine seriously. First, let me talk about independent commissions. There are these binding commissions that have the force of law that can override or just not involve the state legislature at all. And several of them came into use this year. Mostly independent commissions. Virginia's a funny hybrid commission. But these commissions gain the power of redistricting, and they are in part responsible for the increase in relative fairness, and in some cases, the increase in competition in congressional elections that we saw in this year's redistricting. So let's see, my slides are a little bit out of order here, but it's probably good because I'm nearly out of time. On the left are some intended consequences of proponents of the independent state legislature doctrine. And this little shorthand here, these little runic things that I have that say +3R and +1D, these are how many races become advantageous to one party or the other as a consequence of the independent state legislature doctrine. So for example, if this doctrine is upheld in Moore versus Harper, then North Carolina's map may change, and that will be advantageous to the Republican side for several seats. Independent commissions, if those are struck down, there are currently 3 competitive districts, congressional districts in Arizona. Those may in fact go away, and so those will in fact maybe become more advantageous to Republicans. Eliminating the governor's veto may in fact be advantageous. Let's see, I have this a little bit backwards here. I'm sorry, just pause for a moment. Independent commission elimination would be good for the Republicans. Eliminating the governor's veto would actually be good for the Republicans as well. But let me just concentrate on the right-hand side of this and point out that there are some opposite unintended consequences. Although the litigants in North Carolina and Pennsylvania are Republicans, there are unintended benefits that may come from taking state courts out of the picture. It is said that several districts may become more Democratic if there is no role for state courts in New York. In Maryland, we saw play out a process in which the Democrats' advantage was reduced by state court action. And so taking state courts out of the picture may, in fact, create an advantage of relatively 3 seats in those 2 states. Having no independent commissions may lead to a large advantage for Democrats by putting redistricting into the hands of a single party legislature. Eliminating the governor's veto has peculiar effects that I don't really have time to get into, but because of an intra-party dispute between Governor DeSantis and the legislature in Florida, and here in New Hampshire between Governor Sununu and the legislature, I'm looking at one of the parties in this dispute, these may in fact lead to, again, unintended advantages. My point being that these unintended consequences are in some cases larger than the direct consequences of these legal cases. And what that means is that a consistent application of the ISLD would not lead to a net advantage for the litigant's party. And it is possible that the application of this doctrine could be not only neutral, but of net advantage to the Democrats. And I think that if you follow closely the political predilections of all the players in this, you might think, if I'm on the Supreme Court, I might stop and think about that a little bit. So the most recent change in this is that Costello versus Carter, which is a case challenging the governor's authority and challenging state authority under the Article 2 grounds, says, well, you know what, you should also use the US Code about on how to impose congressional maps. This is a wacky one because it turns out that if you look up US Code, if you look it up, it says this phrasing, and just to translate it to be brief, what it basically says is that because Pennsylvania lost a district, all the representatives will be elected at large. And that means that this case, were it to be won by the litigants, would either gain 9 seats for the Democrats or 9 seats for the Republicans. Okay, so it's like this big shoot the moon, if you ever play spades. It's like shooting the moon, and it's this giant advantage that would go to one party or the other. So just a few days ago, the court decided not to go forward with that. They did not grant cert. And so the Supreme Court's not going to hear the case at all. So why is that? And I was puzzled by this, and now I turn to my favorite legal scholarship resource, which is Twitter. And I asked Rick Pildes, Nick Stephanopoulos, and Ian Millhiser, what do you think? And, you know, Twitter gives you what you put into it. And it turns out that if you ask people who have thought about this a lot, you can get some pretty good answers out. And so rather than sending me cat videos, they actually sent me kind of useful answers. So Nick Stephanopoulos says, sounds like they're not interested in the most sweeping form of the theory. And Ian Millhiser says, sounds like they want to maximize their own discretion to intervene when something they don't like happens. And so roughly speaking, I think that the kind of calculation that I've shown you suggests that neither party is going to get a big advantage out of it. And there's an outside chance that Democrats may get an advantage out of the independent state legislature doctrine. And it happens no matter how you slice it up, whether you do away with the governor's veto, whether you do away with independent commissions, or whether you do away with state court involvement. And there's just no way to do it consistently. And so what I would suggest is, just as a speculation, they're not going to do something consistent. So I will leave it at that and take questions. Thank you.
Thank you very much. I want to open it up first to questions from the audience for either Dr. Service or Dr. Wong.
Mid-afternoon.
So with respect to state court holdings against the legislative plans, to what extent do the courts themselves vote along party lines? And to what extent are elections for justices then the determining factors over these long periods for which judges are retained or new judges appointed?
There are legal experts in the audience who know the answer better than I, but I would summarize this briefly as state courts used to have less of this issue, but there is more and more concern at the level of state courts that judges at that level may be more susceptible to partisan concerns. And so the polarization that one sees at the level of the Supreme Court is also present at the level of state Supreme Courts. And I'm looking at some experts that I know in the audience just to see whether they disagree with me or not, but that seems okay. It's like, okay, so evidently I'm close enough to okay that I'm not getting corrected. So so that would be approximately. So anyway, but in seriousness, it is possible to see from the partisan leanings of the justices in places like Wisconsin, North Carolina, and Ohio, it is possible to guess how most of them may rule. And occasionally there are some people who are somewhat surprising, but broadly speaking, one can take a pretty good shot at guessing how they're going to vote based on knowing prior facts about them. I think that seems like an okay thing to say, right?
Yeah, I'll defer to others if other people have questions. But...
Sam, on the ISL doctrine, I take your point, and I'm in agreement that they're not going to do the maximalist version of this. If I had to bet, my bet is that they're going to try to slice the pie, so to speak, by saying that the kind of generic state constitutional language that both of you were talking about, where it just says free and open or free and fair elections, that is off limits to a state Supreme Court that uses that vague clause to functionally give it the power to act like a legislature in drawing maps, but that a state constitution that is specific in its standards, like Florida's or others, as long as it's a clear enough rule that the judiciary enforcing it is acting as interpretively and not legislatively, that would be okay. So if that's how they cut the baloney, so to speak, do you have a sense again of the consequence of it being that narrow a ruling?
So for those online, Professor Foley has just brought up the point that there are state laws and constitutions that explicitly have fairness standards, like Florida and Virginia would be examples that come to mind. I mean, as opposed to these, my optimistic galaxy brain view that all 50 states have freedom of association, or 47 of them do, so let's do that. It'll be brilliant. I think that constraining that still prevents, if I remember correctly, the state of Maryland and the state of New York from intervening. And so it could be that they do that, but it still creates a situation in which both partisans on both sides of the aisle may benefit from even such a narrow ruling. And if they want to do that, they can, but what they leave the door open to is Maryland and New York, let's say, doing mid-decade redistricting. So I think it's pretty hard to come up with some snaky, clever rule that advantages one side or the other. I'm not engaging with the doctrine at all. I'm just saying, I'm just doing the partisan calculation. Now, as a general point, yes, it is possible that they might say, yeah, you're reading too many rights into your state constitutions. That's certainly possible.
I just one quick, just a prediction on this is based not just because of the doctrine's effect on gerrymandering, but the doctrine's effect on other aspects of election law. I mean, I think the case that they're most concerned about actually is also out of Pennsylvania, but it was the extension of the time for submitting absentee ballots, where the Pennsylvania Supreme Court extended it by 3 days. And I think they want to disable state courts from doing that sort of thing.
My general impression is that it is true that state courts will often defer, or I think the word that gets often used when one searches for these things is lockstep, where rights at the state level and the federal level often get interpreted in a similar manner. I mean, I certainly agree that they may say you don't get a second bite of the apple under state constitutions. But I think that we were talking about this earlier, we're living in somewhat unusual times where even the legitimacy of the Supreme Court, I wouldn't characterize it as being, well, I don't know how to characterize it. Let's just say it's under the discussion. And the fact that it's under discussion means that we're entering somewhat unusual territory. And so I think that we may be entering a period of change in the tension between federal and state courts. And I don't know, it just seems like a pretty tense time, I would say, for jurisprudence.
We have time for maybe one more question. All right, with that, join me in thanking our panelists. Our next panel concerns what I've broadly termed the security of voting. Our first speaker will be Professor Andrew W. Appel. He is the Eugene Higgins Professor of Computer Science at Princeton University, where he served as department chair from 2009 through 2015. He received his PhD in computer science from Carnegie Mellon University. He is a fellow of the Association for Computing Machinery, and he works on formal methods and tools for verifying the correctness of software, on cybersecurity issues, technology policy, and particularly voting system security. He has co-authored the National Academy's 2018 study, Securing the Vote, and he has given expert testimony in a wide variety of cases, including topics of digital copyright, antitrust, and voting machines, and a wide range of other cases. He blogs regularly at freedomtotinker.com, explaining tech policy issues to the public. And our second presenter is Professor Eugene D. Mazo. He is visiting professor of law at Seton Hall University School of Law and a nationally recognized scholar of election law. Professor Mezo's research focuses on voting rights, campaign finance, redistricting, and the regulation of democracy both in the United States and around the world. His publications include The Best Candidate, Presidential Nominations in Polarized Times from Cambridge University Press, and Democracy by the People, Reforming Campaign Finance in America, also from Cambridge University Press. In 2021, Professor Mezo served as the chair of the section on election law at the Association of American Law Schools, the scholarly organization that governs law schools in the United States. Professor Mezo's writings examine the laws that regulate our democracy and seek to make them accessible to broad audiences, and he has taught at several law schools throughout his career. He is a graduate of Columbia College, and Professor Mezo holds a master's degree from Harvard, a doctorate in politics from Oxford University, and a law degree from Stanford. The son of immigrants, he was raised in Newark, New Jersey. And without further ado, I'll start off with Professor Appel. Thank you very much.
Thank you. In the 20th century, most people didn't pay much attention to the technology of voting until about November of the year 2000, which was pretty late in the 20th century, when we started to pay attention to punch card voting systems. And punch card voting systems are a truly terrible technology. The chads fly out of those things in between counting. And in fact, the US Congress banned punch card voting systems in the Help America Vote Act of 2002. And so all those states that had been using optical scan voting systems didn't have much of a problem because optical scan voting systems work pretty well and are not unreliable in the ways that punch card voting systems are, but other states had to find something new, and many states turned to touchscreen voting machines, such as these. And the problem with touchscreen voting machines that have no paper trail, you just touch the screen and some computer program inside decides how to interpret what that means and which column to add +1 to, and at the end of the day decides what numbers to print out, is that whoever programs that computer gets to decide what the election results are. And if the legitimate program installed by the manufacturer is in that computer on election day, then it will pretty accurately count the votes, and otherwise it will do whatever it wants. So the way you can commit election fraud with a touchscreen voting computer is you write a computer program that on non-election days accurately counts the votes. So when you do your logic and accuracy testing on that thing, it'll be very accurate. But on election days, it moves 20% of the votes to the wrong column in the direction that you favor. But on the screen, light up the same candidate that the voter selected. So the voter can't see anything wrong. And pre-election logic and accuracy testing won't see anything wrong either. And then you have to load your program into those voting machines by, for example, exploiting vulnerabilities in the software update process or having insider access to the voting machine warehouse or, other means, convincing the election clerk to let you into the voting machine warehouse to carry a few voting machines out. Starting around 2003, computer scientists and others started explaining this fatal flaw of touchscreen voting machines to policymakers at the national level in the Congress and at the state level and at the county level, and not much changed at the national level, but at the state and the county level, actually, state election officials got it. And the vast majority of states that had been using touchscreen paperless voting machines abandoned them by about 2012. With a couple of exceptions, backward states such as Louisiana and New Jersey. But that was a policy success. Optical scan voting machines can also be hacked. They've also got a computer program in them that's deciding how to interpret the marks. And there are all sorts of ways to hack optical scan voting, but underneath that optical scan voting machine, the little white box in the picture, is the ballot box, the blue box in the picture that has all the ballots that the voters actually marked with their own pens and that you can recount by hand. And without any computer program interpreting to you how the votes were, you can see what the votes are. And that is really the only reason that optical scan voting systems are more trustworthy from a computer science point of view than touchscreen voting systems. But, you know, optical scanners can malfunction even if they're not maliciously hacked. And this is a picture of the polling place in Windham, New Hampshire, where in a recent election, some optical scan voting machines got things wrong by mistake. It had to do with the combination of folding the ballot so that the phone line, you know, crossed one of the ovals, plus an accumulation of dust over the sensors of these machines that hadn't been cleaned recently. And it turns out that dust comes from the offset printing process used to print paper ballots. So who would have thunk it? And so that's, again, why it's important that one can recount the votes and get it right. And in New Hampshire, they did recount the votes and got it right, and even took the extra step of having a forensic examination to figure out what went wrong. And what I told you about what went wrong was not obvious at the beginning until they went and did a careful investigation to figure it out. So the scientific consensus, as reported by this consensus study report from the National Academies of Sciences, Engineering, and Medicine. A consensus study report is where they gather together a bunch of scientists, but in this case, scientists and election administrators and political scientists and law professors to figure out what is the scientific consensus, not to invent new science, just to say what everybody knows. And what everybody knows is that based on this fatal flaw of touchscreen voting computers, for example, elections should be conducted with human readable paper ballots, and recounts and audits should be conducted by human inspection of the human readable portion of the paper ballots. So now let me turn to voting over the internet. There's some server that's counting up the votes, and there are client machines, that is, the voters' own personal computers and phones on which the voters are voting. And whether you're sending an email or you're sending a fax through your phone or computer, or whether you're using an app, this is the picture. And in between you, your computer, and the server, there's, you know, messages hopping over the nodes of the internet. What could go wrong? Well, there could be an insider who gets to install the software in the server that adds up the votes. And then the insider gets to decide who wins the election. But actually, the insider doesn't have as much control as he thinks, because the hacker over the internet can hack into the server, exploiting a vulnerability in the server operating system software, and install fraudulent vote counting software in the server, or a fraudulent operating system underneath that vote counting software that pretends to run legitimate vote counting software, but really runs fraudulent vote counting software. And can servers on the internet really be hacked? Do I have to ask that question? But I'll just give one example. The District of Columbia implemented an internet voting system in 2010 and invited, 4 weeks before the election, they invited hackers to try and break into it in a 2-week period to test it, and then they were going to run the election. Now, 2 weeks is a ridiculously short amount of time to run a real study. And if you were really going to hack into an election system that counted, you would have years to prepare for it. And if it required a lot of effort to think about how to hack into it, you would want to only do it when the stakes are high enough, And the $20 billion cost that Ellen Weintraub talked about to, to influence elections in the US is sort of high enough stakes to make it worth hacking. But in the 2 weeks, hackers did break in and completely took over the whole internet voting system. It was Professor Alex Halderman and his students at the University of Michigan who sort of took over the entire internet voting server system and the security cameras that were watching and everything. So they could even see the election officials running around trying to figure out why, when people were voting in the test election, that the music at the end was the Michigan fight song rather than the sound that it should have been. Okay, so, but really, that's not even the worst of it. The worst of it is vulnerabilities in the client computers. Because at least the servers, you could hope, could be professionally maintained by people that know something about modern practices in computer security, right? They should be, as securable as servers can be, which is not all that securable, but better than nothing. But the voters' own computers, who knows what they've got at home? They've got their Android phones and their iPhone phones and their Windows systems and their Macs. And so the first question is the insider who got to write the software that is the client voting application. Because what could the client voting app do? It could display to you your choices on the screen, but then when it packages up the ballot to transmit over the internet, transmit something different. And that ballot is encrypted and authenticated, so it can't be messed with as it goes over the internet. But if it's already been corrupted by the voting app to include the wrong votes, then all the authentication and encryption won't help you there. But the insider who wrote the voting app is not the problem. It's the hacker who breaks into your client computer, your home PC, your Android phone, whatever, and hacks the operating system so that the voting app is running incorrectly. And in between displaying your completed ballot to you so that you can review it and accept it, and then packaging it up for transmission, can replace the votes. So, we ask these questions. Are the votes displayed on the screen the same as the votes actually transmitted by client software over the internet? Not if it's been hacked. And, is the server adding up the votes correctly? Not if it's been hacked. And, I could explain why computers are insecure these days that make it possible to hack your machine or the server machine. It has to do with all these different layers of software that are present on any of your computers now that make it easy for people to put together apps by just picking and choosing existing software layers. But each of them is, bugs in any of these layers can serve as vulnerabilities, ports of entry for hackers to, corrupt the behavior of that layer. And if you can corrupt the behavior of any single layer, then you can sort of ignore what's happening at all the upper layers and use your own fraudulent software instead on the upper layers. So the clear scientific consensus as of 2018 in this National Academies report was the internet should not be used for the return of marked ballots. No known technology guarantees the secrecy, security, and verifiability of a marked ballot transmitted over the internet. And that's the scientific consensus, essentially for the reasons I just explained. The United States Cybersecurity and Infrastructure Security Agency explains it this way. Electronic ballot return is high risk. And there's no mitigating technology that can be used to mitigate that risk. All again for the reasons. But look at the last line. Electronic systems provide the opportunity to rapidly affect voting at scale. What does that mean? There's been election fraud of one kind or another, usually by the insiders, not by the voters, for 250 years. It's a grand American tradition. We hope it's much mitigated from the excesses of the past, but a lot of that election fraud requires being there in the precinct and mucking with physical boxes of ballots and physical tallies. And 200 years ago, it wasn't possible to sit over here and change millions of votes half a continent away or 2 continents away. And at scale, right? Electronic internet-based computer hacking allows one person somewhere to hack into 1 million other computers and change votes. That's very dangerous. So let me go back to the earlier timeline of internet voting. The Department of Defense tried to make a voting system in 2004 to allow overseas military voters to do absentee balloting over the internet. And they made this experimental system. They commissioned a report of it. And the report basically said, the engineers who built the system are pretty sophisticated. They understand the current principles of computer security. They didn't screw anything obvious up that could have been done better, but the system is still inherently insecure. And, a secure all electronic remote voting system is essentially impossible to build in the year 2004. And so the Defense Department abandoned internet ballot return and concentrated instead on allowing online access to voter registration for military voters overseas, and online requests for absentee ballots, and in many cases, electronic delivery of the blank unvoted ballots to the voters where they could print them out and fill them in by hand and then mail them back. But the MOVE Act of 2010 did not require states to adopt the electronic return of voted ballots. It was sort of informed by, for example, the SERV report. Other countries and states did try internet voting. Estonia uses internet voting in addition to hand voting, and it's been found to be seriously insecure. The District of Columbia I've already talked about. Australia deployed an iVote system that was found to have severe vulnerabilities. Still uses it here and there. Switzerland deployed an internet voting system, and in my paper in the symposium, I write more about that. After outsiders found severe security flaws in that system, the Swiss government hired those outsiders to actually write a formal report, plus some other academics, and after the formal reports, they suspended the use of the system. Votes is a company in the US that sells internet voting systems. It was deployed in West Virginia in 2020. Researchers published a paper in which they described severe security flaws in votes. West Virginia switched to something else, which was actually OmniBallot from another company. Researchers published a paper in 2020 about severe security flaws and privacy flaws in OmniBallot. And I don't have a lot of time, but the security flaws in OmniBallot were unsurprising. I've described to you this basic science of you can't do it securely. What was amazing was the entirely creative new ways OmniBallot found to compromise your privacy. Who would have thunk it? All right, so, I told you that internet voting is insecure, and it's no surprise that that internet voting system is insecure, and that internet voting system is insecure, and that one, and that one. How many more internet voting systems do we need to examine one at a time before we remember that internet voting is inherently insecure? But there are two communities that really do have a problem with conventional in the polling place paper ballots or even vote by mail absentee ballots. And that's overseas voters with slow mail service and voters with certain kinds of disabilities that prevent them from being able to mark a paper ballot with a pen. And we should not forget those voters who have a legitimate need for a solution. And I've already told you what the solution was for the military voters, and it works also well for overseas voters, which is online access to the ballot and returning it on paper by mail. Part of the MOVE Act was to give those voters more time, right, which inconvenienced the secretaries of state and the local election officials who have to get their ballot put together 45 days in advance so that there's enough time for it to be returned. And that set of solutions stops short of internet voting, but is adequate. And what's not securable is returning a marked ballot by email, that's internet voting, or by fax. And I've written in the paper about why actually fax these days is just the internet. We don't have a fax machine plugged into a landline. This is the 21st century. But 23 states permit email return of ballots for military overseas voters. 29 states permit return by fax, and so on. So overall, 30 states permit this in some form, and that's a bad idea. The solution for voters with disabilities who can't mark a paper ballot with a pen, there are two real solutions. One is the use of a ballot marking device in the polling place that may have an audio interface for blind voters, for example. Or, voters can request assistance from a person if they have a disability to fill out their ballot for them. And that's not a perfect solution. Voters with disabilities would like to be able to vote independently, but there just is no scientific solution at the moment to voting perfectly independently, but also reasonably securely. And my right to vote is partly that your vote should not be hacked. Okay, so disability rights groups have been asking states to make certain accommodations, train poll workers how to accommodate voters with disabilities, make polling places wheelchair accessible, make their election websites, accessible to blind voters, which has to do with how the websites are programmed, and a thing called remote accessible vote by mail. And remote accessible vote by mail has to do with access to the ballot on your home computer in a way that you can fill it out on your home computer. But one version of it is that you then print it and mail it, which is not internet voting. And the other version is you upload an electronic ballot, which is internet voting. And there were 5 lawsuits in 5 different states in 2020. In Virginia, the National Federation of the Blind requested remote accessible vote by mail, but without electronic ballot return. That's perfectly reasonable. That was settled in 17 days. In New Jersey, the state was about to move to internet voting, form of remote accessible vote by mail. They were sued, and the settlement ended up being without ballot return, electronic ballot return. In New Hampshire, the state was sued. The settlement was improvements to the website, but no electronic ballot return. There was a lawsuit in several states that was it was dismissed right away. I won't go into that one. And in North Carolina, the plaintiffs asked for an accommodation, but they didn't say what. They left it to the court. Now, somebody I know who's a lawyer, I'm not a lawyer, said that that's pretty sloppy lawyering to not say what remedy you want. And it left to the court what remedy to apply. And the court said, well, this state already has this system installed for use of military and overseas voters. It happens to have electronic ballot return. We'll impose a settlement for the use of that system. So now North Carolina has a court-imposed internet voting system for voters with disabilities. Not a good idea. So I'm about done. There's more in the paper that I won't discuss now. And I thank you for your attention.
Hi, everybody. Hope you've had a good day. Thanks, Kyle, for organizing this, and the editors of the Law Review for organizing this, and the Franklin Pierce Law Center for having us. This has been such an interesting conference. My name is Gene Mazo. I'm going to talk to you today about a concept called ballot harvesting. I should say I'm not a specialist in ballot harvesting. I have increasingly gotten interested in ballots and what they have to do with democracy, which is I got interested in this because I'm from New Jersey, and ballots determine all outcomes of primary elections in my state, as Sam and Andrew know, who are also residents of New Jersey. And so I got an interest in this topic, and I'll tell you a little bit about it. What is ballot harvesting in the first place? You've probably heard the word mentioned. What does ballot harvesting refer to? Well, for most voters, I don't know how I click. For most voters, you go into a polling place and you cast a ballot in a polling place. But increasingly, as I'm going to explain to you in a minute, voting is happening increasingly in the states by mail, by absentee ballot or by mail-in ballot or whatever you wish to call it. And so voters are being mailed their ballots. How they get them varies from state to state, but voters are getting their ballots, and then the voter can go to the post office and mail that ballot back, but someone else can mail that ballot back. In other words, a third party can touch the ballot between the time that the voter fills out the envelope, and it's actually returned to election officials. So whereas in a regular voting booth, you walk in and you're surrounded by other election officials, here there's the opportunity, at least, for some third party to touch the ballot. States call this different things. Some of them call it third-party ballot return. Others call it ballot collection. The pejorative term for this is ballot harvesting, which is why harvesting is in quotes for me, because I'm not necessarily adopting that term. I'm just explaining to you how it works. Why is this problematic? Why is this problematic? Well, the theory is it could result in some kind of fraud. And we have a lot of rhetoric about this. For example, in 2020, President Trump changed his residence from New York to California, and then voted himself by absentee ballot from the White House. But he exempted himself and said, this is horrible. He tweeted, this is corrupt. This is rigged. Unfortunately, all those tweets were deleted. I've seen them, but they've been deleted, so I can't find them anymore. So even though one person voted by absentee ballot, this was the kind of rhetoric around ballot harvesting. And we can see on this, oops. Going back, we can see on this slide that searches for the term ballot harvesting, this is from a Google search, and I got this actually from the Stanford Internet Observatory that's written a little bit about this. You can see that even the term, if you look at it trending on Twitter or trending on Google, or when people do searches for this, it pops up and down and people get interested in this at various times, really reflecting the data shows what our politicians are saying about this. So for example, a Pew Charitable poll in the middle of the COVID pandemic, about 65% of Americans all across the country were in favor of allowing absentee ballot voting. And after some of these tweets went out, we had a difference among the parties. Pew tells us that 83% of Democrats supported no excuse absentee voting. This was at the end of 2020. Only 44% of Republicans did. And then Pew also said at the end of 2020, towards around the time of the election, how many people would vote by absentee ballot? 58% of Democrats said that they would. Only 17% of Republicans said they would. Now the evidence shows that there's no benefit from using an absentee voted ballot to either party. There's no partisan advantage. And what we find is in states that allow absentee voting, there's an uptick in the voter turnout. In other words, people that are already going to vote or already registered to vote are slightly more about 10% or 8% more likely to vote. But it doesn't help registration. So people who aren't registered don't all of a sudden go register. And we don't have a lot of studies of this, but we have 3 or 4 that are often cited. In the halls of Congress, we have seen, see if I can get this back. In the halls of Congress, we've seen the same kind of partisanship over this issue, over ballot harvesting. So for example, the Democrats wanted to pass the For the People Act, and it had a kind of a what's what of all the reforms, and Republicans wanted a reform to outlaw ballot harvesting for federal elections, and of course the Democrats didn't allow that to happen. Another Democratic idea, the SAFE Act, was the same thing. These are bills that Democrats pushed in the House, and ballot harvesting or anti-ballot harvesting provisions weren't added. On the other side, we have bills that are proposed by Republicans that, of course, all have ballot harvesting provisions or anti-ballot harvesting provisions. The Election Security Assistance Act, the Honest Elections Act, the Protect American Voters Act. None of them, all of them have some kind of provisions that would forbid this practice in federal elections. And of course, those laws go nowhere because Republicans have a minority in the House. The question that you want to ask is fraud a real problem in the United States? And of course, as most scholars know, in-person voting fraud is exceedingly rare. Yes, it happens from election to election, but there's only a few cases. And out of the millions of votes that are cast, these fraud cases don't really move the needle in any single election. But with ballot harvesting, we have had cases of fraud, and we've had elections that have been voided. So the gentleman here is named McCrae Dowless. You've probably read about him in the New York Times. This is a very famous case at this point. What happened in North Carolina was there was a Republican primary. The incumbent's name was Robert Pittenger, and he was challenged by a Republican named Mark Harris in 2016. The primary was decided by 134 votes. A congressional primary was decided by 134 votes. And out of a rural county in southeast North Carolina, there were 229 votes that were returned by absentee ballot. Out of those 229 votes, 224 went for a third party candidate, 4 went for Mr. Harris, who was the challenger, and 1 went for the incumbent Pittenger. So the North Carolina Board of Elections opened up an investigation into this, and Mr. Harris, who lost this race by 134 votes, went and found this gentleman named McCrae Dowless Jr., who, was a ballot harvester or a political operative. He paid him $130,000. And in 2018, those two gentlemen, Mr. Harris and Mr. Pittenger, the incumbent, went against each other again. That election came down to 828 votes. He paid Mr. Dowling $130,000, this time out of Bladen County in North Carolina, the same small rural county in southeastern North Carolina. There were 697 absentee ballots. 437 of them went for Harris, who won that election. Only 17 went for Pittenger. In other words, 2 years later, all of a sudden, a huge number of votes change for a candidate. Are there any other examples of ballot harvesting? By the way, this election was voided or wasn't certified by the North Carolina Board of Elections, and another race was held in 2019, a candidate more conservative than Bittinger or Harris, and won against the Democrat. Let's see if I can move this. Okay, we had a local election in New Jersey in 2020 in Paterson, not far from where I grew up in Newark. This was a city council election. New Jersey regulates ballot harvesting, whatever you want to call the practice, and what New Jersey does is it says that no third party could be the bearer, the state word is bearer, the bearer of more than 3 ballots. So you can return 3 ballots and you have to sign your name and then you have to certify, that you haven't returned more than 3 ballots in this election. This was a race for city council. I'm not going to tell you the candidates' names, I guess it doesn't really matter, but it was a city council race, and a stack of bundled ballots was found in a post office box. And then there was another county where there was a drop box, because remember, the counties run elections in New Jersey. There was another county in a drop box where there was another case of bundled ballots, and it was enough ballots to overturn the election, because the election was decided by just a mere few hundred votes. A state court superior judge threw out this election. The candidates ran again. One of them was indicted by the Attorney General's office. He actually won the election. Mr. Dallas, by the way, who was on the slide previous to this, died in April. Just a few days ago, 3 or 4 days ago, his 4 co-conspirators pleaded guilty to election fraud. In New Jersey, this prosecution hasn't ended yet. So we don't know what the outcome is, but one of the parties who's been indicted has, went ahead and won the rerun of the election. How do we get data on this issue? It's hard to do that, actually. The Heritage Foundation, if you believe their data, runs a database of fraud cases, and I'll just give you some data. In 2018, the Heritage Foundation said there were 73 cases of fraud within the United States. There is one category called fraud, abuse by an absentee ballot. 9 out of the 73, in other words, 12.3% of cases had to do with ballot harvesting. In 2009, it was 8 out of 34 cases. In 2020, the percentage went up. It was 5 out of 15 cases. So now we go up to 33%. But you can see there's small numbers. In 2021, it was 7 out of 21 cases. And already in 2002, I checked the database just the other day, we have 21 cases of ballot harvesting that are reported. And if you look at the websites of state attorney general's offices, there are cases of this that are reported. I don't know how they turn out. But there are cases where there's an indictment in Texas or in Georgia and so forth. And if you just Google the word ballot harvesting, you'll see lots of state attorney generals speaking about this, or state secretaries of state speaking about this. So I've given you some of the prominent cases. I've given you some of the statistics. I want to take you a little bit to the reality of what's happening to the states, because the point of my paper is to say that the rhetoric, the problem exists, but the rhetoric and the reality of what's happening in states is different. And the reality of what's happening in states is that states across the country, whether they're red, blue, or purple, are increasingly turning to absentee ballots. And we are increasingly voting by mail across the United States as a citizenry. Now, that's not the case everywhere. Maybe it's not the case in New Hampshire, but it is the case across the country. In most states, voting by mail has become increasingly easy. It's available to about 84 or 85% of Americans today. And in some ways, this phenomenon is not new. During the Civil War, soldiers were allowed to vote in some states by returning a mail ballot or an absentee ballot. And as you study the history of voting rights, you'll see that it expands with the military first for obvious reasons. That was the case during the Civil War. If we flip to 1975, Congress passed a law called the Overseas Citizens Voting Rights Act, the OCVRA, which allowed overseas citizens to request an absentee ballot. That law was amended in 1986. Slides are not moving with my lecture. They will. Okay. And we have UOCAVA, the Uniformed and Overseas Citizens Voting Rights Act. Some of us in the room have written about these laws. We're now military service people could also request and at the same time receive an absentee ballot. And then Andrew mentioned the MOVE Act passed in 2009, which amended UOCAVA. And now there was a 45-day period set for where overseas and military voters and their spouses and families had to get a ballot, and it had to be mailed by the states to them 45 days ahead of the election. This is the federal law that has allowed absentee voting for a long time now. In the states, absentee voting didn't really exist for a while. California became the first state that allowed what we call convenience voting, where a person could just apply for an absentee ballot just because the person wanted to vote by absentee ballot. And since then, the states have regulated this in various ways, and most people in the room probably know that some states are excuse states where you have to give an excuse for voting by absentee ballot. 35 states now are no excuse states, so you can vote by absentee as a matter of convenience. And this phenomenon was just totally revolutionized because of COVID 2 years ago. And in 2018, according to the Electoral Assistance Commission, something like 24 to 25% of Americans nationwide voted by a mail-in ballot. That percentage, of course, jumped in 2020 because of COVID. We don't have a good number in a non-COVID year in 2022, but the number is very close or just above 50% at this point. So lots of people are absentee voters. Now, states do this differently. Some you have to request a ballot for every election. Some you can request a ballot and be an absentee voter for a year or two. I'm now a permanent absentee ballot voter, so I just get an absentee ballot, fill it out, and return it. What we also have is a phenomenon of states moving to what we call universal vote by mail, where they run all of their elections in some way or another by mail. So Oregon pioneered this in 1998. Then Washington State joined in 2011. Colorado joined in 2013. Utah joined, and Hawaii joined in 2020. Oops, I got too many states there. Utah and Hawaii joined in 2020, and we had 5 states that were what we call universal vote by mail states. These states weren't actually, not everybody voted by mail. The truth is that you got your ballot by mail, and that there were different ways of returning it. You could return it to a drop box. You could return it to an election official. Or you could return it by mail. And then we have statistics about what percentage of people actually return the ballot by mail, and it differs from state to state. But these states were joined in this past year by Nevada, California, and Vermont. I wouldn't say we have 8 states that do this. I would say we have kind of 7.5. I think what Vermont is doing, if anybody is a specialist in Vermont, could correct me, I think Vermont is doing it for the general election, but not for other elections. And then we have Montana, which allowed different counties to make the decision on its own. And in Montana, I think 32 or 31 out of the 34 counties have basically gone to voting by mail. So you could see that what has happened in terms of our rhetoric around ballot harvesting and the reality of what's happening, not that there isn't fraud happening, I'm neutral on that point at this point, but what's happening in the states is that we have more and more and more voting by mail. And I'd be curious to know what percentage of the room here votes by mail. By the way, a question, how many people vote by mail now at this point as permanent? All right, so about half the room, and then some people going like this. So that's what I would have expected just by looking at this data. Oh, I've got this thing in the middle, don't pay attention to that. Just another statistics. In 2018, voting by mail nationwide was increasing about 1 or 2% per year nationwide. But the variation was really great among the states. So for example, in West Virginia, Tennessee, and Kentucky, only about 2% of residents were voting by mail. Now, as I said, it's greater than 50%. Here's what I want to get to and where I sort of want to close. How are the states regulating this? What are they doing about this? So this slide will sort of tell you one of the regulations, and I've looked at these across the states. You know, there's a lot of kind of legwork to pull this data. Some of it the National Council of State Legislatures tells you, but some of that data is not exactly correct. And just pulling it is interesting to see how states regulate this, just trying to look at the laws and trying to look at the stories. One is almost all the states that allow absentee voting have a regulation on how a voter actually requests his or her ballot. So in some states, you can go to an internet portal or an online portal and request it. Other states make you can apply by printing a state form and mailing it in. In some other states, you actually have to request it in person. This varies. Another thing that I didn't think about when I started doing this research is who's able to request an absentee ballot. And it turns out the states regulate this in different ways. In some states, only a voter can request an absentee ballot. In other states, a third party that's registered with the state can request an absentee ballot, because there are some civil rights groups that, try to register people to vote. And now if people are voting by mail, you've got to get the ballots to them in some way. In a majority of states that regulate this, only a family member or a spouse or someone within some degree of relation can request an absentee ballot. In other states, they don't regulate this at all. And then there's the question of who can return that ballot, which is yet a different regulation within the states. So in some states, of course, only the voter can return it, in Alabama, for example. In some states, a family member, or they say a household member, can return it. Texas says a family member within the third degree of consanguinity can return it. That's what Texas says, okay? In some states, an attorney or an agent can return it. In Georgia allows somebody who's in jail but still has the right to vote. In other words, I'm not sure how that works, because the person might be a felon, but they allow the jail keeper to return, and that's what the state law says. South Carolina tells you not who can return it, but who can't return the ballot. So a campaign worker or the candidate can't return a ballot. Okay? So sometimes this law says who can, and sometimes it says who can't. In a lot of states, the law says the voter shall cause the ballot to be returned, which is sort of, I guess then you have to be a lawyer to figure out who can return it or not, because the voter could return it or could cause someone else to return it. Just give me a minute. In some states, anybody can return the ballot, but the ballot must be accompanied by an oath, either from the voter himself or from the person who's returning it. In some states, require a copy of an ID or a driver's license number on the ballot, or a social security number. New Jersey, my state, when you register to vote, requires a social security number or a driver's license ID. There's only a signature on the ballot card when you return it. States also have time and quantity restrictions. These are kind of interesting. So many states have regulations that say no more than 10 ballots can be returned, or no more than 6, or no more than 2. My state, New Jersey, until recently, the law said they call this a bearer, somebody who returns the ballot. In New Jersey, you could return up to 10 ballots, and just a few years ago, New Jersey lowered that threshold to 3 ballots. And so you can't return any more than 3 ballots unless it's a family member, in which case you can do 5 ballots. Some states, like California, say that a bearer or returner of ballots can't be compensated for his or her services. So that obviously affects groups that try to collect ballots and return them. States also regulate the time. Oops, I'm not following the slides here. Who can return them? The time restrictions. So they say that a bearer of a ballot or somebody returning the ballot or a ballot collector can't hold the ballot for more than 72 hours or more than 36 hours. So they have a time restriction placed on this. Usually it's about 3 days if the state has anything at all. 31 states allow, or at least by my count, allow someone to return the ballot other than the voter. States also differ in terms of their punishments. In other words, what are the penalties for violating this law? Is it a felony? Is it a misdemeanor? And so forth. Now, there's other areas of this that I'm still researching. In other words, how does the state tell the voter that his or her ballot has been returned? I was speaking to a colleague of mine in election law who had moved from the University of Connecticut to the University of Colorado. He sent me a paper to read. This is Doug Spencer. And we were talking on the phone, and there was a little ding in the background. He had received an email, and it was obviously some Microsoft program. And he said, oh, in the middle of our conversation, my ballot just arrived. So Colorado has a way of dealing with this. Oregon, Washington, Colorado, which have absentee voting, they email or send a card back to every voter so that you know that your ballot arrived safely. Here, the law has to balance both the regulation of the ballot and the ballot collection activities, and on the one hand, making voting easy and accessible. And if you read, and I'll end in a second, the academic literature on this topic, what you find is our colleagues are all over the place. They all say that this balance has to happen, but they're not very specific about how it has to happen. I can read you quotes from colleagues, but I'll just skip that and just say that what we have here is rhetoric and reality that doesn't really match up. What's happening on the ground is that states are learning to deal with this issue, with allowing people to vote by mail and how to regulate it. And it doesn't mean that fraud doesn't occur, but they're learning to deal with it through trial and error. They're inventing ways to make voting and mailing an actual physical ballot secure. There are still many, many things that we don't know about this area that I've tried to research, but the data is just not there. I'll give you two examples and then I'll just end. Number one, how many ballots are returned by a third party of all the absentee ballots that are sent? In other words, some people vote by absentee, and then some percentage of those ballots are returned by a bearer or ballot harvester, whatever you want to call it. What are the numbers there? I haven't seen this data published anywhere. Two, what kinds of voters are using these ballots? The state mails ballots to lots of voters, but who's actually returning them? Is it voters with disabilities? Is it students who are out of state? Are people, who's collecting these ballots from these voters? I haven't seen data on this on the state, but I can tell you that Washington, Colorado, and Oregon that have been doing this for a while now are very sophisticated in this, and we see actually almost no voter fraud in those states, or at least no cases are reported. Anyway, thank you for your time.
Apologies, the microphone is reset, so I'll have to use this number.
Until this resets, oh, here we go. I think it's working. Can everyone hear me? Yep. Great, great. Are there any questions for Professor Mazo or Professor Arpel?
Thank you. Really more of a comment about the impact of these ballot harvesting rules. There's been a raft of new bills proposed since 2020 to try and make it harder to vote. And using the rhetoric of ballot harvesting, there have been restrictions proposed on how many people somebody can transport to the polls, how many ballots one can collect. You alluded to this. And I think that it's easy to lose track of the fact that this has a real impact on people who do not live in accessible places. And the most dramatic example that comes to mind is Indian reservations, where there are people who live in these rural areas in the middle of nowhere. They don't have a mailbox on their corner where they can go and put the mail in. It could be 2 hours for them to drive to a place where they could actually deposit their ballot. And so there's a tradition of elders in the community will go around and they'll collect all the ballots. You know, they get in their pickup truck and they go around and they collect ballots from all over the reservation, and then they bring them into central repository. So, you know, when people talk about ballot harvesting, the very term has this inter rorum scary sound to it. Oh, somebody's going around and doing what's his name, Dallas did in North Carolina. That sort of thing is pretty rare and tends to get caught. I think it was kind of obvious when they found that whole stack of ballots in New Jersey sitting in the mailroom. So I think it's really important when we talk about ballot harvesting to look at the other side of the problem. And in Arizona, this is a big deal that they did impose new restrictions, and it is going to make it dramatically harder for people who live on the Indian reservations to get their vote in, because they could be 2 hours away and not have a car, and it then becomes virtually impossible for them to vote.
Just, that was a good comment, but there is another side to that, and it is going back to the voter confidence issue and having processes that are easily understood, transparent, and verifiable. And when it comes to mail voting and no excuse absentee voting and practices that are different from state to state, it allows conspiracy theorists to connect dots that may or may not be there about what's happening. And I think a good example of that is apparently there's a video out called 2000 Mules, and I haven't seen it. Perhaps you have, but do you have a comment on, on that publication and, whether there's, well, I'd just like to have your thoughts on that and how valid it is.
Yeah, I mean, very unfortunately, this issue has become a partisan issue. And, you know, what states should be doing, at least in my view, is making voting easier, but at the same time realizing, hey, we just had these 2 cases of fraud, so how do we make it safe? You know, if you get an email or a return, you know, something saying that you voted. I didn't talk about the court cases on this, which I have looked at. You know, when states have tried to restrict who can bear a ballot, who can be the bearer of a ballot, let's use a neutral word. Those cases have, there's not that many of them, but they've been, those restrictions have been upheld. I mean, most famously by the Supreme Court in Brnovich versus DNC, where there was an Arizona rule that restricted, that put that restriction in place, and it was upheld. That was a Section 2 challenge that went to the Supreme Court, and it was upheld. But, you know, it was put in place, you know, presumably for partisan reasons in Arizona. I mean, I wasn't on the ground there, but from the reading of the case. I mean, the problem with this, and what I'm trying to explain in my paper, is that the kind of the partisan rhetoric just doesn't reflect what's happening in reality, which is that we're making voting easier and easier for people. And whereas nobody thought of absentee voting, or not many of us did it a long time ago, now it's just part of our lives in very many states. So the question is, how do you make it safe and secure? And even if you have that middle person, how do you ensure that there's never, or there can't be any fraud there, or that the person's prosecuted, or that catching them is very safe? So in New Jersey, for example, I know because I know the election law there very well, and I'm a voter there. There's 2 envelopes. The voter fills out one envelope, and the bearer fills out an outside envelope and signs it. You know, if they're tampering with the voter's ballot, you'd figure it out because the 2 envelopes would be opened in some way. But let's say the person knows how these people are going to vote, picks up their ballots, and doesn't return them. By the way, I was a ballot harvester once in my life. In 2008, I lived in California during the primary election, and I voted for one candidate, and my spouse voted for the other one. And she said, "Could you please return my ballot?" Remember that we had the Hillary Obama primary, and you know, I didn't mean to do it, but I forgot to bring her ballot back. And the next day, you know, it was laying there the day after the election on the little mantle in our house in San Francisco, and I didn't mean to do it, but I was accused of all kinds of things. So as I was writing this paper, you know, I was accused of being a ballot harvester. But you can see that the issue is it's a hard thing to regulate. It's not something we've thought of. You know, somebody not opening and tampering with the vote, but just not returning it when you know there's a lot of people of one party or the other. So maybe we should allow nobody to touch ballots. But then you get into the issue that Ellen mentioned, which is, you know, what about communities that rely on this? You don't want to stop all get out the vote efforts and all people from voting. I think states are, as more and more people are moving to voting, not online, but by absentee ballot, states are trying to learn what best practices are and do this the best way. But I don't think the rhetoric helps at that. It's a short answer.
Any other questions?
Thanks, Kyle. Andrew, I have a question about a different aspect potentially of internet voting and whether you have a different take on it. And I've been intrigued by if it would be possible to move to the signature collection system to do that online. In other words, as before any primary election occurs or a ballot referendum is on the ballot, you know, there's this old-fashioned process of going around door to door and collecting signatures, and it's voluminous and it's complicated and it's a messy process. And I was wondering whether there would be a secure way to you know, create a database that registered voters could go online to sign electronically a petition, whether it's a candidate's petition or party's petition or something like that. And the one thought I had that might make it different from internet voting is it doesn't require the same kind of ballot secrecy, because
exactly. So that's the answer. The difficult thing to make internet voting work, if you could just have a public database where anybody could look up how anybody voted, then you could look up your own vote to make sure it's right. And then you could look up everybody's vote and add it up yourself. And that would sort of get us part of the way towards the possibility of making a secure internet voting system. but we have the secret ballot, and for good reason, as a previous speaker explained. But for signatures, it is a public record who signed it. And so you could imagine the possibility of a secure system that, when a certain voter is registered as signing a petition, they get a notification. By the way, did you know that you're registered as signing this petition? So I can't say right off the top of my head that I have designed a secure system, but I'm saying at least you're right, that the same impossibility result doesn't apply, and maybe it's possible.
Yeah, I really appreciated both of your presentations. I thought they were really interesting. But one of the things I noticed was when you were talking about internet voting, the concern that you had was, after you vote on an app, you have a third party taking the vote and then transporting it. And when it comes to ballot harvesting, you kind of have the same issue, but it's much harder to replicate that across multiple, like for every single voter. So if you have a standard app or just a couple of apps from a federal point, that could be much more concerning than having to organize some sort of structure to, I guess, rig a federal election. You'd need a very organized ballot harvesting system put in place. Do you think, though, when it comes to like congressional districts, where it is possible to just have a couple of people ballot harvesting, like it seems like the issue of ballot harvesting would be much more localized than it would be for like a federal or statewide election? And I'm not sure who should answer that, but that's kind of what was on my mind.
Let's just talk about election fraud in general. Some of the worst election fraud is not in presidential elections and congressional elections, it's in local elections, in city political machines where there's like real local money at stake. And one of the convictions in New Jersey 10 years ago or less had to do with a rent control ordinance in Hoboken, where, people interested in, landlords were, interested in collecting more rent and rent, So let us not forget that a lot of elections are important, not only federal elections, and that we need election systems that guarantee us the right representation at all levels of government. And then finally, there are congressional elections that are close, where 500 ballots really will make a difference. And people often know which elections those are that are close. So I think these are all important issues in many kinds of elections.
In Iowa in 2020, Ned, correct me if I'm wrong, there was a congressional election that was decided by 7 votes?
Yeah, 6 votes, I think.
6 votes, congressional election in Iowa. 6 or 7 votes. I want to just point out something. In normal election fraud, it's if I said I would pay you $5 to go, impersonate everybody in this room and vote for them, you probably wouldn't do it. It would be a lot of effort to just get 20 or 30 more votes, and then you might get caught and there would be a jail time. In the things that Andrew and I are talking about, though, there's something different. There is the opportunity for fraud on a wider scale. Not just one person, doing this, which isn't good, but there's an opportunity to collect and not return 200 ballots, right? Which may sway an election. Or in the computer example, you can sway 20% of the vote this way or that way. It could be 2,000 ballots are going the wrong way. So these two things that we're talking about, I mean, there's a kind of a story in our country that voter fraud just never occurs. I don't think that's true. I think it occurs the Secretary of State told us it occurs in some small, very small numbers. We don't worry about it that much, but here we're talking about some things where we've actually seen it occur, and in numbers that are not gigantic, but enough to sway an election where the difference is 100 votes. And so you want to not only prevent voter fraud, but also the apprehension or the idea that people might think that there's fraud happening. You want to just, you want people to say, like in Scandinavia, nope, our elections are secure, and believe that. And the rhetoric doesn't help this. And we're just saying, here's some things that as scholars we just know exist, and we have to figure out ways to solve these issues so that there's no question in voters' minds. That's at least my perspective on it.
And with that, we're out of time for this panel. Please join me in thanking Professor. And we are coming to the end of the symposium. So our final speaker to close us out is Bradford Cook. Brad is a shareholder with the law firm of Sheehan, Finney, Bass, and Green, and he serves as a member of the Board of Advisors of the Warren B. Rudman Center for Justice, Leadership, and Public Service here at the University of New Hampshire, Franklin Pierce School of Law. He serves as the head of the Sheehan Finney's Government Relations and Not-for-Profit Charitable and Religious Institutions Practice Groups, and he is a past president of the firm where he has served since 1973. Brad represents many colleges and schools and religious organizations throughout New England, including hospitals, nursing homes, and other charitable and non-for-profit clients. He also writes a regular column, Cook on Concord, which appears in the New Hampshire Business Review. He also serves as the co-chair of the New Hampshire Special Committee on Voter Confidence. He is a graduate of the University of New Hampshire, where he served as president of student government, where he graduated Phi Beta Kappa, and he also earned his law degree from Cornell University. So without further ado, introduce Brad.
Wasn't much more ado to do after that, except I'm also chairman of the State Ballot Law Commission, which is really why I think I'm here. On behalf of all of us in New Hampshire who are interested in elections, thank you to Kyle, thank you to the law school, thank you to the law review, thank you to all the presenters. I felt like I was back in political science class. My brain was getting beaten up. And when I was in political science major at the University of New Hampshire, it wasn't about computers and it wasn't about math. And that's why I got through it. This has been a wonderful day. I was asked to sum up. I couldn't possibly sum up all the things that we've heard today, but they were very interesting. I'm co-chairman of a voter confidence committee for the state of New Hampshire, and we've just been serving for 6 months or so to try to go around the state and gather opinions and figure out what's going on. The reason all this stuff is important is because people care about their democracy. Elections are complicated. Elections are covered by a lot of laws, a lot of different systems, state by state. Thank God that it's not one system imposed on us from Washington. We think we have it done pretty well here in New Hampshire, but it's because we care about our democracy. And the other reason, very frankly, that we're talking about this so much these days is because the first time in our history, we've had a former president of the United States refuse to accept the fact that he was not reelected. In 1960, Richard Nixon, when he might have had reason to contest it, conceded to John F. Kennedy. In 2000, after a Supreme Court decision, Al Gore conceded to George W. Bush. In 2020, after he lost fair and square, Donald Trump lied about it. That's why we're here, folks, and that's the problem. New Hampshire's very lucky. As Dave Scanlan said at the beginning today, we have a deep, centralized, citizen-run election system that's run by our neighbors and friends. We go to the polls. We cast our ballots on election day. We don't have any kind of fancy, everybody gets a ballot in the mail. We have a constitutional provision that says how people can cast absentee ballots. So all these conversations about universal absentee ballots require a constitutional amendment in New Hampshire. We like it the way we have it. And it's the eternal issue of balance, which we just heard about. the balance between security and ease of voting. And I like to say to people when I talk about this, you know, we could go to Hannaford's or to Shaw's or to Market Basket Supermarket, and there could be a pile of ballots there, and we could pick one up, fill it out, and give it to some teenager making the minimum wage, and show them our driver's license and have them put it in a box. And that would be really easy, and we'd never do it that way. Or we could make it as hard as it is to get a secure ID when you go to get your license renewed, and it's almost impossible. I asked somebody at Motor Vehicles how many people did it right. They said 1 out of 10. I did it right. I felt like 7 years of college and 3 years of law school was probably a pretty good thing. But we can't make it that hard because that would be wrong too. So it's that balance, and we keep striving for that balance. And the legislature, Representative Griffin's committee, every session had to figure out what elements we had to add to it. And we keep adjusting it to get it right, and every other state tries to do that too. It can be too easy, it can be too hard. We get, with our system of going to the polls and casting a ballot, we're always in the top turnout. Now, finally, just to screw up your minds before we go to the cocktail party, and I recognize I'm what's standing between you and a glass of wine, I'm going to leave you with the thought that a political science philosophy teacher taught us in the first political theory class I ever had. And it's this: when we talk about wanting everybody to vote and universal turnout, is it better to only have those people who have studied the issues, educated themselves on the issues, familiarized themselves with the candidates, and are prepared vote? Or is it better to have everybody, whether they're influenced by the internet, by know-nothing candidates, by the labor union, whatever they're influenced by, vote in record numbers? Which is better for democracy? Thank you.
And thank you all for being here today, and for everyone in person and online. Many of the presentations that were given here today will be featured in our Symposium issue available in 2023, and the recording of today's session will be available online sometime next week. So we all have the ability to relive everything that we just heard today. And with that, thank you all for coming. There are refreshments downstairs in the lower atrium, and I look forward to continuing the conversation, and safe travels. Thank you again.
Thank you, Kyle.